Here we go.
Thank you.
You're welcome.
Good morning, everyone. Today is Wednesday, May 12th. This is a meeting of the Criminal Justice Public Safety Committee. And today's work is a little different. We're going to begin with 4 bills that are work session, followed by a number of public hearings. What you see posted is the order we will be conducting the work session. That would be LD 438, followed by LD 1127, and then LD 1171 and LD 1408. Excuse me. I am Senator DeChambeau, and I represent District 32, which is Dayton, Lyman, Alfred, Arundel, Kennebunk-Port, and Biddeford. I've said this, 100 times? You guys should come down, especially this summer. So the purpose of this meeting, as I said, is a work session, and this is for the committee to receive information from staff and others in order for members to consider these legislative proposals and make recommendations and report to the legislature. Only committee members, the committee analysts, and those specifically invited to attend will be participating in the work session via Zoom. Members of the public wishing to observe this meeting, it is being live streamed on YouTube channel and will be recorded for viewing after this meeting is concluded. I will now ask, I will say though, however, that materials will be provided, and when it's we're able to do it, we will do it by screen share or post it somehow. When it comes time for the committee to vote, and we must have a quorum present, at least 7 members, including a senator. In order to be counted as present, your identity must be visually verifiable on the Zoom screen. So I will ask the members to introduce themselves, and I will first introduce Representative Warren, co-chair of the committee.
Good morning, everyone. Thank you, Senator DeChambeau. My name is Charlotte Warren, and I represent the city of Hallowell and the towns of West Gardner and Manchester.
Thank you. Representative Pickett.
Morning, Madam Chair. My name is Dick Pickett. I represent House District 116, the towns of Canton, Dixfield, Hartford, Mexico, and Peru. The fishing is great in the Western Mountains. Come on up and throw your line in.
Thank you. Senator Searway.
Good morning. I'm Senator Scott Searway, and I represent District 16, which covers Waterville, Winslow, Fairfield, Benton, Albion, Clinton, and Unity Township.
Thanks. Representative Morales.
Good morning, everyone. My name is Victoria Morales, and I represent House District 33 in South Portland.
And where is he? There he is, Representative Pluker.
Thank you, Madam Chair. My name is Bill Pluker. I represent House District 95, which is Warren, Hope, Appleton, and part of Union.
Thank you. And Representative Wernicke.
Good morning, Madam Chair. I'm Shelley Rudnicki. I represent House District 108, and I am live here from the Capitol, but I am still here under protest. Thank you.
And Representative Lookner.
Morning, I'm Grayson Lookner. I represent part of the district of in Portland. It's 37 around the Fore River. We have great striper fishing, so I'd also extend that invitation. When the tide is coming in, we get good striper on the Fore River.
That's what I fish at Higgins Beach. Okay, so we're getting to know more of each other here. Representative Newman.
Morning, I'm Dan Newman, District 76, which is Belgrade, Rome, Mount Vernon, Fayette, Vienna, and Wayne.
Thank you. Representative Reckitt.
Morning, my name is Lois Reckitt, and I represent the ocean end of South Portland, even though
My background this morning looks like prehistoric lily of the valleys. I have no idea where this photo came from. So don't blame me, but at least it's a change. So, thank you.
Thank you. I don't see Representative Costain. Will he be joining us later, Representative Pickett?
No, he had to take a trip out of town on business. He will be back with us on Friday.
Great, thank you. I just want to add one more thing about work sessions. I will open up the meeting. We will have discussion. There will be a motion, a second, and more discussion, and then a vote on these 4 bills. So this morning, we begin with LD 438, an act to increase public safety by adding a position to the Computer Crimes Unit of the Maine State Police. Do we have Senator Diamond with us? Hey, there's the name. Welcome.
Thank you very much.
Would you like to share with us your position on this bill right now?
Yes, actually, I have, knowing how busy you are, I have 2 good newses for you today. First, I would like to ask for an ought not to pass on 1408, and I would like to ask for an ought to pass on 438. Ought not to pass on both of them. 1408, there was a mix-up. It was totally my fault. I was asked to co-sponsor it, and that's where it stayed in my mind. So I didn't show up for the hearing. So I apologize to the committee for that. But I double checked on everything, and I'm confident that that issue is already covered in the current statute. So I really don't think you need to waste any time on that. And I apologize again for not being here. It was my mistake, in spite the good work of my assistant. And the other one, 438, where I'm making some progress on this. So the progress I'm making, we really don't need this bill anymore. But I do want to thank the committee for your sincere and genuine interest in the what I consider to be a very serious problem. And hopefully we'll be able to get some results of that before the session is over. But I won't need this legislation, although it did serve its purpose, and I thank you all for that.
Thank you. So ought not to pass on both 438 and 1408 is your recommendation?
That's correct.
Okay. Well, we'll make it official and have someone make a motion. I would like to say, as a former member, I know you're supposed to bring a treat, but this is probably the best treat we've received. So thank you.
I totally appreciate that.
I will recognize first Representative Pickett, followed by Representative Warren.
Thank you very much, Madam Chair, and thank you, Senator Diamond, for bringing the bills forward in the first place. I'd like to make a motion ought not to pass on 438.
I'll second that.
Representative Warren?
Thank you, Madam Chair. My question is specific for the senator regarding 1408. Do you want me to wait on 1408?
No, it can be ought not to pass now. Again, I checked with some other people on this. It was, like I said, as I indicated, it was, I thought I was a co-sponsor, so I didn't pay a lot of attention. But then when I started paying attention, I figured out what the story was, and I'm confident that it's already covered.
Thank you, Senator. My question specifically is, at the public hearing the other day, the Maine Coalition to End Domestic Violence came forward with an amendment on 1408 around providing additional training for guardian ad litems. They really made a great case to us that that is something that's needed to help children that are involved in domestic violence situations. And my question for you is, are you aware of that amendment, and are you in support of us using your vehicle for that amendment?
I would be totally pleased to have you use the vehicle for that, if the committee
Great.
felt that was the way to go. So absolutely.
Wonderful. Thank you very much, Senator. I appreciate that. And I am happy to go along with the ought not to pass on 438 as well, Senator, if, when you're ready to run that vote.
Yeah. No other questions? Okay. We will have a roll call, please.
Video on, and please unmute for a roll call vote. We're voting on LD 438. The motion is ought not to pass. Representative Warren,
Yes.
Representative Morales,
Yes.
Representative Sharp is absent. Representative Lookner,
Yes.
Representative Pickett,
Yes.
Representative Costain is absent. Representative Rudnicki,
Yes.
Representative Newman,
Yes.
Representative Pluker,
Yes.
Representative Reckett,
Yes.
Senator Lawrence is absent. Senator Searway,
Yes.
Senator DeChambeau.
Yes.
That's unanimous, 10 votes yes, and 3 absent.
Thank you. Sounds good. Now we're up to the second one that Representative Warren spoke of. Okay, 1408, an act to increase the protection of children from domestic abuse and violence. Representative Warren.
Thank you, Madam Chair. I'd make a motion ought to pass as amended.
I'll second that.
It's been moved and seconded. I am going to ask if someone can just give me an idea. I don't have it in front of me. I really believe in the people that work in domestic violence causes. What could you, Representative Warren, just brief me on that for a minute?
I'm sure we could look at the amendment maybe with a screen share. It was attached. Do you have it easily, Jane or Deb?
Yeah, I think Deb has it.
Yes.
Okay. And it would replace the entire bill.
So I'm trying to just get the document.
Is this from the main coalition? It said?
Yes.
Yes.
Okay.
It was presented on the 28th by Andrea Mancuso. Yeah, that's the one. I have it in my hand too.
Yeah, I get the training in there. Is there a page 2?
No.
No, that's it. Okay. Very good. Is Senator, did Senator Diamond leave?
Oh, right here.
Can you see that, Senator Diamond?
I
Can
can.
maybe she can put it wider?
Oh, I've got it. This is
Okay.
really, I've not seen the wording before. What a great start. Right off quick, my first reaction, this is a really well needed and very appropriate amendment.
That sounds great. Thank you. All right, that answers my question. So I don't see anyone else has a hand up. We will have a roll call.
Video cameras on, please, and unmute for roll call vote. We're voting on LD 1408. The motion is ought to pass as amended. Representative Warren,
Yes.
Representative Morales,
Yes.
Representative Sharp is absent. Representative Lookner,
Yes.
Representative Pickett,
Yes.
Representative Costain is absent. Representative Rudnicki,
Yes.
Representative Newman,
Yes.
Representative Pluker,
Yes.
Representative Reckett,
Yes.
Senator Lawrence is absent. Senator Searway, Can you please unmute, Senator?
Yes.
Thank you. Senator DeChambeau.
Yes.
That's unanimous, 10 yes and 3 absent.
Could someone tell me who seconded that?
Representative Pickett?
Okay, thank you. Very good. And
Senator
thank you,
Diamond,
Senator
thank you.
Diamond. You always bring good stuff.
Well, but thank you for your attention to this, especially 438, that, and a great outcome to 1408. Thank you very, very much for being so good. Thanks.
Thank you.
Thank you,
for all
Senator.
your work, Senator.
We now have 1127. 1127 is Representative Rader, isn't it? Rader. An act to prohibit the use of no-knock warrants. She has joined us. No, is she with us?
Not yet.
She's in another work session on her bill.
She's on taxation right now.
Okay, thank you.
So we'll skip that, shall we? Because there is an amendment, is there not? Or maybe it's the next
Yeah,
one.
the amendment, I believe, is a combination of the two bills. So maybe
Yep.
we could start with Representative Fectow
Yep,
and Major Scott.
yep. So we'll move to 1171, an act to curtail no-knock warrants, and that was presented by Representative Justin Fecteau. I'm used to Ryan Fecteau since he is in my hometown, so. You have something to present to us, Representative Fecteau?
Yes, Madam Chair, and thanks to the committee for having me this morning. Major Scott, we can't say enough nice things about him. We really facilitated a wonderful conversation, bringing in all the stakeholders. And we had a really great conversation between me, Rep. Rader, Major Scott, Maine Chiefs, Maine Sheriffs, and it's, I believe the Maine Sheriffs are still on hold on how they feel about this bill, based on my last email that I received from them. But there is an amendment to 1171, which has been agreed upon by at least me, Rep. Rader, Major Scott, and then it's okay with the Maine Chiefs. I'm sure Major Scott can go over the fine points much better than I can. But it was just really great to be a part of a nice, honest, and open discussion surrounding this.
Thank you. Major Scott, do you wish to add to that?
Madam Chair.
Representative Warren?
Thank you. I'm sorry for interrupting, but just before the major gets started, I see we do have Sheriff Carroll with us. Maybe we could bring him in as well.
Certainly.
Thank you.
Well, thank you, and good morning, Senator DeChambeau and Representative Warren and members of the Joint Standing Committee on Criminal Justice and Public Safety. My name is Major Brian Scott, and I'm very happy to report that Representative Fecteau, Representative Rader, myself, Maine Sheriffs, Maine Chiefs had a very productive conversation. We took the tasking from the committee from the public hearing and got together and had a conversation about what might work for everyone, and address some of the concerns that we heard raised by committee members, as well as take a look at 1127 and 1171. And as you know, we started 1171 with about 4 sentences, very small section, non-prescriptive, Representative Fectow's and Representative Rader's. That was about 4 pages, very prescriptive requirements around no-knock warrants. The 2 representatives themselves certainly engaged in some give and take during the conversation. I don't think either one of them got 100% of what they were looking for, but they compromised. There were some things that were very important to both of the sponsors of the bill. And those were things that we discussed as a law enforcement community as well. The state police and Maine chiefs are in agreement that the amendment that was provided to Mrs. Oberden, and she since has prepared another one. I believe she's probably disseminated it, that I've had a chance to take a look at. And what she did is just made it legally correct, unlike myself trying to add some information to a bill. So I believe it looked what Ms. Oberden had provided. I believe she provided looked great. 100% in agreement with that. Sheriff Carroll, I see, is on the call, so I can let him speak for Maine sheriffs, but I know they had a voice and have had some response from a portion of their membership that were okay with this language as well. Happy to go over the details of what's included in it, but I can pause there for the committee's direction and see if they wanted to hear from Sheriff Carroll on the Sheriff's Association portion.
Yes, thank you. Welcome, Sheriff Carroll, again.
Good morning, everybody, and thank you very much. It's not 100% only because I didn't hear from all 16 sheriffs, but the majority of them did respond back to the question, and we are in support of the newest language. And again, I want to recognize Major Scott with an outstanding job, but I think that regarding this bill, it seemed to me it's exactly what it's supposed to be. We had both of the bills, both of the representatives in a conversation with those affected, Maine chiefs, Maine State Police, and the Maine sheriffs. And I think the outcome is outstanding with all being involved, give and take on both sides and just working it through. So I am speaking on behalf of Maine sheriffs. A majority were in a agreement with this, and it's only because I didn't hear 100% from all of them. I didn't hear any opposition to this newest language. So thank you very much all for the great work, and especially Major Scott.
Thank you. Representative Pickett.
Yes, Madam Chair, thank you very much. I have something, if I may, I'll ask the committee's indulgence. I have something I'd like to share with you about these type of warrants, or a warrant being executed on Monday of this week. It's a very short article. I'd just like to read it if I could. Probably take about 2 minutes to read, but if I could have the indulgence of the committee to do that, I think it will give us a better perspective of what officers actually go through when they go to execute a warrant. Would that be okay to do that?
Yes. Yep, since it's relatively new.
Thank you. Just pulling it up now. It'll only take a second. Monday, May 10th, 2021. Detective Luca Benedetti was shot and killed as he and other detectives executed a search warrant as part of an investigation of a series of burglaries. The detectives approached the apartment, identified themselves, and asked if they could enter. They waited an extended period of time with no response before making entry into the apartment. The suspect was laying in wait inside and opened fire as the detectives entered the apartment. Detective Benedetti and another detective were both struck. The subject was also wounded by return fire, and later the suspect committed suicide. Detective Benedetti was transported to a local hospital where he succumbed to his wounds. Detective Benedetti had served with the San Luis Obispo Police Department for 12 years. He is survived by his wife and 2 children. He was age 37. And the reason why I wanted to share that is because that is what an officer goes to work every day and never knows what's going to happen by the end of the day. This officer went and he executed a warrant, did everything by the book, everything that we've been talking about in this committee about warrants, identifying yourself, making sure the people inside know so there won't be any danger to them or yourself or anything. And they did it by the book. And the result was an officer ended up dying that day, leaving 2 children and a wife behind at age 37. So I think that just really brings into perspective how important this bill really is. And I'm so proud of those that have worked on it. Major Scott, Maine Chiefs, MSA, Representative Fecto, Representative Rader, and working together to come up with something. And I really hope we can pass this out of committee unanimously. Thank you. Thank you for your indulgence.
Thank you. Representative Wernicke.
Thank you, Madam Chair. I'd like to move 1171 ought to pass as amended.
Thank you. Any, the second, please?
I'll second that.
It's been moved by Representative Wernicke, seconded by Representative Pickett. Ought to pass, yeah. Oh, I see Representative Morales.
Deb, could you please
Yes.
bring in Representative Rader?
Oh,
She's
good.
here.
Yes.
Thank you, Madam Chair. I was going to ask to hear what the agreed upon bill looked like and was hoping to hear from the sponsors. Thank you.
Right now, we're dealing with 1171. I don't know, were you here when Representative Fecto spoke?
Madam Chair, the determination will be made that these two bills are becoming one bill. That's what the amendment is about. So we're talking actually about two bills right now.
Well, I want to make sure that that's what I understand and what Representative Wernicke was making the motion on both bills. I failed to hear that one. I knew what the intent was, but I will defer to Representative Wernicke what her motion. Was it to this bill?
Yes, Madam Chair, it's 1171 ought to pass as amended. This is what they brought forward.
Okay, let me, Representative Warren is correct. If I may clarify something. These two bills, both Representative Rader's and Representative Fecto dealt with no-knock warrants. All three have met. If I may, I'm going to put your motion aside and ask if Representative Rader supports this, then it is a replacement for both bills, an amendment. Is that all right with you, Representative Wernicke?
What are you asking to put it aside? We have a bill number and that's, I mean, if they've worked together using this vehicle.
Yeah, okay, what I'm gonna do way aside, it's still there. I am asking Representative Wernicke to speak on her bill because after that, we'll have a decision to make. So it may be out of order right now. Let's ask, since she was involved and wasn't here. So I'm now gonna recognize Representative Rader.
Thank you so much. Because my bill was full of amendments and Representative Ficto's was relatively simple and straightforward, we took my amendments and added them to his bill. So yes, 1171 is the foundational document on which we built, and I am okay with that. Lastly, if I may just take a moment to thank the committee, to thank Representative Fecto, to thank Major Scott and all of the law enforcement that participated in this. If nothing else in the world will restore your faith in democracy, this process will. It was incredible. So thank you.
Thank you. So it sounds, and I'm speaking for myself here, Representative Rader, when we get to your bill, it'll be ought not to pass because you deferred to this one.
That is correct.
Is that correct? All right. So we are back to the original motion, having that clarification. And yes, I am going to recognize before we vote Representative Reckitt.
Thank you so much. I just wanted to point out that the amendment has been sent to us this morning at 10:15 by Jane Orbiton. So if you have a way to look at something while you're online, I just printed out from my iPhone the text of the amendment. So if you want to look at it and hold it in your hand, that's the way to get it. So thanks to Jane for getting that out so quickly. this morning. That's all. I just wanted to make sure people knew there was access if they wanted it.
Do people, I'll back off if people need to take a few moments to look at it before we vote. I want to make sure. For the newer representatives who have put in a bill that usually electrifies discussion, and to work with the Department of Public Safety major and to come to some resolve, I think all of us find that to be commendable, all of you who are willing to give and take. Representative Pluker, followed by Representative Morales.
Thank you, Madam Chair. I'm not sure who would be best to answer this question, but looking at the amendment, it in section 4 refers to exigent circumstances, and it puts quotation marks around exigent circumstances. I was wondering if there's a definition of exigent circumstances, or if there's a common understanding of exigent circumstances as would apply to no-knock warrants. Maybe Major Scott. Yep.
Major Scott.
Yes, thank you, Senator DeChambeau, and Representative Pluker happy to answer the question. So the exigent circumstances really does not apply to warrants themselves. It's actually a recognized exception to the warrant requirement that's been created by doctrine through the Supreme Court. One of the conversations that came up while we were having this conversation, certainly within the law enforcement community, is this is about a structure and parameter and reasonable restrictions around no-knock warrants. But we didn't want any reader in the future, law enforcement or otherwise, to read this amendment or what will become an LD in public law, we believe or we hope, is that this would circumvent or somehow overrule constitutional law, case law, and things that have been clearly established. So part of the conversation on creating a definition of a no-knock warrant, it was really important to Representative Rader that we had some time frame in there. That's where the 20 seconds came from, of differentiating between what is a no-knock warrant compared to a knock and announce warrant. So that 20-second that became important. I think you saw in the first bill, 1127 was 30 seconds, and that was a negotiation of realizing that we do need a definition to determine the difference between the two warrants. 30 seconds is an awful long time for law enforcement officers from our perspective. We came with 20 as a mutual agreement that was a reasonable differentiation between a no-knock warrant and a no-knock warrant. But we also, in the law enforcement community, understood that there's an exception to the warrant requirement called exigent circumstances. And that might be something where even if you're not, maybe we haven't applied for a no-knock warrant, we could simply have a warrant. We go to a residence, maybe knock and announce, but something comes to our attention that creates an emergency. It might be something like the rack of a shotgun, or we might hear somebody acknowledge, oh, crap, the police are here, grab your gun, or something that would necessitate an immediate entry. Then there technically is not a requirement to a warrant to begin with, but we didn't want this restriction here to overrule or have a reader believe that it overruled the exigent circumstance, which is, again, is an exception to the warrant requirement. And it's usually more for those things that I discussed during the public hearing, where we might respond to a complaint like a 911 call of a domestic or what sounds to be a domestic in progress. We go to the residence, knock on the door, we hear fighting, people yelling, someone yelling for help, maybe furniture being thrown around or objects being broken. We don't have to stop and go get a warrant. What we would do is make entry into the home under exigent circumstances. So that was the reason to add that. It was at our request, and the sponsors indulged us with that, understanding that there might be an emergency that presents itself that we're going to have to act upon. And we didn't want this to be, again, a barrier, a potential barrier to being able to use other tools that are available.
So just to clarify in my own head, exigent circumstances means no warrant is necessary. And you just want to make it clear that you can still go in. And then a question I think may be best for Ms. Orbiton, is there any definition of exigent circumstances in Maine statute? Or is it purely under case law?
I don't know.
Okay.
We
Thank you,
do
Madam
have this amendment is available for screen share, if that would help you.
I'm reading it now.
Okay.
It has has exigent circumstances in quotations, which in my mind means it's an idea, it's an established idea. And I was wondering if it was an established idea somewhere, and it sounds like it's established in case law, but maybe not in statute. Thank you.
Thank you.
Representative Morales?
Thank you, Madam Chair. Just to follow on the thread of Representative Pluker, there is no definition of exigent circumstances in the Maine criminal statutes, but I did look up case law, Maine Supreme Judicial Court case law, and it reads that, and I'll give you the citation of the case, but although case specific, exigent circumstances such as, quote, the need to pursue a fleeing suspect, protect individuals who are threatened with imminent harm, or prevent the imminent destruction of evidence can supply an exception to the warrant requirement. And that is from, I'll give you the case citation here. Oh, let me get all the way to the top of this. It's from State of Maine v. O'Donnell. It's a 2018 case.
Is that it? Thank you.
Yes.
Okay, thank you for that. Jane Overton?
Oh, sorry. I was just going to say that if you want a copy, we can get it for you.
A copy of State of Maine versus O'Donnell?
No, of the draft amendment.
Oh, the draft amendment, okay. Fine. I will go back. We do have a motion. Motion by Representative Vernecki, seconded by Representative Pickett. Ought to pass. As amended, excuse me. Am I correct, Representative Vernecki? Thank you. So I've listened to some people here and we're ready for a roll call, Ms. Fahey.
Video's on and please unmute for a roll call vote. We're voting on LD 1171. The motion is ought to pass as amended. Representative Warren,
Yes.
Representative Morales,
Yes.
Representative Sharp is absent. Representative Lookner,
Come back to me.
Representative Pickett,
Yes.
Representative Costain is absent. Representative Rudnicki,
Yes.
Representative Newman,
Yes.
Representative Pluker,
Yes.
Representative Reckett,
Yes.
Senator Lawrence is absent. Senator Searway,
Yes.
Senator DeChambeau,
Yes.
Representative Lookner.
Yes.
That's 10 yes votes and 3 absent.
That's great. Thank you. Well, I was going to say it's not a divided report. I won't get up in the Senate, but Representative Rader, I sure as heck will add your name to that list. So for all the work you've done on this too. I think Representative Fecto recognizes that also. Representative, I have a couple of people, and first Representative Pickett, followed by Representative Fecto.
Yes, thank you, Madam Chair. I just wanted to personally thank both representatives, Representative Fecto and Representative Rader, for being willing to work together. And this really was a very good outcome. Couldn't ask for better. And I just thank you for your willing to work. And thank you for those Major Scott, and Sheriff Carroll, and also anybody else out there that has had a part in this. It's a really good outcome, and I thank you much.
Thank you. Representative Fecto.
Thank you, Madam Chair, and thank you to the committee. Especially thank you to all of the stakeholders, especially Representative Rader. We proved today and last week that bipartisanship and collaboration isn't dead. And all we have to do is emulate the good policymaking that we want to see, and it's contagious. So thank you very much.
Very good. Representative Rader.
I won't take up much more of your time. I just wanted to say from the bottom of my heart, thank you for all of your consideration. Thank you for giving us a shot at reworking this, because as Representative Fecto said, bipartisanship is not dead. And I'm getting a little emotional because this is my first unanimous report, so thank you. But also my deepest thanks to Representative Fecto, to Major Scott, to all the stakeholders who worked on this, and to the committee for hearing this. I appreciate all of your time. I appreciate your vote. I appreciate you recognizing that this work was really important and really a really positive step forward, I think. Thank you.
Representative Rader, us who have been here for a while know what it feels like to have a unanimous report and also one that we collaborate with. And the comment about bipartisanship, I wish the TV stations would pick up on that. State of Maine knows how to do it. So thank you very much.
I also want to congratulate you guys all and thank you for your good work, but I don't want to let this moment go by without commending the people in this committee, because we almost always get unanimous reports. And I'll say that again. It's not like other committees in this committee. We spend a lot of time and we work really hard, and we do come together on most of our bills. And I think that's probably surprising to most people. So when you look at the members of this committee, know that they work really hard to do the same thing. So I just wanted to give them some props as well. So thank you for your work.
Very good. All set. Thanks.
I'll make a motion.
Yeah, a motion.
We have one more bill still in front of us. I'll make ought not to pass on 11/27.
I'll second that.
Thank you. It's been moved and seconded. I believe we've discussed this, and so seeing no hands, I will call for a roll call vote.
Video on, and please unmute for a roll call vote. We're voting on LD 1127. The motion is ought not to pass. Representative Warren.
Yes.
Representative Morales.
Yes.
Representative Sharp is absent. Representative Lookner.
Yes.
Representative Pickett.
Yes.
Representative Costain is absent. Representative Rudnicki.
Yes.
Representative Newman.
Yes.
Representative Pluker.
Yes.
Representative Reckett.
Yes.
Senator Lawrence is absent. Senator Searway.
Yes.
Senator DeChambeau.
Yes.
That's unanimous, yes, and 3 absent.
Thank you. I may have missed something. Does that conclude our work session? I forgot to cross them out. It does?
Yes.
Thank you.
Madam Chair, did you want me to announce the order for the public hearings, or would you like to do that?
If you have it in front of you, I do, but go right ahead.
So for folks who are here, we're going to go now to public hearings, and we're going to start with LD 1422, followed by 1486, then 1592, then 1605, and then LD 1607. Next, we'll do LD 847, then LD 1298, then LD 1585, and finally LD 1473.
Thank you. My apologies to both very good people here. Jane Overton is our policy analyst. She joins us. I did not introduce her. Or our committee clerk, Deborah Fahey. She's in the box with the LD that we will be reviewing next. So my apologies to you guys. LD 1422 is he with us, Representative Stewart? If he isn't, I was going to ask if we can put it aside until we can notify him.
I don't see him.
Excuse me?
I don't see him in the waiting room.
Senator Stewart.
Excuse me?
I said so much for the order. The reason
No, that's my fault. When we decided on the order, I failed to notify him or his staff. Senator Stairway, could you locate him or his?
Yep. Yeah, I will try to do that right now.
Thank you very much.
Nate, are you watching? Because we're going to be up a whole lot quicker than I thought.
Deb, could you?
Okay, we're up third, and the first one may even
Deb,
get.
would you? Yes, thank you.
Deb, would you do me a favor and make me a host as well so that I can mute people at will?
Yes.
Only when they're taking phone calls and they don't want to share their
Gladly.
entire life story with everyone.
Don't go crazy on that one. So
I will not mute anybody unless you're on a phone call or yelling at your kids.
So let's go next. I don't know where Senator Trey Stewart is. 1486.
Trey said he'd be right over.
Oh, right over? All right. That's not his fault. Fine.
We'll give him a minute. We got all day.
You know what? The next session in January, we should rotate who's chair so you guys can play with all these different piles over here. You're all in the same boat, but keeping it going and changing it at the last minute. Yeah. I think I'm harder on myself when I fail to do something, so.
I'm sure he'll be right here.
So I'll begin.
He's here.
I'm sure. Great. Welcome, Senator Trey Stewart. I should have called you earlier and I failed to do that. So we are up to your bill, 1422. All right. So we'll begin. I will, 11 o'clock. So my clock's going to ring 11 times. This is an act to strengthen laws protecting members of law enforcement and promote in-classroom drug use avoidance education. And we have, this is a public hearing. I failed to to advise the public of this. So this is a public hearing and I will turn it over to Senator Stewart to present.
Thank you very much, Madam Chair. Appreciate the introduction. Senator DeChambeau, Representative Warren, and members of the Criminal Justice and Public Safety Committee. I'm Senator Trey Stewart, and I have the honor of representing 51 communities in Aroostook and Penobscot counties. I'm here before you today to present LD 1422, an act to strengthen laws protecting members of law enforcement and promote in-classroom drug use avoidance education. Over the last 14 months, the Maine Centers for Disease Control, CDC, Governor Mills' office and news outlets across the state have actively reported the number of COVID-19 cases and related deaths. Meanwhile, they have been virtually silent in respect to overdose deaths, where in Maine, we had a record-breaking 502 deaths in 2020, up from 380 in 2019. The governor created an opioid response position within her office and issued Executive Order 2 on February 6, 2019, with actions, quote, intended to reduce overdose deaths, expand treatment and recovery efforts, and begin to focus on prevention, end quote, as stated on her website. Unfortunately, based on the increased number of overdose-related deaths, it seems that these actions have taken a backseat to the COVID-19 pandemic, which, please don't be mistaken, I feel is also a very serious matter. With the steep increase in overdose deaths, dramatically impacting families across the state of Maine, I think it is important that we make every effort that we can to educate our youth on the harms associated with drug use. For that reason, I'm bringing forward this legislation, which includes an annual appropriation of $1 million from for the Department of Education for the funding of programs that educate Maine youth against drug use. As a member of the statewide opioid task force that was formed in 2017, we prioritize education as a major component of the prevention leg of the three-legged stool approach that we use to strategize our response to the crisis. Making a significant investment in this effort with the state's financial support and putting our money where our mouth is will finally make good on this priority. Additionally, we have seen a major decrease over the last several years in the number of people applying to join the law enforcement ranks. According to a 2019 survey conducted by the Police Executive Research Forum, 63% of police departments said that they have seen fewer applicants than just 5 years prior. The reality is fewer people want to go into a profession where they might not make it home to their loved ones at the end of the shift, and they are constantly under fire for the actions of their colleagues in other parts of the country who represent a stark minority in the profession. While there are most regrettably a few terrible people who have mistreated their rank and given the profession a black eye, I think it is important that we, as leaders in our state, continue to support the honorable men and women in law enforcement who join the ranks to serve and protect those in their community. In addition to funding these programs, educating against drug use, the legislation also extends the application of a hate crime sentencing laws to a defendant who selects the person against whom a crime is committed based on that individual's employment as law enforcement, or who selects property to damage owned by a member of law enforcement specifically because they are a member of law enforcement. Law enforcement was another prong of the opioid task force's work in 2017. This initiative will help ensure that we have necessary support within the profession, that they can focus on keeping our community safe and drug-free, rather than ensuring that they have enough manpower to barely cover every shift. It's critical to mention the third prong of the recommendations of the opioid task force as well, which is treatment for individuals suffering from addiction. While not within the jurisdiction of this committee, be assured that there are efforts underway in other committees of the legislature to ensure that individuals struggling with addiction in Maine have resources they need to win their battle and survive so that they can live out their lives as survivors rather than statistics of the crisis. I appreciate the committee's support of this important legislation and that will help to address two critical components of the opioid crisis our state is facing and aid in the protection of Maine people. Happy to answer any questions that the committee has at this time.
Thank you, Senator Stewart. Any questions of Senator Stewart? Representative Lookner?
Thank you, Madam Chair, and thank you, Senator Stewart, for bringing this bill to this committee. So this bill is saying that law enforcement is a protected status, similarly to somebody's racial status or their sexuality. It's saying that a hate crime could be directed towards somebody based on their employment instead of, one of their inherent identities. Is that correct?
So thank you for the question, Representative. So one of the components of the bill is a protection that would exist for law enforcement beyond the scope of if I was to, for instance, assault someone in the street just because that would just be an assault and battery charge. It would be likely criminal charges associated with that. But beyond that if I was to explicitly target someone because of, as it reads right now, hate crimes are reserved to protected classes in Maine statute. As you mentioned, things like race, gender, that sort of thing. But if what I'm proposing is that if someone is targeted specifically because of the uniform that they have on, and their job is to protect our communities, and they are then assaulted because of that job and that uniform, that that should be included in those provisions and have extenuating penalties associated with that act.
That's clear. Thank you.
Okay. Representative Warren.
Thank you, Madam Chair. Thank you, Senator Stewart. It's good to see you. How many attacks on law enforcement in Maine happened in the past year?
That's a great question, Representative. If somebody can't answer that question for you after me, I don't have that data available. I'm happy to provide that for you in the work session, though. I do know that, unfortunately, for instance, I am familiar with at least one death in Corporal Cole, who was killed in the line of duty as well. There are attacks that do happen. I'm not sure exactly how many, though, but I will work to get you that information.
Okay, great. Thank you.
Senator Stairway.
Thank you, Madam Chair. I was thinking about the statistics on attacks, but I know it happens quite often. It's happening in the field. It could have happened to me just a few days ago. I had one situation that I avoided, but the guy was high on something, and it was a very, very dangerous situation. So it does happen. So I don't know what the statistics are. Maybe Major Scott might have some information on that. I don't know. Maybe for the work session, we can try to get some statistics.
I don't see any other hands. I will say, though, that I am now looking at Clack's memo on this bill. And it refreshed my memory, paragraph 2. We do have law enforcement officers already have special protection under the criminal code in that a simple assault committed upon a law enforcement officer is a Class C offense, punishable 5 years. My statement is only an anecdote. I have seen many of those. That in itself does not put someone in a state prison, but in the commission of the crime or during the arrests, an assault or even a simple assault is levied on the law enforcement officer, especially in arrests. So I've seen that, but not by itself in the prisons. So if we would take a look at Clack also, but we'll probably have testimony from Clack on this. Anyone else? If not, I will ask if there are any legislators or co-sponsors who wish to make a statement on this bill. Seeing none, I will open it up to the public. I failed again, my God, to make an introduction. The public will have 3 minutes. I will ask those in support of this bill to please testify first, and then we'll go those in opposition and those neither for nor against. And this will be done for every bill during the public hearing. So those in support of LD 1422, please raise your hand and we'll welcome you in. I don't see any. Ms. Fahey, do we have anybody who wished to speak in support of this bill?
No, seeing no hands.
Okay. And those who wish to speak in opposition of LD 1422.
I'm bringing over Michael Cabetta.
Thank you. Welcome, Mr. Cabetta. Join us.
Thank you very much, Senator DeChambeau, Representative Warren, and honorable members of this committee. Good morning. My name is Michael Cabetta, and I'm Policy Counsel for the ACLU of Maine. And on behalf of our members, we urge you to vote that this bill ought not to pass. If enacted, as the sponsor explained, this bill would do two things: fund drug abstinence education programs by $1 million and add police to Maine's hate crime statutes. Both these reforms would represent steps backwards for this committee. I'll start with the hate crimes point first. Adding police to Maine's hate crime statute would be a wholly inappropriate amendment and, frankly, an affront to the foundational precedent for hate crimes legislation. These laws were intended to aid prosecutions for crimes that were typically undercharged or not charged at all, like crimes where people beat or murdered African Americans and received very light sentences. By contrast, since the beginning of the development of modern police departments in the 1920s, there is absolutely no record that crimes against police officers or other first responders have been treated frivolously. There's no record that such crimes have not been prosecuted because prosecutors want people to get away with the crime. And after conviction for these crimes, there's no record of sentences so low that they were insulting. That is the history required to justify a hate crime, and it simply does not apply to violence against law enforcement. The second prong of the bill would also be a terrible idea. Drug abstinence education has repeatedly been shown not to work. In fact, those with children in this committee know that advising young people not to do something is one sure way to ensure that they do it. What does work is treatment, destigmatization, and mitigation of the factors that inculcate despair throughout our society. In order to make a difference in the opioid overdose crisis, legislators must appropriate money for those items. We recommend ending the criminalization of people who use drugs. Ending prohibition is not a panacea. It will not by itself end substance use disorders, nor will it bring about social and economic revitalization. However, ending prohibition, hand in hand with increasing treatment and other life-affirming supports such as housing, could foster the redirection of public resources towards social development, legitimate economic opportunities, and effective treatment, enhancing the safety, health, and well-being of all Mainers. We urge you to vote ought not to pass, and I'm happy to try to answer questions.
I see Senator Sayaway, followed by Representative Pickett.
Thank you, Madam Chair. Mr. Cabetta, could you, for the work session, get your science-based information that you gave out about it does not work for
with pleasure.
Drug education?
I would be happy to briefly describe that data here as well, if you wish, Senator.
Well, I'd like just see it.
With
Thank
pleasure.
you.
I'll send it to you and to the committee.
Thank you.
Yep.
And now Representative Pickett.
Yes, thank you, Madam Chair. Thank you, Mr. Cabetta, for being here today. When you look in, when you look into the code and you're looking on sentencing, and it says by up to, and then there's a number. In the case of this being a simple assault committed upon a law enforcement officer, is a Class C offense punishable by up to 5 years in prison. What does the up to mean?
It means up that much or less.
Okay. And I think you said, if I'm correct, I think you said that there hasn't been much, you don't have much record, or you don't see much record of any frivolous sentencing or such as that. I can't remember exactly how you put that, and I don't want to put words in your mouth, but saying that law enforcement officers, they've always, if something like that has happened, it's been dealt with as far as an assault on them. Am I correct in that?
Yeah, our understanding is these crimes are not undercharged. These crimes are charged. And so hate crime statutes exist for the crimes that historically have been undercharged. And that doesn't happen in this area.
Okay. Okay. So I would just say this, and I'm not, and I just would say this from experience. I was in a time in the 70s, 1970s to early 80s. I was in law enforcement, starting out my career in the early 70s. And and again, the law is only as good as the people that enforce it, and the prosecutors that prosecute it, and the judges that hear it and give out whatever the sentence is supposed to be. And the problem sometimes is with these assaults on police officers, as was at the time with me. Back at that time, we had a judge in a certain court that it was well known that if you assaulted a police officer or decided to take a punch at a police officer, that if you went to court and you were going to get a $50 fine, that was it, period, nothing else. And that's a fact, because I know I was there working in that district. So I only say that to just let you know that I think you're right. I think they are reported a lot. There's a lot of people that are charged with that, but I just wish there was some way that we could get the importance that when a police officer gets assaulted, that they're doing their job, and and fight me in court, don't fight me on the street, that kind of thing. And so I just wanted to get that out there, just to let you know that there are situations, at least in our state, there have been, when it became a joke, and the standard joke in the area was, hey, if you don't like Trooper Pickett or you don't like Trooper Savage or whatever the case may be on Saturday night, go ahead. It's only going to cost you $50. What's the problem? So I just wanted to throw that out to you.
Thank you, Representative Pickett. I think what your comment highlights is the need for the state of Maine to collect more data across all systems. And that's one of the walls that we come up against when we try and understand what's going on in our government.
I do have a question, but before I ask that, I was just looking at Vertigo, page 114, 115, about, and they're all class Cs, I believe, assault on an officer, and then another section, unlawful interference with law enforcement dogs, assault on medical care providers, assault on law enforcement horses, on a firefighter, apprehension. They're all the same. And again, I go back with what's Clark's position on this. This is almost a special class, but I do have a question of, is Mr. Stewart, Senator Stewart still
Madam
here?
Chair, we're in a public hearing, and he testified and we asked questions, and now we have somebody in front of us and we can ask questions, but let's do the repeated questions of Senator Stewart at the work session. This is just a public hearing right now. Otherwise, I mean, we have about 16.
I wanted a clarification. If you can clarify it, it is section 2, ongoing funds. I just wanted to know if those funds are currently appropriated. But your counsel is well taken.
Thank you.
Even though I'm choking, but that's okay.
Thank you.
All right. So we are in opposition. Anyone else wish to speak in opposition? I have Miss Arrington, are you here to speak in opposition?
Yes.
All right, go right ahead.
Yeah, I'm just listening to the hearing today, and I just wanted to say one thing as like a resident of Maine. I live in Portland. I've spoken before the committee before on different bills having to do with substance use disorder for the most part. And I just wanted to express how DARE is ineffective and how I do not like the DARE program. And I wish that it was a different program. The only thing DARE taught me is where to find drugs. And also I would like to say, I can't believe that I'm having to say this, but hate crimes should not be based on occupation. Thanks.
Anyone else wishing to give testimony in opposition? Seeing none, I don't believe anyone
Yes,
else
no
did.
further hands, Senator.
Excuse me?
Seeing no further hands.
Thank you. Anyone wishing to speak neither for nor against?
Again, seeing no hands.
Thank you. Therefore, seeing no one else to speak on this, I close the hearing on 1422. And Ms. Overton, do we have a date for a work session?
No, we don't. We had to, at the last minute, cancel all the ones. We'll let people know as
All
soon
right,
as we can.
thank you. Thank you very much. I now have the second one. This is 1486, and then we'll be following with 1592 and 1605. 1486 is Representative McDonald. Is she with us? Thank you. And Representative McDonald's bill is an act to improve investigation of child sexual abuse. And we also have something from Clack with that. Representative McDonald, welcome.
Good morning, Senator. Thank you very much for having me here today. Senator DeChambeau, Representative Warren, and distinguished members of the Joint Standing Committee on Criminal Justice and Public Safety, I am Representative Genevieve McDonald of Maine House District 134, and I am here to present LD 1486, an act to improve investigations of child sexual abuse. This bill provides law enforcement with an additional tool in the fight against child sex trafficking and increases the punishment for those who attempt to patronize prostitution of a minor. LD 1486 would clarify in the Maine Criminal Code that when a law enforcement officer or advocate is posing as a minor as part of a sex crime investigation or other law enforcement effort, they are deemed a minor for the purpose of criminal prosecution. Under this legislation, the level of crime the subject would be charged with would be the same, whether they merely believed the adult was a minor or whether there was an actual minor who was the victim. This bill also upgrades the level of crime from Class D to Class C. It is imperative we stop would-be predators from gaining access to minors who are victims of child sex trafficking operations, and this legislation provides an additional pathway to do that. We do not want to leave loopholes open or tie law enforcement's hands as they work to protect our youth from predatory behavior and to disrupt child trafficking networks anywhere they exist. Thank you for your time and consideration, and I'm happy to answer any questions.
Any questions of Representative McDonald? Representative McDonald, I read this and I kept getting stuck on the word believe to be a juvenile or a young person. I don't know. Do you know of a story that I'm trying to figure out why we have this bill.
We have this bill so that a law enforcement officer posing, for example, as an undercover who in fact is not a minor, the person could still be charged if they solicited that undercover officer.
Oh, all right. I'm sorry, I missed that. Interesting, thank you. Any questions, Ms. McDonald? Seeing none, I will now ask if there are no co-sponsors or legislators that might want to speak. I will open it up to those who are in support of LD 1486 to come forward and give testimony.
I'm bringing two people over.
Thank you. Welcome, Mr. Walsh, Nathan Walsh. And you wish to give your testimony in support?
Yes, thank you, Madam Chair. I am an assistant district attorney in prosecutorial district 3, where I've been designated as the human trafficking prosecutor. I have spoke with Representative McDonald about this bill, just to put some context for it, because I oversee some of the operations that she's talking about. So currently, under the patronizing the prostitution of a minor statute, it requires for me to prove my case that there was a victim who in fact had not attained 18 years of age. So basically this language change would be so that if the defendant was proven to have believed to be the person with whom they were communicating was under the age of 18, we could still obtain a conviction. As of right now, for us to conduct sting operations, we would not, the undercover officer is not in fact under the age of 18. So we've run into an issue where it makes it difficult for us to proactively look for people who seek to prey on children.
Thank you. Is that your testimony to explain that? That's it? Thank you.
Yes, sir. And I also would say that there a portion of this is also addressed in LD 1592. It's very similar, the language, but I support this amendment to allow us to carry out this function to conduct proactive stings for people soliciting children online.
Okay. Mr. Walsh, District 3, could you tell us where that's located?
Sure. Okay. If I bring it up.
No, you said you were an ADA at District 3?
Oh, Androscoggin, Franklin, and Oxford counties. I serve District Attorney Andrew Robinson.
Okay, thank you. No questions of Mr. Walsh. I now will recognize Elizabeth Saxo. Welcome.
Hello, Senator DeChambeau, Representative Warren, and distinguished members of the committee. My name is Elizabeth Ward Saxel, and I'm submitting testimony today on behalf of the Maine Coalition Against Sexual Assault, the organization which represents and serves Maine's sexual assault support centers, as well as Maine's children's advocacy centers. We are here today in favor of LD 1486, and thank you to Representative McDonald for sponsoring this bill. Child sexual abuse has a significant impact on the health and wellness of Maine's communities. Half of the calls to our sexual assault support line are from or about people under 18. In Maine, about 7% of high school students, that's 10% of girls and 4% of boys, report that they've been forced to have sex in their life. Law enforcement officers and prosecutors, as you've heard, have indicated that the current law does not allow for some undercover investigations if, in fact, the individual who is posing as the child is not, in fact, a child. In Title 17, Chapter 11, there's precedent for this approach. Both 259A, solicitation of a child to commit a prohibited act, and 259B, solicitation of a child to engage in prostitution, include the element that the actor believes the other person to be less than 14 or 18. This bill takes the approach of adding language which would apply broadly across chapters 11, 12, and 35 to address the investigative issue. I understand there may be some concerns about this approach. A more tailored approach may be to focus on the section 855, which is included in the bill, and which is the other crime relating to attempting to engage in illegal sexual activity. With regard to the final section of the bill, as with the other instances this provision has been introduced this session, we don't have a position with regard to the elevation of the crime of patronizing prostitution of a person who has not yet attained the age of 18. This is because we don't have enough data about the prosecution of these current offenses and whether the sentences for these offenses are more often than not hitting the maximum sentence. I'd be happy to try and answer any questions you might have, and I thank you for your time.
Thank you. Questions for Ms. Saxon? Seeing none, thank you very much. If there are no one else that wishes to speak in support, I will ask if there's anyone who wants to give opposition testimony.
Seeing no hands, Senator.
Thank you. Anyone wishing to speak neither for nor against LD 1486?
Again, seeing no hands.
Thank you. Having concluded the testimony, I will close the public hearing on 1486. Thank you. I now will turn it over to Representative Warren, who will do 1592 and 1605.
Thank you, Madam Chair. So 1592 is an act to decriminalize engaging in prostitution, strengthen the laws against commercial sexual or exploitation, and allow a person convicted of engaging in prostitution to petition the court to expunge the record of conviction. And that's our very own Representative Reckitt. Thank you, Representative Reckitt.
Shall I begin?
Yes, please.
Thank you. I'm not going to repeat the long name of this bill. It would take up too much time, even though I know that I have unlimited time, unlike the others who will be restricted to 3 minutes. However, I will say, Senator DeChambeau, Representative Warren, my fellow members of the Criminal Justice and Safety Committee, I'm sorry for my outfit today with the earphones. There's a carpenter in the other room, and I'm trying to make sure that both I can hear and you don't have to hear them working on my wife's office. My name is Lois Galgay Reckitt, and I'm a representative from District 31 in South Portland. Before I begin my presentation on the substance of my proposed bill, I want to tell you why I submitted such a bill. Early in the 1980s, my local chapter of the National Organization for Women held a series of internal small group discussions about difficult topics that had surfaced in the women's movement at that time. We chose to verbally struggle together on the topics of power, pornography, and prostitution. One of the leaders of the chapter at that time was a good friend, and we trusted each other, enough for me to risk saying to her about her previous struggle to survive and raise her children. She did so as what I then called a prostitute. I understand that you sold your body to survive, I said, but what I don't understand is how could you do it? In the mid-1980s, I was elected to the post of Executive Vice President of the National Organization for Women. As a result, I spent 6 years in Washington, D.C. Excuse me, as part of my policy work, I volunteered to travel the breadth of the United States to hold hearings on the issue of pornography. That trip changed my perspective and drove me to activism on both the issue of pornography and the damage it causes to women, both physically and culturally, and the entanglement of the issue with the plight of what I now call prostituted persons. After I was elected to this legislature and had served a term, I realized it was possible I might be in a position to make a difference on the issue of prostitution. At the time, I was also close friends with a patrol officer in the Portland Police Department. At the time, his beat was the track in Portland, and we talked a lot about the realities on the street. In fact, it was that young officer that began the research that brought the equality model for dealing with prostitution to me. And together with him and a young ADA of his acquaintance, and subsequently mine, who have worked with me on this issue before you for several years, I go on. As a result of that research and outreach, we have connected with many regional and national groups, led in large part by survivors of prostitution. A number of those groups will appear here today in support of LD 1592. This bill before you does not come without a lengthy struggle to, quote, get it right. The first draft just plain missed the boat, I presume because we were perhaps not clear of our intentions. The second draft got the innocent and guilty backward. Even though the draft was finally worked out, had finally worked out most of the kinks, there are a couple of substantive changes yet to be made and one clarifying word. Now I want to walk you through what I call an English translation of the lawyer document that is the bill. And others who follow me can explain it in more detail, but here goes. When you look at my testimony that is posted online, pages 3 through 9, are the text of the bill separated and articulated, excuse me, and explained section by section what that means exactly. I myself am not a lawyer, and so it's always helpful to me when somebody gives me an English translation of what a lawyer is talking about. So when we get to consideration of the bill in work session, I hope that you will look at that document and try to see it, see if your concerns are met when you find the explanation. I'm not going to go through it section by section, although I am going to do a couple. Section A1 amends the Victim Compensation Fund to clarify by new placement that the victims of what I call in my bill commercial sexual exploitation are compensable by that act, and the fines that I propose be assessed on those who buy sex are directed to that fund. Section A2 ensures sex sellers can't be charged with criminal conspiracy, including by clarifying that to engage in or agreeing to personally engage in a sexual act or sexual contact in return for pecuniary benefit. Please note that the words "in return" should be added to my bill. That's the first of the amendments I'm proposing. There's a relatively lengthy list of explanations, section by section, and that I included at the end of my testimony. But in the interest of time, I will note one other critical section. The last printing of the proposed bill still refers to the expungement of records in the proposed amendment, in the proposed amendment sent to the committee and analysts this week. I have shifted that to the sealing of records, with drafting help from the State Bureau that holds such records, SBI, and out of a desire to not interfere with the Chief Executive's exclusive pardon power. In summary, the bill keeps prostitution on the books, but creates defenses for the seller while increasing penalties for the buyer. I would add that that's not in my text, that the penalties for the buyer are not jail sentences. I'm not asking you to send people to jail. I'm asking you to penalize people who on average spend $100 a pop to deal with a prostituted person, that they have to pay a monetary fine for engaging in this act if they're apprehended. So prostitution, therefore, is redefined as a buyer problem and a demand issue. The prostituted person is a victim of if a patron attempted to buy her or him. At the end of this testimony, I appended the detailed analysis of not only of LD 1592, I also attached links to a relatively brief description of the equality model, which was the philosophical basis for the bill before you, and a survey report of the actions and attitudes of a survey of 8,201 adult males in the other Portland in Oregon. I found reading it both fascinating and instructive. I hope that this legislature will see fit to enact the substance of LD 1592. Of course, I hope that you will choose to request funding for what I call an exit ramp for survivors. I've suggested a placement of that. I'm not married to that location. I'm only married to the recognition that to help persons escape from prostitution, they need an exit ramp. I truly believe that that if we get this law right, we will be able to find a way to fund the needed services. I thank you for your careful consideration of this critical legislation. And I'm happy to answer questions if I'm able. If not, I'm going to divert it to the person speaking subsequent to me, who I know who helped me and frankly did the draft of this legislation before it went to the revisers. And he knows exactly what each section means. So if you ask me specifics about that, I'm going to ask to bring in the person who knows the answers, and or when he testifies himself, you can ask him for him. Thank you.
Thank you, Representative Reckitt. That sounds fair. Any questions for Representative Reckitt? Seeing none, thank you. Yes, Senator Searway.
Thank you, Madam Chair. Do you, I don't know if you know the statistics of those that have been actually charged and convicted of prostitution. In Maine, you don't hear of it very often. And I just thought that most of them, even if they got a charge, that they got help and directed in many cases. And I was just wondering about that, what the statistics were.
I don't know exactly. I do know that in some jurisdictions there has been a shift against arresting the person who is selling the sex, and so therefore there have been less arrests. And one of the officers who was engaged in that activity is testifying today, and he could be able to answer that end of it. And the prosecutor who's going to be testifying at some point behind me might have better statistics than I. I know everyone's intent is to assist people who wish to exit what they call the life. And certainly that's what I'm trying to do as part of this as well. But I believe you have to come from a place of believing that the people who are engaging in the selling of sex are predominantly doing that frankly for survival, and can't just be arrested and thought world's going to be great. One of the other things I'm proud of in the bill is that there is a small section that says when 6 years down the road, if somebody had a prosecution for prostitution, so therefore they have that word in their records, it can be used. I take out that word so that it can't be used against them in a child protective situation, because right now there's a section in the law that says if you were a prostitute, then you're a danger to your own children. And I don't believe that somebody who has left the life, or even who is in it, frankly, is necessarily a danger to their children, and should not have them taken away on that account. So there's some small things like that I've also built into the bill.
Just follow up on that,
Sure.
Madam Chair. So, so what do you do if children are being exposed to those situations where somebody keeps coming in or whatever? Is that
well? It's really it's unusual that people are doing in-home prostitution, and so it's not. There's less chance of exposure than there is, for instance, in domestic violence, where it's happening in the home and the children are consistently exposed. That's not generally the truth. In fact, most people, prostituted women who I've spoken with, go to great lengths to keep their children away from what they're doing to survive.
Thank you.
Any other questions for Representative Reckitt? Seeing none. Thank you, Representative Reckitt.
Thank you.
Any co-sponsors or legislators here to testify on this bill? Seeing none, we'll now take testimony in support of LD 1592. And if you raise your hand, Deb will bring you over. Good afternoon again, Mr. Walsh. ADA Walsh, correct?
Yes, Madam Chair, thank you.
Welcome. Thank you for being here.
Thank you for having me. So I am here to testify in support of LD 1592 and urge you to vote that it ought to pass. The bill it's long and it seems a little technical when you read it on its face, but basically what we would be doing is instituting what's been called the equality model in the state of Maine. The equality model is because it identifies the problem in prostitution, not on the people who are selling sex, but on the sex buyers. At its root, the harm that's caused is caused from sex buyers. If people didn't buy people, people wouldn't sell people. I've been doing the work as a human trafficking prosecutor for 5 to 6 years now, and I've met numerous women in the life from Maine and from people from out of the state of Maine who've been involved in this. And what I've come to see this issue as the commercial sexual exploitation of some of the most vulnerable members of our community. This isn't something that's occurring between two consenting adults when consent has been purchased. It really is an issue of exploitation. And that's how I think a lot of the prosecutors in the state and a lot of law enforcement see it too. So presently we talk about arresting women who are, or men who are involved in selling sex in order to divert them to access to services. But I think that kind of shouldn't the point be to have them have services so that they don't get involved in the criminal justice system, as opposed to having the criminal justice system be the answer to the problem to provide services. I don't have services to offer. I prosecute people for crimes when they're culpable and deserve a criminal penalty. And when we're dealing with survivors of sexual exploitation and sex trafficking, I don't see them as deserving of a criminal penalty. So I think there could be a better way. Part of the bill at the end would adopt a pilot program in Androscoggin County, where I'm a prosecutor, which would provide the services that we're talking about, so that law enforcement would no longer have to be the gatekeeper to access to services for the people in need, and that we'd have a mechanism in place for people to exit the life. I think that the equality model is, from my experience, the best way to go to respond to this issue. And I noted it's not, it's a bold move in the United States, but it's not new. Canada uses the equality model. So this is, I think this is a big step in the right direction to better serve Mainers who are being exploited for sex commercially.
Thank you for your testimony. Questions for Mr. Walsh? Seeing none, thank you. Next up, we have Christian Eduardo. Welcome.
Yes, thank you, everyone. Good morning. I really appreciate of creating the time for this. I'm here to ask your support and to vote in favor of LD 1592. I'm Christian Eduardo. Trigger warning, because I'm going to be talking about really heavy stuff. I am a survivor of international and domestic sex and labor trafficking. What is the meaning of this? That I was exploited not only on labor activity, but on sexual activity. And the reality is that a lot of times we think as prostitution as a separate entity, human trafficking. That's not the reality. Prostitution and human trafficking are intertwined. And prostitution is a multi-billionaire industry. And you need to keep in mind that this money came from one source, the buyers, the sex buyers that were raping me, the sex buyers that were using my body, and the sex buyers that are promoting like the commodification of people. They are not seeing us as person, they're seeing us just literally as wholes, literally as things that they can dispose and things that they can use just because they have disposable income. That is why the equality model, it's focused on keep accountable, especially buyers, because they are the ones who are promoting prostitution. They are the ones who are preying on vulnerable people like me, that need housing, need food, need resources, that they don't have access to education, or skill trainings for job. So they are going to the places, the communities that they know that they can access. And because they don't see us as human beings, just because they have money, they decide to access our body. They decide to rape us. They don't care about if we are enjoying this. They don't even ask if we are here because we are being forced, coerced. They really don't care. And the other part of the equality model is just because when I escaped my trafficking situation, there were no resources. And that's the reality for a lot of people who are in prostitution. Once you are in prostitution, prostitution is not a playground. There is sexual violence, there is dehumanization of as persons, and we are just seen as things that you can throw to the garbage when the people with money use us. So it's very, very important to have resources and services regardless how people are in prostitution, because it's very important to understand that a lot of people are forced and coerced in prostitution, and on the other part, there is people who are just trying to survive. Because we are failing them, we have been criminalizing them, and that's not the solution. Just being criminalized because I'm trying to survive is traumatizing, and a lot of times it replicates what traffickers do to me. Not acknowledging me as a human being and just putting all the blame on me. That I'm the one creating this and I'm the one to blame for my own exploitation.
Thank you, Christian, for being here and sharing your story with us. We have a question for you from Representative Pickett.
Thank you, Mr. Eduardo. I just want to thank you as well for really explaining this in a way that we really get a real understanding for what really is happening out there. It took courage for you to come on today and do that, and I really appreciate that. It's given me a much clearer view of what actually is going on here. Thank you again.
No, thank you everyone for giving me this time. I think that it's very important to listen to survivors. It's hard as a survivor to speak about this because buyers are out there. The buyers that were accessing my body, the people who exploit me, are there, and they are doing the same to other people. So it's very important to keep them accountable. Thank you for listening to Survivor, and more importantly, I really making a call for you. Vote and support on LD 1592. Like, we need to keep accountable buyers. We need to listen to survivors, and we need to believe in survivors. We deserve more than just surviving. We deserve to thrive. Thank you so much.
Thank you again. Thank you for your testimony. Next up, we have Elizabeth Ward Saxel.
Senator DeChambeau, Representative Warren, members of the committee. My name is Elizabeth Ward Saxel. I'm here again on behalf of the Maine Coalition Against Sexual Assault in favor of LD 1592. Because of the timing of this hearing, we don't currently have consensus among our members on the issue of repealing the crime of engaging in prostitution, but we do believe it would greatly increase the safety of individuals engaged in commercial sex. Being part of a marginalized group, people who are engaged in commercial sex are at risk of violence, poverty, homelessness, substance use disorder, system involvement. Prosecuting people for commercial sex has a host of negative consequences on those individuals' lives that make healing from trauma and exiting conditions of poverty, homelessness, and substance use harder. They include loss of jobs, barriers to employment as a result of incarceration, loss of financial security, including asset seizure and loss of housing. We do not support the renaming of the crime of engaging a prostitute. While we know that many people who are engaged in commercial experiencing sexual exploitation or trafficking, not all are. It is possible for there to be a consensual action between two adults who are seeking to exchange sexual activity for money or something else of value. Similarly, sex crimes all share the element of lack of consent or inability for the victim to give consent. While this could be a component of engaging a prostitute, and often is, it is not necessary. We believe that moving this crime into the sexual assault section has the potential to weaken or confuse the meaning of sexual assault. We strongly support the expungement provision. Now I understand it's ceiling issue. While you have heard over and over again the concern that expungement may be unconstitutional, we think it's time for the courts to decide that. So we would love to see expungement go forward, and if not, certainly sealing of records as Representative Reckitt has presented. With regard to the pilot project, there are a number of great organizations who are currently doing this work. Safe Voices, who runs the first only emergency shelter for people experiencing sexual exploitation trafficking. Sexual Assault Prevention and Response Services, who has a dedicated advocate serving sexual exploitation survivors. Preble Street Anti-Trafficking Services, etc. There are more in my testimony. And additionally, there are some multidisciplinary teams across the state who are looking into this issue and services. So we'd really urge you to speak with the existing teams about the existing needs per community. We're grateful for Representative Reckitt bringing this forward. We certainly believe there are more services that are needed across the state, and look forward to working with the committee.
Thank you so much. Any questions for Ms. Ward Saxel? Yes, Senator Searway.
Thank you, Madam Chair. Thank you for coming, Ms. Saxel. I just got a question. I know we worked on something like this before, and the big problem was trying to figure out how we can get them help. I think it was trying to get them into some type of program. And what's your thoughts on that?
Sure. Thank you for asking it. And if I might, I'm going to answer the first question that you asked earlier on too, which is that I have looked at the data for the prosecution of prostitution over the last 3 years. And what was said is correct. Most districts in Maine have not been prosecuting prostitution, period, for the last 3 years. However, some are. And what that does not address is how many, as you know, are being charged with prostitution. And I know that there has been a line of thought, Senator Searway, you and I have talked about it over the years, that charging someone is the way into this. But we believe that the ramifications of that charge alone are really not it. That there are other paths into services through advocacy services and so forth. And so increasingly, what law enforcement officers are doing in communities is when who's engaging in prostitution, engaging in sex work, they will reach out to the service providers and have them connect directly. So pulling the law enforcement and all the ramifications of engaging with the criminal justice system out of the center of that. That said, as Representative Reckitt's bill recognizes, there are not enough services statewide. And I think it will take a significant investment by the legislature to really expand the scope of services. But the good news is that we've got a really strong victim services set of service providers who can work with others to continue to build that structure out to meet the needs of survivors. Certainly organizations like Survivor Speak are right out on the front of doing that work and supporting survivors. So that's a really long-winded answer, and I appreciate your patience while I provided it.
Just to follow up on that, I don't know if what I'm saying is lots of times they're not being charged, but there's kind of like that umbrella just saying that they could be unless they go and get this help, which has been kind of the carrot to get them the help. So how do we do that if this is gone?
Right, and I would argue that it's not the carrot, it's the stick. And okay. I think there are carrots that are available. And so I think what we want to do is when law enforcement becomes aware of these situations, them connecting directly with the advocates who they've got relationships with to help have those advocates reach out to provide support and help folks get to substance use disorder treatment or get to housing or get whatever supports they need to be safety and, as your previous witness said, to thrive.
And just
thank you.
Just additional to that is I hear you, and I just kind of wonder, if a law enforcement officer says something about somebody, and then somebody goes to that person, how do they take it? And they may get very defensive, and so I don't know how that would work.
Well, it's currently working on the ground that way in many communities. I'm sorry, Madam Chair.
Thank you.
I'd like to ask Elizabeth if you'll be at the work session, because it sounds like this will be a great discussion for the work session, and you will be. Could you also get us the data that you talked about over the last 3 years?
Sure. It is owned by the Prosecutors Association, so I will reach out to them and confirm that it is all right to provide that information to you.
Great. Thank you very much. And also Representative Pluker has a question for you.
Thank you, Madam Chair. Thank you, Ms. Saxel, for being here. I'm looking at your testimony around renaming and moving engaging a prostitute. Mm-hmm. Could you, and specifically not those who are engaging a prostitute, who are not experiencing these forms of violence by the action of the person. Could you just explain that a little bit to me? I'm having a hard time.
Sure, absolutely. Well, it is, there is a philosophical disagreement in the movement. And the question you're asking comes down to that, which is that our providers and we have had conversations with a range of folks who are engaged in sex work. And there are some who indicate that they are doing that work of their own consent. And there are others who believe that under no circumstances can anyone consent to do this work. And one of the challenges for us is that when survivors tell us a thing, our job is to believe it, right? So we come from a place of believing that not all sex work is sex trafficking or necessarily sex exploitation. Whereas there are others in the field who believe that all sex work of any kind is the individual is a victim who is being trafficked.
So the person, a follow-up, Madam Chair.
Yes, please.
So the person who is engaging the prostitute may not be committing a crime if everybody is consenting, is what you're saying?
Well, I guess what no, because we're not quite at a point where we think that the supply side is, we can still, that individual who's engaged in the crime can be doing that with consent, it'll be illegal. I know that's a fine line, but that's where we land. So
you were breaking up a little bit. So
okay.
So I understand how the person providing the services should not be criminalized. Right. But the person who's purchasing the services, you're saying, are there some examples where that person should not be committing a crime?
Currently, that is not our position. We're to the extent that we have consensus, which we don't quite yet because we haven't finished this conversation in-house, but the majority of people support this model where the buyer side is criminalized and the sex work side is decriminalized.
Okay. I think I look forward to getting clearer on it for the work session. Thank you.
Okay.
Any other questions for Ms. Ward-Zaxel? Seeing none, thank you very much for your testimony. I'm going to move now to Lena Nealon. Welcome.
Thank you, Madam Chair, members of the Committee on Criminal Justice and Public Safety. Thank you for this opportunity to provide background and context showing LD 1592 to be a very strategic and innovative approach to the goal of shrinking sex trafficking and prostitution markets, both of which cause profound, often lifelong harm to its victims. My name is Lena Nealon, and I'm the Director of Corporate and Strategic Initiatives at the National Center on Sexual Exploitation in Washington, D.C. Our mission is to oppose all forms of sexual exploitation and abuse and to promote human dignity. For 8 years, between 2008 and 2016, I served as the founding director of Demand Abolition, a Boston-based national program dedicated to combating the demand for commercial sexual exploitation. Our most innovative work involved a collaboration between 12 major cities, including Boston, to flip the paradigm widely used by law enforcement. Rather than arresting those selling sex as the main approach to limiting prostitution, jurisdictions we worked with focused on sex buyers as the drivers of the entire commercial sex industry. The insights motivating this new approach, being implemented in cities now ranging from Seattle to Houston to Boston, that are embedded in LD 1592 are the following. Prostitution is not a business like any other. It is exploitation, as this bill so rightly defines it. Multiple research studies and survivor testimony leave no question that prostitution is an inherently harmful, illicit industry preying on the most marginalized in society. Prostitution and sex trafficking are inextricably linked. All victims of sex trafficking are trafficked into prostitution markets. By federal definition, severe forms of sex trafficking involve the use of force, fraud, and coercion, which may, for example, involve drugs, disabilities, or homelessness. Sex buyers drive the commercial sex market. Simply put, if there were no buyers, there would be no business. Yet sex buyers have remained largely unaccountable, while those they purchase have too often suffered multiple traumas, including arrest and incarceration for a crime perpetrated against them. Robust evidence is spurring rapidly increasing recognition across the US and globally that the most effective way to combat sexual exploitation is to tackle demand, the root cause. We know from interviewing sex buyers and monitoring online sex buyer chat boards that buyers purchase people because they are confident they will get away with it. In a study by Demand Abolition surveying 8,000 adult US males, the majority reported that they would stop doing it if the legal and social consequences were more punitive. Punishments they especially fear are being arrested and having their crime found out by families and employers. LD 1592 addresses several areas buyers themselves said would alter their behavior. It sends a powerful message to buyers and society at large that purchasing another human being is not acceptable in the state of Maine. It enacts principled penalties, making the consequences fit the gravity of the crime. It makes clear that consent cannot be coerced by cash or credit cards. Some of the proven methods of reducing demand can be pursued without burden on taxpayers, and equally important, it provides options for people who are exploited in prostitution and want to get out. Thank you for your attention.
Thank you, Ms. Nealon. Any questions? Yes, Representative Pickett.
Yes, thank you, Madam Chair. Ms. Nielsen, is there any way that we could get you to submit your testimony? I don't see it in the queue. It would be very helpful for us for the work session.
Absolutely.
Thank you.
Any other questions? Seeing none, thank you very much for your testimony.
Thank you.
Up next, I have Lucy Bloom.
Hello, thank you very much, Madam Chair. And I want to give a special shout out to Representative Lois Rickett for her courage and bravery in representing the voices of so many who have been sexually exploited and have also received the brunt of the criminal system at the same time. And I am very impressed with ADA Nathan Walsh and the other testimonies that have been shared today. And on behalf of the voices of thousands of sexually exploited on the East Coast and then untold across our nation, I want to say thank you to all of you for considering what is this bill, which is representative of the equality model, which has already been stated. In my testimony, I included some of the history of with the Palermo Protocol and with our efforts in the United States to provide protections to our citizens from commercial sexual exploitation and from human trafficking. So I won't go into that now, but where I kind of want to pick up is this concept that language matters. It matters very much. And there is nowhere in our society right now that being a person labeled as a prostitute is an advantage. It is a tremendous disadvantage as you are seeking protection from law enforcement, as you are seeking to access services, seeking to be housed, seeking to raise your children in a safe community. And this language of commercial sexual exploitation is so important because it calls it what it is. And it also recognizes that this is not a victimless crime. This is a crime of exploitation. There have been several organizations that were named by Elizabeth Ward Saxel that stand ready to serve victims. And I want to list one more. Sister survivor Tricia Grant of Sophia's House is there in Maine, ready to help lead the way in design of this pilot program that I believe is not just a pilot for Maine, but it will be a beacon of hope and light for organizations such as Veronica's Voice across the country. Veronica's Voice has been serving survivors of commercial sexual exploitation since 2000 and have been proponents of the very model that you all dare to discuss today. And I'm so excited to be standing alongside you all from the state of Kansas, but in favor of what you are doing, because I believe that what they have written together, it recognizes the numerous human rights and the dignity of a person that is being violated when they are purchased to perform a sex act. And it also gets at the root of the crime by addressing demand. And it provides a streamlined law, making it easier to coordinate the enforcement of these crimes, whether it be a crime against an adult or a minor, a national or a foreign national. So Veronica's voice is strongly supporting LD 1592. And again, congratulations on your efforts. Thank you for your time and your consideration.
Thank you, Ms. Bloom. Any questions? Seeing no questions, thank you very much for your testimony. Up next, we have Michael Cabetta. Welcome.
Thank you, Representative Warren, Senator DeChambeau, and distinguished members of the committee. Good afternoon. Michael Cabetta from the ACLU of Maine, where I serve as policy counsel. On behalf of our members, we urge you to pass this bill, but with certain amendments, which I will discuss now. Our organization has advocated for the decriminalization of prostitution since 1975 for reasons included in my testimony, and for the same reasons that testifiers before me described. We urge the committee to unequivocally support the provision of this bill decriminalizing prostitution. This bill would also set in motion a promising approach to healing survivors of sexual trafficking and coercion, a stakeholders group made up of representatives of interested groups. Moreover, it would allow for survivors to have their criminal records expunged. I want to pause here to briefly comment on the question of whether expungement is constitutional. There's no court in Maine that has held that to be true. The only source for the conviction that expungement is unconstitutional is an opinion by the Attorney General. Like Elizabeth Ward Saxel, we believe that this issue should go to court. This committee should boldly favor and enact an expungement provision. We applaud the bill sponsor for adding these positions, but we actually think the committee can strengthen the expungement provision of this bill. Expungement should extend not only to the crime of prostitution, but also to other criminal acts committed during the period in which the petitioner was trafficked. The coercion of survivors typically extends well past prostitution to drug trafficking and other behavior that's currently prohibited. We urge the committee to take this opportunity to truly give survivors a clean slate. There are parts of the bill that we urge the committee to reject, like other bills before the committee this session and today. This bill would increase the classification of engaging in prostitution with a minor to a Class C crime, and it would create a Class D crime for commercial sexual exploitation. This new form of punishment will not get to the root of the problem, which is the impoverishment of families and their children, especially families and communities of color in whom the government does not invest sufficient resources. We urge you to amend this bill in accordance with our suggestions and vote ought to pass as amended. More detailed reasons for our position are included in my written testimony, and I'd be happy to try to answer questions.
Michael, thank you very much. Questions? I just have a quick question because I didn't know that expungement, you know, we sort of have this, everyone has this theory that we can only seal in Maine. Who was the Attorney General when they ruled that expungement was only provision of the governor?
I believe in the, well, I think in previous legislatures and previous governors have opined that expungement is unconstitutional to committees. I remember 2 years ago, Attorney General Aaron Fry opined to the Judiciary Committee that expungement is unconstitutional. And the constitutionality argument is fairly straightforward. The Maine state constitution says the governor has the exclusive power to pardon people convicted of crimes. And the Attorney General thinks that expungement is synonymous with pardon. And that's not necessarily the case. Lois Reckitt earlier, Representative Reckitt, said that lawyers should translate their words into English. The words pardon and the words expunge are both straightforward English language words that could mean the same thing, could not mean the same thing. It's up to a court to decide. And if a court does decide it, then 2/3 of the legislature can decide to take that power back from the governor and give itself the power to expunge criminal records, which makes perfect sense because it's the legislature that creates the crimes. So why shouldn't the legislature also be able to take away the crimes, to expunge the crimes?
Here, here. Thank you very much for that answer. Any other questions? Thank you for your testimony. Up next, I have Pansy Watson. Welcome.
Thank you. Thank you. My name is Pansy Watson, and I'm an attorney at the National Center on Sexual Exploitation in Washington, D.C. We're here to support the state of Maine in proposing this landmark bill. 1592 accurately reframes prostitution as a buyer problem. Rather than just remove prostitution laws from the books, it puts the onus on sex buyers, redefines them as commercial sexual exploiters, moves patronizing to the section of laws on sexual assault, and increases penalties for exploiting minors. These are exactly the kinds of approaches that have led to substantial positive changes in other states that implement them. Last year, I reviewed state laws on prostitution and found that those that addressed the demand side and offered comprehensive services had the most effective results in reducing prostitution, including the nuisance level crimes that often are associated with it, as well as the more severe crime of trafficking that always stems from it. States that target buyers increase neighborhood safety, and law enforcement report feeling good about getting to focus on the real bad guys. All prostitution exists because of demand, and all sex trafficking exists on the prostitution market. Demand must be targeted in order to curb exploitation. By redefining buyers as commercial sexual exploiters and placing the crime of engaging a prostitute in sexual assault laws, Maine is making it clear that consent cannot be bought and that human beings are not commodities. No one should be legally entitled to buy another's body. This is a cutting-edge approach that would make Maine an innovator and a leader. By creating a pilot program with comprehensive services for those who seek to exit the life or mitigate the harm they are subject to, Maine recognizes that the decision to prostitute is often made when there are no other choices. Providing these services creates real choice and real opportunity. And in many states, it is fines assessed against the buyer that funds these programs, making buyers truly accountable for the harm they cause and easing the burden on the state. Importantly, this bill creates a means by which prostituted persons may expunge and seal their records so that they can pursue housing, work, and live their life free of the stigma of criminal records that do not reflect who they truly are. To conclude, demand reduction, along with the exit and expungement services outlined in 1592, are the most effective ways to mitigate prostitution and trafficking. Passage of this bill would help make Maine a place where no one is exploited and would put Maine on the map as a leader in prostitution reform. Thank you.
Thank you. Any questions? Yes, Representative Pickett.
Yes, thank you, Madam Chair. And Ms. Watson, could you as well get your testimony to us? I didn't see it in the queue, so it
Yes,
would really be helpful for the work session.
Mhm.
Thank you.
Great. Any other questions? Seeing none, thank you very much for your testimony.
Thank you.
Next up, I have Mark Keller.
Hello.
Hello.
Good afternoon. Would it be helpful? I know Senator Seaway had some questions earlier. Would it helpful if I could help answer some questions from before, or would it be more helpful if I just read my testimony and take it from there?
How about if you start with your testimony, and if Senator Searway still has questions, he'll ask you.
Great.
Thank you.
Senator DeChambeau, Representative Warren, and members of the Criminal Justice and Public Safety Committee. My name is Mark Keller. I am a resident of the city of Westbrook and formerly a resident of the city of Portland. Currently, I'm a Portland police officer, and I have served in the Portland Police Crime Reduction Unit, and I was also a task force officer with Homeland Security, which one of their primary tasks is looking at the crimes of human trafficking, prostitution, and also related crimes. I was once a co-chair of the Greater Portland Coalition against sex trafficking and exploitation. Today, I come before you as a citizen of the state of Maine, and I need to put this out there. I'm not speaking on behalf of the Portland Police Department or the city of Portland or Homeland Security. Sex trafficking victims and prostituted people are one and the same. However, the laws of every state in the union view them as different. Prostituted people come from a childhood upbringing of experiencing physical violence, sexual violence, neglect, and exposure to substance use. While it's important for us to recognize that not all people who have suffered from this condition become prostituted people, most prostituted people have a trauma background or have experienced those symptoms. Prostitution is a continuation of violence which began during childhood and continues through adulthood. Prostitution's roots and perpetuation stem from inequality and poverty. Based on my knowledge and experience, it's apparent prostituted people are often the victims of serious crimes to include murder, sexual assault, aggravated assault, robbery, and theft. Prostituted people suffer more from crime than the average citizen. Prostituted people are a population that rarely reports these instances to police because of the occurrence is when engaging in the act of prostitution, which is currently illegal. My research and experience has also shown me there's an adverse relationship between law enforcement and prostituted people due to the nature of the current laws. Engaging in prostitution is a crime of high recidivism due to many factors to include poverty, homelessness, substance use disorder, and the nature of trauma-based experiences and the lack of services. Regardless of the condition of sex trafficking or prostitution, the mere act of engaging in prostitution is an act of survival, and for many, a time without options. The problem is not the prostituted person. The problem lies in the hands of exploiters. It is now apparent that the traditional response to dealing with prostitution is the re-traumatization of the victim at best. It is the rarest of cases that law enforcement intervention using a post-arrest strategy has led to the prostituted person's exit from the life of being trafficked and or prostituted. Law enforcement activity focused against prostituted people ultimately puts them at a disadvantage. Decriminalization empowers the prostituted person by giving them options to seek their own justice. It gives them access to a system that formerly created difficulty in their lives. They've gained a civil right to live without fear from law enforcement and the ability to regain dignity. They are a community scorned by civil society, but will now have access to the justice system in a non-adverse circumstance. As it stands, the current law allows for disparity, relying on the discretion of law enforcement and prosecutors to act in what each individual thinks the best course of action for the person being charged. All too often, the charging of engaging in prostitution is a tool used to entice victims to inform on others, be it pimps.
Mr. Keller, I'm going to ask you to try to wrap up. And
I'm
we'll
sorry.
read your testimony. That's okay. Just if you'd wrap up and then we'll go to questions, okay?
Sure. The law provides an affirmative defense to those who report and inform prosecutors for being trafficked, but what the victims who have no one to inform. So what happens with the law provides an out for people who are being trafficked, but doesn't provide an out for the women who are not being trafficked. I think that's an important thing to know. I suppose the rest you can read. It's the pleasantries. And I thank you for listening to me. And if there are any questions, please feel free.
Thank you, Mr. Keller. I'll ask the first, which is just, I hope you're going to be able to be at the work session just because of your lived experience as a police officer working this beat. I know we're really going to be leaning on your expertise. So we'll make sure that we get that information to you as soon as we have it about when it'll be.
I will do my best to attend.
Thank you very much. Questions for Mr. Keller? Senator Searway, do you still, yes, Senator Searway.
Thank you, Madam Chair. Thank you for coming, Mr. Keller. We don't, around in our parts, we hear about it a little bit, but we don't hear about it as much probably as you do in Portland area or in the city areas. With your expertise, I guess, my biggest question is how do we get them the help, and I get it. We're just trying to do what we can to get them, help and get them back to be able to be, just back to humanity, I guess. But it's just, I don't know how we do that. That's all. And maybe you've got a little experience about that.
Sure. I think I'm blessed to be part of the Portland Police Department in the sense is that help is usually pretty close. We have boots on the ground, like Preble Street anti-trafficking, survivor speak. I'm very much, when I was doing the job, was very much a phone call away from help. But what I do know is that if we truly care about the people who are involved in this activity, we have to come to a reckoning that it's not a law enforcement exit strategy that is working. I have yet to meet a woman who, due to a law enforcement strategy, and that means charging with the hopes that they're gonna essentially be stung by the law and that they're gonna think better of it. Sometimes people are having contact with law enforcement; they're already getting services, and it's more of the person is working a system, and it just takes, and it's on their time frame. So their exit is really it's their choice, and it's their good work. And I hope that answers your question, Senator.
Thank you, Mr. Keller. Any other questions for Mr. Keller? Seeing none, thank you for your testimony. Up next, we have Victoria Arrington. Good afternoon.
Hi, thank you. I just wanted to be here again this afternoon to support this bill or show my support for this bill for 1592. Please continue to do the work to make Maine a safe place. Thank you.
Thank you. Any questions for Victoria Arrington? Seeing none, thank you. Next up, we have Eleanor Gayton. Good afternoon. Oh, whoops. Hold on one second, Helen. Let me see if Eleanor Gayton is here.
Yes.
Welcome.
Here we go. Is that working?
Yes, perfect. Go right
Okay,
ahead. Thank
great.
you for being here.
Thanks so much for having me. You've heard a lot of important testimony today. I'm speaking for New Englanders Against Sexual Exploitation. It's a group called NEASE. We meet monthly to share information across the borders of New England states. My roots are in Connecticut, but I've also been in this field working against sex trafficking for 20 years, beginning with USAID in Romania. So I really know this issue quite well. I also happened to work for Representative Reckitt a few decades ago when she was a vice president of National NAB. So it's sort of a full circle to come back and find myself enthusiastically supportive of her championship. This is a path-breaking bill. The most important thing I want to convey to you is this is landmark. Maine will be a leader of the nation in confronting a problem that every state knows it has. So while an earlier Pansy Watson mentioned, or I'm sorry, it was Lynn Nealon mentioned that a number of city jurisdictions from Seattle to Houston to Boston are flipping the paradigm. The pressure, the focus is going on the buyers. We do not want to criminalize victims. That's happening in jurisdictions, but it hasn't been happening at the state level. Here's why Maine is a really appropriate state to take this path-breaking decision. As Senator Seaway was asking questions about data, a problem in Maine is a problem in about half the states where you're combining solicitation of prostitution and prostitution offenses combine the act of selling and the act of buying. So it's very hard to discern from your data how many of the rest are related to mainly women and how many are related mainly to men. So this bill does separate out and treat differently two parts of the transaction. It's very important to do that. And the numbers are low. So I looked at data for Maine from 2013 to 2019, the most recent year available. Arrest data is no more than 120 cases of some bundle of both women selling and men buying. It's some combination we can't see. It's under 120 cases. That means you're really dealing with populations that can, you can hand these numbers. You could do a major American social experiment there in Maine and be champions of a fascinating flip, a paradigm switch. To address, I think Representative Plucker was asking questions to try, well, come on, it's consensual adults and some guys are just buying sex. Here's the problem. The men buying are driving all the abuse. And they never ask the question, do you have a pimp? Because they don't care if the woman has a pimp. Pimp control generally means 100% of any money made is going to the pimp. So be bold, be the leader of the nation, Maine. And Representative Reckitt, I love you.
Thank you, Ms. Gayton. Any questions? Seeing none, we love Lois too. Thank you for your testimony. Next up, we have Helen Taylor.
Hi there. Good morning, Madam Chair, representatives, honourable members of the committee. My name is Helen Taylor, and I'm the Director of Outreach and Intervention for an international anti-sex trafficking organisation, Exodus Cry. I've worked in this field in 10 different nations, so really come from an international perspective of seeing how prostitution and sex trafficking intertwined, and to lay before you my reasons for wholeheartedly supporting the bill LD 1592. This bill is supported by trafficking survivors and those of us who work directly with survivors. Why hold sex buyers accountable? It's been mentioned before, the nature of supply and demand. And when we look at sex trafficking, those fundamental dynamics have to be considered. Demand is what fuels sex trafficking. Without demand, there would be no supply. When we normalize sex buying, we increase sex trafficking. And the largest international study on this ever done observed 150 different countries, and it found where you remove the penalties for sex buyers, you normalize an increased demand, which increases sex trafficking. So this bill goes to the very root of sex trafficking. Secondly, sex buying is an act of violence that perpetrates a system of gender inequality. At any given time, a sex buyer can go to a website and select a menu of sex acts from an individual that he wishes to purchase for a period of time. Some websites list up to 90 different sex acts, including extreme acts of violence such as electrocution, sex acts involving bodily waste, multiple penetration, extreme acts of violence. This is a normal part of the sex buyer experience. I personally worked with one victim who refused to do a certain sex act with a buyer, and he pushed her from a 3-story window. This is a key part of our understanding in the post-Me Too world of understanding the power dynamic between a privileged person with money and a disposable income and a vulnerable and marginalized individual. As was mentioned before, Demand Abolition did an incredible report in 2017 with 8,000 buyers that listed the #1 deterrent for sex buyers buying was increased penalties, and this bill addresses that. So why should we decriminalize those in prostitution? Victims are more likely to freely report after other criminal acts, for example, theft and rape, and can come forward to law enforcement knowing that they are not at risk of arrest. A criminal record often prevents survivors from getting a job. I ran a weekly program in a county jail for 4 years and saw how challenging it was for survivors who have prostitution records as a criminal on their criminal record. And I fully support that this bill enables survivors to seal records. Those in the sex trade bear a much greater resemblance to victims of domestic violence than criminals. And so I very much appreciate the language of calling this commercial sexual exploitation. Just to conclude, the best policy for prostitution is one that promotes equality, freedom from exploitation, helps prevent sex trafficking by reducing the demand for commercial sex. And by introducing this law, you are stating that you support victims. I wholeheartedly commend Maine for being a progressive forerunner in the US for the cause for gender equality and justice. Thank you.
Thank you, Ms. Taylor. The first question is from Representative Pickett.
Yes, thank you, Madam Chair. Thank you, Ms. Taylor, for being here. Again, could you provide that testimony to us in the queue so that we can have it for the work session?
I shall. Thank you.
Thank you.
Any other questions for Ms. Taylor? Yes, Senator Searway.
Thank you, Madam Chair. I appreciate you coming, Ms. Taylor. What area or what I know you're kind of like internationally out there, and what area do you find does the best job for steering the person to get help? I guess that's the biggest issue I'm trying to figure out.
And my role and job is actually doing outreach with those in the sex industry and connecting them to services. Obviously, state by state, the number of services are very different, but women are in need of affordable housing, services, exit programs, further education, job opportunities, legal assistance, childcare, therapy. I've seen this law that we're looking at today was introduced 22 years ago in Sweden. 8 countries at present have adopted this law, and we really see it being most successful when there are those robust exit services and programs. I feel like that's another meeting for another time, but there are a lot of excellent services nationwide, and often it's in the interest of a trafficking survivor to leave the city or even leave the state where they were exploited. So you would be looking at services just not only within Maine, but beyond Maine for relocating survivors if that's in their interest.
Thank you, Ms. Taylor, for your testimony. Next up, we have Nicole Bell. Welcome.
Hi, good afternoon. Thank you to the members of the Judiciary Committee for hearing my testimony today. So my name is Nicole Bell, and I am a Massachusetts resident. I am also a survivor of prostitution and sex trafficking, and the founder and chief executive officer of Living in Freedom Together, a survivor-led organization that provides exit programs for survivors of the sex trade for both youth and adults. I am testifying today in support of LD 1592. Every day I see the devastating impacts of being bought and sold in the sex trade in both the work that I do and in my own personal life. The implementing of the equality model and continuing to patronize buyers and brothel keepers and traffickers and decriminalizing survivors is the right step forward. Survivors all over the country are advocating for this legislation, and we actually have similar legislation going through the Judiciary Committee in Massachusetts currently. It people view prostitution as a choice. I've heard a couple times that, like, you know, if this is consenting adults choosing to engage in it, but it is the most marginalized among us that end up being forced into prostitution to meet the wants of privileged white men who feel like it is their right to buy access to the bodies of vulnerable people. The sex trade is not something that people end up entering willingly. It goes with the least amount of choices that end up being brutalized in the sex trade. When we create legislation, we should be protecting those with the least social capital, including those in poverty, women and girls, predominantly of color, LGBTQ plus youth, and others experiencing vulnerability. And I believe this legislation does that. This legislation protects survivors' human rights over the buyer's wants. I've been working with prostituted people for over 7 years, and I see the harm, the substance use disorder, the complex PTSD, and the wreckage that prostitution has caused in the lives of the people we support and in my own. We've worked with over 400 prostituted people, and we do not see liberation and freedom. We see violence and devastation. Having to sell access to your body because you need food, shelter, or for survival, or because you're being trafficked is not an act of liberation, but an act of oppression. We believe there's an urgent need to end the arrest and incarceration of people who are exploited in the sex trade. But we do believe, and we firmly believe, that buyers need to be held accountable for the devastation they are causing. We agree prostituted people should be decriminalized, and that we should continue to penalize buyers. Over 60% of the survivors we support experienced sexual abuse, rapes, and beatings at the hands of sex buyers. This bill proposes to repeal criminal offenses for prostitution survivors, which is so incredibly important. We need these and vacate our record so that we can access housing, jobs, and employment. I appreciate taking the time to hear my testimony.
Thank you very much for your testimony. Any questions? Seeing none, thank you. Let's see if we have anyone else here to testify in support of LD 1592. Please raise your hand. Seeing none, I'll now go to testimony in opposition to LD 1592. Seeing no testimony in opposition to LD 1592, I'll now go to those wishing to testify neither for nor against LD 1592.
There's a couple hands up. I'll start bringing people over.
Thank you, Deb. First up, I see Catherine Wilson.
Good afternoon. Thank you. I appreciate this opportunity to be heard. It was interesting for me to listen to everyone talk about what people like me need. So I appreciate the opportunity to be heard. My name is Catherine Ann Wilson. I'm the founder of Stop Trafficking US. I live on Sebago Lake in Standish, Maine. I am a survivor of multiple sexual abuse. I lived on the street from 12 to 17 years old and was trafficked at 15 years old. I am against the legalization of prostitution, LD 1592, and here's why. Again, I was a runaway. I was groomed into sex trafficking at 15 years old. I was sold all over the state of Maine. I met many children, teens, adults who, like me, had been enslaved by others into this, into prostitution. In those years and in the years that I have been working with survivors across the state of Maine and elsewhere, I've only met a half dozen people who were trading sex for some sort of gain, who wasn't being prostituted through a third party being forced to do so. Based on my own personal experience, I believe that the legalization of prostitution would not eliminate sex trafficking. I understand that there's quite a bit of data in places like Nevada and Amsterdam, where they found where prostitution had been legalized for decades, sex trafficking was not eliminated, but in fact exasperated, and they had greater cases of sex trafficking there. In 2019, I was invited by the White House to come and speak to with a panel of leaders all over the United States talking about sex trafficking and what Senator Siri was asking about, what can we do to help? And it really is a multi-pronged approach in its healing. John's School, like the one they have in Kings County, Brooklyn, New York, has a 3% recidivism rate. So education is huge, having the high penalty for such. Expungement, that's a no-brainer. Of course, if someone committed a crime while they were being in slavery during that time, of course that should be expunged. I don't believe that the legalization of prostitution is the answer. And as everyone had said across the board, resources, 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 and I completely agree with that. Of course, resources, but we need to remember that the average age of entry into sex trafficking is between 12 to 14 years old. These are kids, and the vast majority of those people were sexually abused prior. So really having a strong child sexual abuse prevention program across our state is huge. John's School, huge. Support and resources for survivors, huge. Thank you so much for your time.
Thank you, Ms. Wilson. Thank you for being here. Any questions? Seeing none, thank you. Next up, I see Diane Clark. Welcome. Hi, Dee. Welcome.
Hi, good to see you all. I won't forget the formalities and thank the Senate Chair and the House Chair and the Standing Committee on Criminal Justice and Public Safety. My name's Dee Clark. I am a survivor of sex trafficking, sexploitation, and prostitution for 8 years. I'm also the Executive Director of Survivors Speak, which is an organization of all survivors leading the way to end sexploitation and trafficking. I have many concerns with repealing engaging in prostitution. Everything I know about today and yesterday's pimps or traffickers is what I am basing my concerns on, as well as all I know and continue to know with women caught up in the life of engaging in prostitution, regardless of why. But I will mention many survivors have boyfriends who are not considered traffickers, yet they benefit and are okay with her prostituting. Repealing engaging in prostitution will harm more than it will help. This is my opinion. These are my concerns, but I'm not opposing. Young girls are easily swayed by false promises of love and a better life. Women in relationship that are grounded in coercive controls will be reminded that they don't have to worry about being arrested for prostitution. And Maine will become a spot for traffickers. In the work that I do, it's amazing who we still know, including pimps. Survivors Speak USA supports changing solicitation of a child to engage in prostitution from a misdemeanor to a felony. Nice job. We also support increasing the penalty of engaging a prostitute from a Class E to a Class D. We just heard many testify about the horrendous acts that buyers portray to us. Maybe they should be penalized more. Survivors Speak USA hopes that there will be real comprehensive services that will support a survivor from discovery to recovery. That is what Survivors Speak USA tries to do when we meet survivors. We know the difficulty of assisting a survivor who have so many layers of needs, including mental health, physical health, including living with a PIC, and substance use disorders. At one point, this bill included services for survivors. Easier said than done. And I would love to be part of a work session that's figuring that out, because there are women that aren't accessing services, but people believe they're there.
Thank you, Ms. Clark.
Survivors Speak USA tried to bring vacatur to the table for survivors to have all their records, not just prostitution, vacated. It did not pass. Sealing of prostitution records is helpful. Committee members, please consider passing the bill excluding, decriminalizing, repealing, or engaging in prostitution. Representative Record and those who helped you create this bill, thank you for your efforts.
Thank you, Ms. Clark. Thank you for being here. And as I've said to others, as soon as we get a date for the work session, it will be sent out on our interested parties list. So we're going to look at the schedule tomorrow, so that information will go out. So thank you very much for being here. Any questions for Ms. Clark? Seeing none, I'm going to go to Rebecca Cleary. Welcome.
Hi, good afternoon. I'm Rebecca Cleary. I'm a staff attorney awaiting admission with Decriminalized Sex Work. We're a national organization pursuing ending the prohibition of consensual adult prostitution in the United States. And as an organization of experienced advocates, we know that the criminalization of sex work subjects the sellers of sex, who are often already marginalized people, to increased violence and an increased risk of exploitation. So in that sense, we of course support not criminalizing sex workers. It's the core of our mission. But I want to draw attention to the fact that this is a partial decriminalization bill. You've heard it referred to as the equality model. I don't refer to that. I think that's kind of a misnomer. It doesn't have much to do with equality. So I'll call it partial decrim. We're in support of total decriminalization, which decriminalizes both the sale and purchase of consensual adult sex work. And total decrim is not an extreme thing. We see it in other parts of the world, and it's also supported by some large international organizations who have studied total decriminalization, including Amnesty International, Human Rights Watch, there's others, and they found that total decrim is a necessary public health policy, and it's also actually one of the most effective approaches in ending trafficking, because we know that when sellers of sex are afraid of arrest, they're unlikely to report violence or exploitation to the police. Similarly, purchasers of sex who suspect that there's trafficking at hand are not going to report that if they're in fear of legal consequences themselves. And we know that criminalizing sex work between consenting adults doesn't end the demand for sex work. It doesn't improve the lives of people who participate in the sex trades by choice, by circumstance, or by coercion. And so we hope that Maine legislators are willing to take the next step in making the world safer for sex workers by totally, not partially, decriminalizing sex work and getting rid of this idea that everyone in the sex trade is a criminal, a victim, or both, and looking at the whole greater picture with more nuance. I also wanted to quickly talk about the expungement, or what might turn into a sealing provision. Almost every state in the country offers some form of post-conviction relief for trafficked people whose criminal records arose out of their trafficking experience. As far as I know, Maine is one of only 6 states without extensive criminal record relief for adult trafficking survivors. And so now is a really great moment to join the rest of the country in that, but I also think to lead the way in allowing for expungement regardless of the circumstances underlying the convictions. Prostitution convictions can bar access to housing, healthcare, immigration resources, and other avenues to security, well-being, and the ability to transition into other forms of employment for those who choose to do so. And criminal records resulting from exploitation serve as a painful reminder for survivors of trafficking of their experience, which can prevent them from rebuilding their lives, both practically and psychologically. I know I'm out of my time, but I just wanted to thank you for your time and consideration. And all people, especially those who are already targeted and marginalized, need to be able to work safely and live free of a burdensome and stigmatizing criminal record. Thank you.
Thank you, Ms. Cleary. Any questions? Seeing none, thank you for your testimony. Next up, I have Tiara Ross.
Good afternoon, Madam Chair and Joint Committee. My name is Tiara Ross. I live in Portland, Maine with my 10-year-old son. I'm a local business salon owner. I'm a survivor of sex trafficking for over 13 years. My son was in foster care due to my victimization and prostitution, and I'm a last girl. LD 1592, an act to decriminalize engaging in prostitution, strengthen laws against commercial sexual exploitation, in allowing persons convicted of engaging in prostitution and the petition courts to expunge the records of conviction. And for the most part, it is a good bill, and I support all but the decriminalization of engaging in prostitution. I do not support. I do agree that sex buyers and sex traffickers are the biggest predators to victims and should receive higher penalties for taking advantage of individuals. I also agree that victims of prostitution should not get their children taken away, but instead receive support and resources. We need our communities to thrive and our families to live successfully. From being a victim of prostitution, I'm opposing decriminalization in LD 1592. Pimps are so manipulative and they know how to blend in and stay out the way. For over a decade, my pimps usually sent me away to different states all the time to make money. And every morning I had a daily quota sent back to them via Visa cards, Green Dot cards, which are untraceable. I'm afraid if decriminalization and engaging in prostitution become legal, more victimization will happen in our communities. In Maine, there is already a lack of resources, and the resources do not trickle down to the last girl, Black, Brown, Indigenous, young girls, women, and trans, who are the most victimized, exploited people statistically, globally, nationally, and even here in this very white state of Maine. Where will we get more resources from? Decriminalization comes from a very privileged place, and it leaves out the last girl, victimizing her even more. Therefore, adding Bill LD 1455, the support of survivors of trafficking and sex trafficking and exploitation. This amendment will support survivors. There will be an opportunity through the courts to see, evaluate, and help if there's any abuse, needs or resources for individuals engaging in prostitution. Decriminalization will only bring more prostitution, victimization, abuse, and trafficking. Please do not decriminalize engaging in prostitution in the state of Maine. It would only cause more harm. Thank you so much.
Thank you, Tiara. Thanks for your testimony. Your first question comes from Representative Pickett.
Thank you, Madam Chair. Thank you, Ms. Ross, for being here. Again, could you please provide your testimony in writing to us so that we can have it for the work session?
Okay, thank you.
Thank you.
Any other questions? Seeing none, thank you very much.
Thank you.
Next up, I have Amanda Como.
Yes, ma'am.
Correct me if I didn't say that right.
That was perfect.
Okay, good.
My name is Amanda Como, and I am from Portland, Maine. I live here. I am a survivor of sexploitation, and my sex exploitation happened in Maine. This morning, unfortunately, I'm not unable to read my testimony because I'm sick, and I don't think anybody would be able to hear me. So I just wanted to let everybody know my testimony has been sent in.
Thank you very much, Ms. Como, and I hope that you feel better. Thank you for submitting testimony.
Thank you.
Next up, I have Henry Binks. Welcome.
Good morning. Thank you so much, Madam Chair. Thank you to the Criminal Justice and Public Safety Committee. My name is Henry Binks. I'm the co-founder and co-director of the Ishtar Collective. We're an anti-trafficking organization based out of Vermont. We're also a coalition member of the Erotic Laborers Alliance of New England. Before I begin, I wanted to flag a couple things. I heard in a lot of testimonies today, conversations where the rhetoric of buying and sell a person was used. I myself am a second generation sex worker. I'm a farmer. I'm an advocate. I work in food justice, and every bit of my adult laboring has been consensual. I feel like when we use statements like this, they become problematic because they erase the experiences of people like me and people that I work with. Now I'll begin. I'm here to express our partial support of LD 1592 and share perspective on this particular approach to the decriminalization of sex work. As an anti-trafficking organization, we advocate for sex workers and survivors of trafficking in Vermont and regionally to sex workers in New England, which includes Maine. As experienced advocates, we know that the criminalization of sex work subjects sellers of sex, often already marginalized people to increased violence and risk of exploitation. Sex work is a means of survival for many, yes, and sex workers want to work without fear of police. We want to be able to safely report violence and trafficking if it affects us or our peers. And as insiders of the sex industry, we are often the first line of defense against trafficking in the ways police and the criminal justice system are not. We can spot signs of exploitation or coercion that are subtle and easy to miss, but we cannot report that or intervene safely in a criminalized or fear-based, stigmatized environment. I testified behalf of my organization at both the chambers and the state, on both chambers at the State House of Vermont within the last month in favor of a Good Samaritan bill for sex workers and trafficking survivors. And it's being put on the governor's desk for signing as of today. This bill was designed to provide safe harbor for sex workers and clients to report if they are witness to or victim of a crime while they're engaged in prostitution with limited immunity. This may seem strange to include clients, but for those who view clients as inherently evil and bad, and as the sex industry is inherently exploitative, we would like to take a moment to shift your paradigm. Clients are not inherently evil. Not all clients are men, and some sex workers are also clients of sex workers. Well, our members of LO1 are sex workers and survivors. The other co-director of Ishtar Collective is a transgender sex worker and has been in a loving relationship with a former client for nearly 10 years. Now, I want to make it clear that this is not a pretty woman type story of a hooker and a John falling in love. They never actually saw each other professionally. They were instead just two people that happened to be in the same industry, one as a buyer and one as a seller at different times in their lives. The sex industry was one of the things they had in common, much like their love of music. Some of our LO1 members who are longtime sex workers are also themselves clients of sex workers at times. This bill would in effect say that on one day, while they are selling sex, our members are victims who need protection from criminal liability. And on the other day, when they are buyers, this bill would say they are villains that deserve to be arrested. To me, this is really bizarre logic. Every lawyer knows that sometimes—
I'm going to ask you to wrap up your testimony.
Absolutely. I'd like to wrap up with just a statement from one of my clients. I work for a lot of neurodivergent people in the state of Vermont, people living with autism and complex PTSD, trying to find means of healing in their sexuality. So what he had to say was that the Nordic model, which makes it legal to buy and sell sex, but makes it illegal, or makes it legal to sell sex, but illegal to buy it, does not cut it where decriminalization is concerned. If the goal is to destigmatize, then promoting the stereotype that sex workers and femmes are helpless is not removing stigma, it's changing it. After I was victimized at age 4, I became extremely wary of physical intimacy with any family or friends. I never learned the implicit languages of intimacy, languages that were difficult anyway with autism. Once I hit puberty, those languages, And I developed my sexuality. Intimacy became terrifying to me, and I'm always held back by this fear that I'm doing something wrong when I try to flirt or approach somebody. Sex work is healing work. It's social work. I've never bought full service because of the illegal markets requiring so much implicit communication. But I'm asking people today to stop criminalizing our humanity, stop criminalizing the efforts of hurt and disabled people to reclaim our humanity. Thank you so much. Sorry I went over time. I really appreciate you sharing the space. Thank you.
I really want to ask, did you submit that testimony so that we can, I know we missed some of it, so that we can read it?
Absolutely. Yep. Yeah.
Great. Okay.
And I'm open to any and all questions anybody might have.
Wonderful. Thank you. Any questions? Seeing none. Thank you very much for your testimony.
Thank you.
Madam Chair, that testimony is in the queue.
Oh, it is. Great. Thank you very much.
Thank you.
Thank you. Up next, I have Dusty Homans Sprague. Welcome.
Good afternoon, Representative Warren, Senator DeChambeau, and members of the committee. I hope for your belly's sake, I'm the last person in between you and your lunch. So I join you today on behalf of the Maine Women's Lobby. For over 40 years, we've advocated for policy which increases the health, wellness, safety, and economic security of Maine women and girls. Many of you also know me from my time at the Maine Coalition Against Sexual Assault with Elizabeth Ward Saxel, who you previously heard from. And you may know then that in my role there, I worked extensively on trafficking issues. This bill has several different parts. You've heard a lot about them today. We're in full support of Section A8, which creates a defense for people who promote prostitution only of their own selves. Section A11, which changes patronizing the prostitution of a minor to commercial sexual exploitation of a minor. I will just flag that there is already a sexual exploitation of minors chapter, which is 12, as no doubt you know. And also support the persons with mental disabilities language update. Also support A14, removing prostitution from the definition of children with special needs in the adoption section. With regard to the more substantive portions, I will be silent on the crime of engaging a prostitute and the renaming of that, but I would echo what Ms. Ward Saxel said, that moving it to the sexual assault chapter is can be problematic. But I also think that I would echo what some of the other folks here said in the neither for nor against section, that commercial sex is not inherently exploitation. I think that bears a longer conversation. And when survivors like Henry Binks come to us, or workers like Henry Binks come to us and say that they are engaged in consensual sexualized labor, that we need to listen to them. Regarding Part B, and that title change does not do that. Regarding Part B, I believe that I'd echo that the judiciary is tending to these comprehensively. And regarding the decriminalization of engaging in prostitution, we concur that trauma and violence in commercial sex are often connected. We concur that reducing the harm of criminal that the data is actually as clear as others have said, that decriminalizing only portions of the transaction and criminalizing other portions actually makes people safer. SESTA and FOSTA at the national level are problematic, and we do see that criminalizing just portions can increase the risk to sellers, which is the opposite of what we intend to do. So I see I'm at time. I'm happy to stop. I have very long written testimony and I apologize for it, but it needed to be said. And I am happy to answer your questions or to attend the work session.
Any questions? Thank you very much. And yes, we have Representative Pluker for you.
Thank you, Madam Chair.
I'm looking at your written testimony. Would you be willing to talk a little bit on you have those 3 bullet points at the very, or I guess it's in the middle of your testimony there, and you just mentioned Sesta Fosta. Could you just talk a little bit about that second bullet point and the third one?
Sure. It's always hard to figure out how much of the other stuff to cover up top. We hear from people who are engaged in the commercial sex trade that when the buyer is criminally liable, it can force the seller, and I'm going to reject the gender norms that I think a lot of folks have brought up. It is not necessarily that sellers are women. It is not necessarily that buyers are men. So I just want to flag that, but that we do hear from sellers that when their buyers are criminalized, their clients are criminalized, that they have to make more accommodations in order to protect those buyers. So they are less likely to be able to connect in more public spaces. They go to more isolated spaces. When those connections happen off the internet, they're less able to do like background checks or connect with their, with other workers to make sure that the buyers are safe. That protection of buyers in order to sort of protect their livelihood or their trade can just create a situation where they have to make more problematic choices. So I don't think it goes without saying that they want their clients criminalized, although as we've heard today, in some cases, they certainly do. This is a really complicated issue.
Thank you.
Thank you very much. And I'm sure you've heard me say it also. We will be announcing when the work session is. So thank you. Other questions for Ms. Homan Sprague? Seeing none, I have Jay Echevarria.
Hi, that's Janet Echeverria.
Thank you.
Hi.
Sorry.
That's okay. I'll just read my testimony. I have zero confidence in the justice system of colonizers. I am straddling the fence on this legislation as survivors deserve more than the opportunity to petition for expungement. Survivors deserve guaranteed expungement of these discriminatory criminalization practices. Trump-era Naziist immigration policies are reflective of US white nationalist policies pre-1930s. These immigration policies, inspired the Third Reich. These policies and laws target survivors, as well as Maine's Black immigrant communities and Indigenous nations of Wabanakik. And these are my personal demands. Although I am connected to a group, and I plugged my group's title into this, which is Demilitarization and Decolonization Now. We act as independent individuals in our group. So these demands are my personal statement, and I cannot speak on behalf of anybody else. Immediately halt anti-immigrant policies as they inflict further harm on immigrant survivors of gender-based violence. End courthouse detention of witnesses and victims by ICE. End the 287G agreements between ICE and local law enforcement agencies, allowing local law enforcement to enforce immigration law. Eliminate penalties in grant programs for communities that have strong sanctuary policies. Increase access to U visas and T visas. Train police and prosecutors in providing U visa and T visa certifications, restore asylum eligibility for survivors of gender-based violence, strengthen enforcement of the Prison Rape Elimination Act through investigation, and where the evidence is sufficient, prosecute sexual predators within Custom and Border Patrol and Immigration and Custom Enforcement. Increase screening to prevent hiring and the retention of sexual predators within CPB and ICE. Empower Native and First Nation survivors of sexual violence by lifting the restrictions on tribal authority to prosecute all sexual assault, trafficking, and stalking crimes against Native people by non-natives in Indian country, with the intention to spread this movement across Wabanakik and Turtle Island as a whole. Ensure Native women are protected by the federal government adequately, carrying out this unique jurisdictional responsibility to prosecute crimes committed in Indian country. Disproportionately affects survivors, as well as Black immigrant and Wabanaki communities. In all aspects of Maine law, I did consult Nations, Micmac, Wasatch, Passamaquoddy, as well as our powerful and present immigrant communities, including, but not limited to, the nations Danka, Nuer, Acholi, Zande, Somali, Guatemalan, Haitian, and many more to come.
Thank you very much for your testimony. Do we have any questions? Seeing none, thank you. Any others here to testify in opposition to LD 1592? I'm seeing no more hands raised. Anyone here to testify neither for nor against LD 1592? I'm seeing no hands to testify neither for nor against. Therefore, I will close the public hearing on LD 1592. Thank you, Representative Reckitt. And I will turn to Representative Pickett.
Yes, thank you, Madam Chair. After that, I think I need some lunch, so maybe we ought to take a break.
I think it's time for a lunch break. So it's 1:20. What do we need? 30 minutes?
Why don't we, it's going to be a long afternoon anyways. Why don't we make it at least, yeah, we ought to be able to be back in half an hour. It's okay.
Okay. You want to come back at 10 of, everyone? Thank you. All right, I see we have Representative McDonald here for our next bill.
Hello, everyone.
Hello, hello. How are you?
I'm good. How are you? I'm going to
Great.
switch gears to a completely different topic for you now. Are you ready?
We're waiting. Let me get a few more people coming back from lunch. I was just saying hello. I was just scanning the trying to get some information of what was released in the governor's budget.
Oh, same. Yeah, I just saw that come in.
I do notice that it's the second budget announcement we've had in the last few weeks where money for treatment is not even referenced. So it's a little bit frustrating. It's actually a lot frustrating. While 11 Mainers die a week of overdose. Not even a mention.
Charlotte?
Yeah.
Can you remind me which bills we actually did this morning? Because I was a little tuned out because I was.
I'm
concerned.
happy to. We completed 1422, 1486, and 1592.
I knew about the 1592.
Yes, of course.
Oh, I don't see them.
And we're going to 1505.
So we're going to do 5 more bills or 6 more bills today? Or like-
Yep, 6 more.
Okay.
But I'll have to tell you about that later.
I tell you, I have had more mail on 1473 than anything since some faraway gun bill.
I know, me too. I've gotten a ton.
If we have a minute, we have a.
Yeah, Jane.
We have a minute. Representative Reckitt, your testimony with the attached side-by-side is really wonderful. But when I print it, in the side-by-side, all of the edits, all the strikes throughs and underlines are missing. Can you check it on your end?
Yeah, yeah.
And we can figure out why that happened, because the side-by-side is a very, very helpful document.
Well, yeah, I thought it would make your life easier. But actually what we should do is ask Nate, who's the one that did it. I mean, it was his work that put that together. And I asked him when I was closing it whether he wanted me to give him attribution for it. And he said, no, that was okay. He didn't care. And but I'll see if my original has those kind of markings on it. Maybe we can do it as a thing.
Could you check with them, because having it with the markings it's not very useful without the markings, and It's a great document.
Okay.
Thank you.
I'll talk to him, and I may have the original somewhere in my stuff too. I'll check.
Okay, it's obviously a computer problem.
Yeah.
Okay. Welcome back, everyone. And we have Representative McDonald with us. So we are going to start with LD 1605, an act to license ambulance drivers who are not licensed to provide emergency medical services. Welcome, Representative.
Thank you. And thank you for having me back. Senator DeChambeau, Representative Warren, and distinguished members of the Joint Standing Committee on Criminal Justice and Public Safety. I'm Representative Genevieve McDonald of House District 134, and I'm testifying before you today as the sponsor of LD 1605, an act to license ambulance drivers who are not licensed to provide emergency medical services. Ambulance drivers carry out life-saving duties by assuring that patients arrive swiftly and safely to a medical treatment center in the event of an emergency. They place themselves in harm's way, arriving at the scene of car accidents, fires, domestic violence disputes, and a multitude of other emergency situations. In addition to driving, ambulance operators often assist with moving and lifting patients. While not trained as emergency medical technicians, ambulance drivers are emergency medical service personnel. Yet Maine law remains ambiguous, both in quantifying non-EMT ambulance drivers and in granting them the same protections and privileges as their EMT counterparts. A licensing system for non-EMT ambulance drivers would create a mechanism to quantify drivers so that we know how many operators there are. It would also create a pathway by which we can explicitly include non-EMT ambulance drivers in legal language, such as defines eligibility for EMS death benefits. Thank you for your time and consideration, and I'm happy to answer any questions.
Thank you, Representative. Any questions for Representative McDonald? Seeing none, thank you. Are there any sponsors or legislators here to testify on LD 1605? Seeing none, I'll now take testimony in support of LD 1605. Seeing none, I'll now take testimony in opposition to LD 1605. Seeing none, anyone here to testify neither for nor against LD 1605? Thank you.
Excuse me. I'm bringing over J. Sam Hurley.
Thank you. Good afternoon, Director Hurley. It's good to see you. You are muted.
One day I will figure out how to operate Zoom. One day.
Welcome.
Thank you so much for having me. Senator DeChambeau, Representative Warren, and honorable members of the Joint Standing Committee on Criminal Justice and Public Safety. My name is Sam Hurley, and I'm the Director of Maine Emergency Medical Services, or Maine EMS, within the Department of Public Safety. I am testifying on behalf of Maine Department of Public Safety as well as Maine EMS, neither for nor against LD 1605. The ongoing COVID-19 pandemic has made the issue of non-licensed ambulance operators quite apparent within our overall system. These individuals serve a critical role for many agencies that use them as part of their response system, where they have one licensed EMS clinician on board and a driver. Last year, Maine EMS developed an automated notification system that alerted every licensed EMS clinician documented on call for an exposure to a patient that was later found to be suffering from COVID-19 disease. We quickly found that non-licensed operators, these drivers, were not being notified because they were not traditionally included in our documentation system. In the interim, we were able to amend this issue and ensure that all persons on these calls that were connected to the EMS system were able to be contacted through this mechanism, but it highlighted the reality that we really don't know the expansiveness of EMS operators. This once again became apparent at the time of initial vaccine rollout. There was no way to understand whether someone was a frontline healthcare worker that drove the ambulance one time every 2 years, or someone who was employed by an agency as a driver within our system and drove every day. For that reason, it was impossible for us to establish who was eligible for vaccination and who was not, as the vaccine was extremely scarce at that time. This legislation would serve to ensure that issues like this do not arise again in the future, because we would have real-time information about who is and is not authorized as an ambulance operator in the state of Maine. We also have concerns about the requirement in Section 3, Paragraph 1, that there is consultation with the Emergency Communication Bureau within the PUC, as there is no other licensed EMS professional that requires such consultation, including emergency medical dispatchers. The PUC only has authority over dispatching systems. Maine EMS retains regulatory authority over emergency medical dispatch centers and dispatchers. Additionally, we would recommend removing everything in paragraph 4 after the first sentence. This license type does not relate to the Emergency Communications Bureau nor the Public Utilities Commissions, and so the board should not be restricted by having to consult with them before taking action as needed. We appreciate your time and consideration, and I'm more than happy to answer any questions that you may have at this time, but please feel free to reach out to me anytime if there is any additional information that I call for you and or the committee. Thank you.
Thank you very much, Director Hurley. And your first question is going to come from Representative Newman.
Thank you, Madam Chair. Mr. Hurley, how would this affect, and I'm not sure if it will affect it, being on the Belgrade Fire Department, every once in a while, when we have Delta respond out there, you'll end up with a situation where both paramedics end up in the back of the ambulance and they'll grab a firefighter and say, you're driving this ambulance to the hospital because we've got to go. So I'm just wondering how this affects things like that.
Yeah, the bill was written very well in that context, and the fact that it excludes those persons that are needed in an emergent situation like that. This only applies to persons who are specifically hired by agencies to function as drivers, where that is their sole role.
All right, thank you.
Any other questions for Director Hurley? Seeing none, thank you, Director. Anyone else here to testify neither for nor against LD 1605? Seeing none, I'll close the public hearing on LD 1605. Thank you.
Thank you.
Senator DeChambeau, you are up to take over for LD 1607, and I see that we have the sponsor here.
Yes, the next one is, yes, 1607, and that is Representative Tepler. Hi there, Representative Tepler. Her bill is an act to criminalize calls made to emergency services based on racial profiling. Again, welcome, and you can give us your testimony.
Thank you, Senator DeChambeau and Representative Warren and esteemed members of the Criminal Justice and Public Safety Committee. I am Denise Tepler. I represent House District number 54, which is all of the sweet town of Topsom. And I'm pleased to present to you today LD 1607, an act to criminalize calls made to emergency services based on racial profiling. I put in this bill when I heard the news of the woman in New York who harassed an African-American bird watcher by calling 911 to falsely report him for threatening behavior. I thought of my sons, both of whom are Black. One of them had the unfortunate experience of being videotaped by a neighbor in the next neighborhood over for nothing more than riding his bike around. California, Oregon, New Jersey, and the cities of Grand Rapids, Michigan, and San Francisco, California are all either considering or have passed similar legislation to this. I have no interest in creating a new crime. This bill was initially conceived as a fine. This is the version that was able to be developed based on other states' bills from the revisor's office. I am open to the committee's consideration of changes to the bill, including just eliminating the parts of it that create a criminal action. This kind of behavior is, however, already punishable by law for other types of false reports. This bill just specifies the type of false reporting based on racial profiling. And I understand that that may be difficult to prove. However, I am concerned that we have folks in the state who simply don't understand that this is not appropriate behavior. I believe it is important in making our state a welcoming place for all kinds of Mainers, that we acknowledge that using a person's race as a reason to view them suspiciously or not as belonging is wrong behavior. And using it as a reason to report them to the police is similar to pulling the fire alarm when nothing is burning. Thank you for your time, and I will attempt to answer any questions that you have.
Thank you, Representative Tepler. I like that last sentence. Anyways, anyone have any questions for Representative Tepler on this bill? No clarification or anything? That's fine. All right. I will ask if there's anyone any legislators who are here and wish to testify on this bill. Seeing none, I will now ask for individuals to raise their hand if they are here to testify in support of LD, I got it, 1607.
Seeing no hands, Senator.
Thank you. Anyone in opposition of 1607?
I'm bringing over 2 people.
Thank you. Welcome, Attorney Cabetta. You are up.
Thank you, Senator DeChambeau, Representative Warren, and distinguished members of the committee. Good afternoon. My name is Michael Cabetta, and I'm Policy Counsel for the American Civil Liberties Union of Maine, a statewide organization committed to advancing and preserving civil liberties guaranteed by the Maine and U.S. constitutions. On behalf of our members, we urge the committee to reject Section 2 of this bill, which it sounds like the sponsor of the bill is being voted against. Our reasons for advising that you reject this section of the bill are that creating a new crime will not keep marginalized people safer. In fact, people who harm because of hate do not learn their lesson in prison, and instead they often double down on these views. There are other forms of dispute resolution that are better suited to this very serious problem. We urge you to learn about and to fund and support transformative and restorative justice practices and programs in Maine, and to remember that Christian Cooper himself, the person on whom Amy Cooper called the police in Central Park, declined to cooperate with prosecutors. He declined to press charges against Amy Cooper. I urge the committee to follow his lead and think outside the criminal legal system. And we urge you to vote that only Section 2 of this bill ought not to pass. Thank you, and I'm happy to try to answer questions.
Thank you, Mr. Cabetta. Any questions of Mr. Cabetta? Let me ask you, Mr. Cabetta, do you know if there's any other state that has anything close to this?
Yeah, I think Representative Tepler mentioned a couple of states that have laws that criminalize calling 911 based on some bias. Yeah.
Okay. Any questions for Mr. Cabetta? Seeing none, thank you.
Thank you.
I will ask if there's anyone else that wishes to testify in opposition.
Bill Ross is in the room.
Excuse me, Deb, I didn't hear you.
William Ross is in the room.
Okay, thank you.
Good afternoon, everyone. My name is
Good afternoon, Mr. Ross.
Good afternoon. My name is Major William Ross. I'm here to represent the Department of Public Safety and the Maine State Police to testify against LD 1607, an act to criminalize calls made to emergency services based on racial profiling. The state of Maine has no specific hate crime or racial profiling statute, but an established process to address these issues is in place. Adding the racial profiling or biased language to the statute or other similar statute would present significant challenges for law enforcement and negatively impact successful prosecution. All crimes are investigated by law enforcement, and when enough evidence or probable cause of the crime has been determined, enforcement of that statute takes place. Law enforcement during their investigation will have gathered evidence, conducted interviews, and documented these findings in a report before the case is submitted to the prosecuting authority. The racial profile or bias aspect of the proposed bill would put the burden on law enforcement to not only provide evidence of the elements of the existing crime, i.e. false public alarm or report, but to determine the motivation behind the offender's actions. This nuance makes enforcement considerably more difficult, as uncovering an individual's motivation for committing a crime isn't captured as easily or clearly. Law enforcement investigations with subsequent enforcement must provide how the crime was committed, but doesn't necessarily need to establish why the crime was committed. This bill, if enacted, would make the offender's motivation part of the elements of the crime and considered for a law enforcement officer's determination of probable cause. It will also need to be proven beyond a reasonable doubt for successful prosecution. The racial profiling or bias aspect of any criminal act is presently and most effectively handled by the prosecuting authority through the Maine Criminal Code by either the Attorney General's office or the respective district attorney's office under existing sentencing provisions. The section by the person of the victim or the property that was damaged or otherwise affected by the crime because of the race, color, religion, sex, ancestry, national origin, physical or mental disability, sexual orientation, homelessness of the victim or the owner or occupant of that property is what is in statute. In addition, law enforcement agencies can make referrals to the Attorney General's office where these types of incidents can be addressed through the Maine Civil Rights Act. The racial profiling or hate crime aspect of any crime is already addressed universally through existing law, which would avoid adding this kind of language to this specific statute. The proposed legislation also creates a private right of action in small claims court with damages up to $250 for race-based false public alarm or report. The existing sentencing provisions would address this concern more efficiently. For these reasons, I strongly urge the committee vote ought not to pass on this bill. On behalf of the Department of Public Safety and the Maine State Police, I thank you for your time. We'll be happy to answer questions. And I'm sorry I forgot the part about Senator DeChambeau, Representative Warren, and distinguished members of the Joint Standing Committee. I jumped a paragraph on you. My apologies, but I'll answer questions at this time.
We will not forgive you for that. Okay, kiddingly. Any questions for Mr. Ross? Mr. Ross, in reading again the bill and hearing you, now I'm reading it a little differently. I've not known of the term race-based profiling, but let's say we're familiar, a lot of us, with hate crimes. In my own community, an assault was risen to the federal level because as they were assaulting the individual, they called them a bunch of racist names, and it was obvious that was the intent of the assault. So that was viewed as a, quote, hate crime. Race-based is pretty much the way I read this. Well, let me ask you how that would work in calling 911 and reporting something that would be viewed as race-based profiling. Does it have to be what the person is saying when they're describing the incident?
I think they're two very similar, if not the same thing. A hate crime or a crime that's committed where part of the motivation is race-based or some of the other identifiers that I had mentioned earlier. And that case in Biddeford, I think, is a really good example on how the current system works well. And that ended with some pretty significant federal sentences. One was a 5-year and the other was a 10-year for an unprovoked assault on a Black male in Biddeford that they were able to determine was racially motivated. And again, that went federal through the Federal Civil Rights Act. And if we had to prosecute that in Maine as an assault with, say, some of this hate crime language built into the law, we would have problems with getting beyond a reasonable doubt, that burden of proof, because you'd be asking the investigators and the prosecutors to get into that individual's head to kind of pull out that motivation. The process we have in place really works well, and the spirit of this law is, I think, right on target. I think the best way to go about it would be very similar to I think LD 491, which was Senator Melmont's bill regarding false public alarm as a hate crime. I testified very similar to what I did today in that bill. And, perhaps there's a way to bring those together, because I think what we're trying to achieve here is hold people accountable for these types of actions. But it's a not so well-known process, but there is a pretty good process in place that we feel, certainly as investigators, and I know other prosecutors have voiced their opinion that this is probably the more appropriate avenue to take when we have a hate crime or racially motivated type incidents.
Thank you. Any questions of Mr. Ross? Seeing no hands raised, thank you. I will now ask if there's still anyone else that wishes to testify. We are in the opposition.
Seeing no hands.
Thank you. Anyone wishing to provide testimony neither for nor against?
Again, seeing no hands.
Thank you. Therefore, seeing no other or raised of hands for questions, I would view that we will close the public hearing on LD 1607. I don't believe we have a list yet of when we will have a work session, but you can well imagine, Representative Tepler, it'll be soon. Do you have it, Ms. Overton? You
No.
don't? Okay. We're meeting tomorrow. You'll probably find out tomorrow evening. So thank you very much. And thank you, Mr. Ross.
Thank you to the committee, yes.
I have the next two coming up. 8:47. I will probably read a couple of them for anybody who's listening. We're going to be doing 8:47 and then 12:98. And then Representative Warren will do 1585 and 1473. So those are the last four. So now we're on 8:47, an act to divert older youth from the adult criminal justice system, and that is Representative Morales. And she initially was a concept draft, but we have since received an amendment. Yes, Representative Morales.
Thank you very much. You should have all received the bill in your email, and I believe it is posted on the website. And I wanted to let you all know that I've been working with District Attorney Sarbeck on this particular policy, and he's going to try to make it here today, but if he can't, he's available for the work session. He's in a training. Senator DeChambeau, Representative Warren, my friends on what I believe is the best committee in the State House. My name is Victoria Morales, and I represent House District 33 in South Portland. And it is my distinct honor to present this policy to you today, which you all know aligns with my work with young people in Maine. We know today that adolescence spans from ages 14 to 25 and is an important developmental period, much like early childhood, when the brain is especially open to learning and growing. It's a time ripe for building young people's capabilities, a time when they can heal from traumatic experiences earlier in life, and if necessary, they can change course. It's a time when young people are establishing their identity and relationships and developing important life skills, such as making decisions and assuming responsibility. It's also a time when young people make mistakes, sometimes serious mistakes, but it's also a time for them to learn from those mistakes. And importantly, it is a time when they need supportive adults and the right developmental experiences to foster their growth. In Maine, there are approximately 15,000 young people between the ages of 16 and 24 who are not in school and not working. This number has alarmed me, and I can't help but think that it may be related to the 1,600 juvenile justice cases filed each year, and the between 5,000 and 10,000 young adult cases filed each year. The Maine judicial branch provided me with the following data for the 18 to 25-year-old age group to assist me with drafting this bill. Around a quarter of criminal cases filed involved a defendant in the target age group in 2020, and the target age group being 18 to 25. 76% of those cases filed were misdemeanors. 49% of the cases filed were Class E crimes. 27% of those cases were Class D. In 73% of cases where the defendant was aged 18 to 25, the defendant was male. And in 27% of those cases, the defendant was female. 8.6% of cases involved a Black defendant. I've provided, and I will send you all my testimony, but there is a chart from the data that the Maine Judicial Branch provided me that shows you this data. What we know about young people is that they need resources in 5 key areas to develop comprehensive solutions that address the multifaceted issues young people contend with and that enable them to thrive. Their basic needs. Young people regularly say they need immediate support to meet their basic needs: food, housing, safety, physical and mental health, transportation, and childcare, so that they can focus on long-term goals and become self-sufficient. Permanent connections. Young people deserve to have stable, permanent connections with a loving family and other supportive and caring relationships with adults in their community who can help them navigate school, work, finances, and life issues. Education and credentials. Young people should have the support they need to graduate from high school and obtain a post-secondary credential that will position them for economic success. Financial stability. Young people need access to traditional or entrepreneurial employment and financial tools and products that allow them to build savings and credit. And youth leadership. Young people can develop skills to advocate for themselves, promote policies that will help them and their families succeed, and play a leadership role in making their community stronger and safer over the long term. Too often, this is very difficult for some young people. The road to adulthood can be challenging, but young people of color, young people in low-income families, youth in high poverty communities, young parents and youth involved in the child welfare system or the juvenile justice system face significant obstacles that can stall their aspirations and prospects or derail them entirely. The policy I'm proposing here today, and I'll explain it to you, will help to keep our young people out of the criminal justice system and connect them more to their communities through diversion and community supports. Young people, as I know you all believe, are our next generation of leaders, workers, innovators, and parents. In Maine, they make up 20% of our population, and ensuring that they can thrive by 25, which is a goal of the Annie E. Casey Foundation as well. That will benefit their lives and strengthen Maine communities. So just to go through the bill, which you should all have in your email, what is proposed here is that for those young people who law enforcement find have committed a Class E crime for the first time, that they would not be issued a summons or an arrest for a Class E, the lowest level of a misdemeanor. That's the first piece of this bill. The second piece of this bill is that for young people who have committed an offense of a Class E, C, or D crime, and E would be their second or any further offenses, E, C, or D crime, that a law enforcement officer or a prosecutor or the court will take a look at whether diversion is an appropriate option for this young person before they issue a final decision on whether charging or conviction of the young person. The final piece of it is some data collection, just so we know how it's working. But essentially, it is those two pieces, which is one, that for a Class E crime first offense, law enforcement will not issue a summons or arrest. And then for the second piece, if it's a crime that's a Class E, D, or C, then diversion would be explored before issuing any other final criminal actions. So thank you so much for the ability to present this to you, and I'd be happy to take any questions.
Any questions for Representative Morales? And I see Senator Seaway.
Thank you, Madam Chair. Thank you for bringing this forward, Representative Morales. I was wondering, I used to do a thumbs up program for juveniles. It was for 13 to 17-year-olds. For 13 years I did it. It was on a weekend program. And the officers would give a choice if they would get summoned. And what would happen is the courts would say this would be ripped up. There'd be no charge if you go to thumbs up program. So it would be a choice, and it worked very well. So I understand what you're trying to do. And I think if there was a program or something that they had a choice to, even on the first offense, that would be something I'd be really interested in, if you could work on something like that.
Yeah, thank you for that question, Senator. Every community is different. And so when we were crafting this bill, we wanted to make sure that each community could use this policy in the way that their community had those kinds of diversions. So it may, as you probably, and we all know, some diversion programs don't exist in certain communities. And so if they don't exist, then that particular prosecutor may not be able to use diversion, right? If they do exist, then they would be able to use that. But what we've looked at when we looked at that data, and I'll provide that to you for the, so that you have that in your records, is it's pretty alarming, and I think in a good way, the number of young people who are committing the lowest level offenses. And that's a pretty high number. 49% of the cases filed for this age group are Class E. So, what we know from, at least I know from the juvenile side and working in diversion, that sometimes for the very lowest level, the lightest touch of the criminal justice system is all that's needed, so that we don't have that net widening impact of just providing too much for folks, when really all they needed was that warning from that police officer that, hey, we caught you doing this, don't do it again. And what we know from brain science as well is that sometimes that is often enough.
Any other questions for Representative Morales? Representative Morales, I find that interesting, and I would like to hear from law enforcement officers. If they come across a young person at that age, let's say, the officer on the beat, so the law enforcement officer shall determine first if there should be a diversion. And that's what I need to know more from a law enforcement officer, if that in fact has that authority, or if it would require, if this bill passed, it seems to me it would require training of that. I don't know of any officers on the beat that feel that they have that leeway, but they would if this bill passed. Yeah, it was interesting that Senator Seaway mentioned thumbs up. I remember the Jump Start program too. So I guess leaving it at that, I just want to know the procedures one after another, because even if the law enforcement officer did not think of diversion, the prosecutor could, the way I read this. And even if both the law enforcement and the prosecutor did not, the court could determine a diversion. Is that correct?
That is right. So kind of creating off-ramps for this young person at every level of the system. And, I just point, because I've been working with diversion for juveniles for 15 years and working with law enforcement. And in fact, law enforcement officers do divert cases often. And whether they divert to a program, again, we're talking about Maine, we're talking about where we do have program deserts in our state, or whether they divert by simply not filing a charge, that does happen quite a bit. And so law enforcement has that discretion now. this is just putting that into policy as well, that for first-time offenses, we don't want them for this lowest level. We want it really to be a warning and a contact with that law enforcement officer, issuing them that warning, but not filing that charge. Again, we're only talking about the lowest level. Thank you.
Okay. Senator Seaway.
Thank you, Madam Chair. One thing I found out though, Representative Morales, is that a lot of these times you catch them the first time, it's not their first time they're doing it. And if you don't have something other than just a warning, in some cases, it's not going to work. So I agree with you on the diversion or a choice. I don't know if I am to the point where I could just do a warning if and with no consequence. If there's, so I just think if we could do something where you open the door for communities or areas to come up with some type of diversion program. And I know that thumbs up money we got from the juvenile probation money, it was the JEPTA program. And we got grant money, like $113,000. And I think there is money out there that for each area, and they could probably do something like that.
That's
what's
more
your thoughts?
right.
Yeah.
Question. You're making a comment, right, Senator?
Yeah, I did. I kind of a comment, but also if that's something to think about for the work session, I guess.
Yes, and I'm absolutely willing to talk about it. The idea is that for class Ds, for second class Es, for class Bs, Cs, those are the cases where we have the diversion built in. And again, in an ideal world, we'd have money for diversion everywhere. We just simply don't have it yet. I'm hoping that we build that up. That's needed. But for those who are committing the first time, the lowest level, what we know is that the lightest touch is often all that they need to never, ever touch this system again. And so we don't want to do too much and put too much resources where they're actually not needed and that a very light touch is needed. But certainly willing to work with you on that and hearing from the district attorney and the other experts who will come after me, maybe that will help with this question.
And on that comment you just said, I think a lot of law enforcement officers will do that already because they can use discretion, just so you know. So they do give little warnings. So yeah, thank you.
Okay, I also have Representative Pickett.
Yes, thank you, Madam Chair. Thank you, Representative Morales. I'm kind of trying to go over here. Let me just preface my question with this. When I was patrolling and I stopped somebody for speeding, and I would go back to my car and run a check on them, found out they had a clean record, that had to play in making my decision on whether or not I was going to give them a warning or a summons.
Right.
If I gave them a warning, then the next person that stopped them 3 days later when they were speeding to work, who used my same philosophy, would have said, oh, no record, so I'll give them a warning. No record, so I'll give. And I say that to say this. If we're going to do that on that Class E crime the first time and use it as a warning, the record keeping is going to have to be so that the officer somehow can get that information right then when it's happening, or they're going to have no choice other than to put that charge in as a Class E until they have that information, because there's going to be no way at all for them to know whether it's the person's first. It might be their 10th, if under that same scenario I was talking about speeding. Just something to think about on how to piece that together.
Yeah, and that's a great point, and certainly something that DA Sarbeck and I have talked about quite a bit, and some of the other folks who will come after me. And that's something that I think, using your expertise, Representative, on how we can craft this, that would be very helpful. Thank you.
Thank you.
Seeing no hands raised for any more question for Representative Morales, I would now ask if there are any legislators in the audience who wish to testify in support. Also, I would welcome anyone who wishes to speak in support of LD 847. Please raise your hand.
I'm bringing 3 people over.
I am looking at all police officer Westbrook. What is that? Your name, please?
I have no idea. My name's Ali. I don't know who edited that. I'm not a police officer.
Ali?
Yeah.
Okay, you're from Westbrook, I would assume?
No, I'm actually from
Oh.
Portland too. So that's really
Oh
odd.
my God. Okay, could you please give us your testimony and maybe we'll get your whole name? Thank you.
Yes. Representative Warren, Senator DeChambeau, and members of the Joint Standing Committee on Criminal Justice Public Safety. My name is Abdul Ali. I am from Portland. Today, I'm representing a few different positions, one with Maine Youth Justice, one myself. So I'm going to give you a little background on what I do for work right now. I work with Maine Youth Justice. I also work with the University of Southern Maine as a policy analyst. I also work with YPC, Young People's Caucus, and different organizations. I launched a initiative named Reversing Structural Racism in Maine. But my history, even prior to that, is I used to be previously incarcerated in the juvenile facility for about 18 months. And the point with this bill that kind of connects to me the most is because that level of diversion, how important it was, and how important it would have been for me back then, and would have supported me to get to where I am now, because the disadvantages that I had to go through for the first 3 years after being released, of trying to find a job, trying to get a home, because of the criminal record that I had, that if I would have been diverted in the first place, like even going to the university I go to right now, I have a 3.8 GPA. It took me 2 years to even get accepted to that school, and knowing a lot of the people that I have been incarcerated with and whatnot, a lot of them didn't make it. A lot of them didn't make it even in life, and passed away because of a lot of the issues of having to not only try to succeed in life coming from difficult family members and background, but also trying to reach wherever you're going to reach. Right now, the police training that Sarbeck is at right now was actually the same police training that I came from, where Sasuchuk actually invited me to, and it was great. And we have a diversion program over here, which I am an advisor on over here in Portland. We have where Class E and Class D misdemeanors are getting diverted to this program where they do what do you call it? It's not transformative, but restorative justice. And if they do the program well, they get cleaned off completely. And what I would say is, like, I do understand the perspective that where Representative Pickett was speaking on how it would help police officers determine, if this person was kept doing it on a constant basis. But a lot of the disadvantages that really does happen for an individual is, like, having to deal with, because I had to go through therapy for over 2 years just to get myself out of the mindset of being confined in such a space. But the difficulties that it really carries throughout your college career, you pursuing anything, or you trying to ever get anywhere. If I had that diversion of the opportunity to have the diversion in a really early state, I think that I would even been farther right now. And not only me, but a lot of my constituents and people that I know my time is up, that I work with right now, and people that have been incarcerated that didn't make it the way as far as I made it. So that's why I'm in support.
Thank you. I wrote your name down here. Yes, Abdul Ali. Any questions for Mr. Ali? Representative Pickett?
Yes, Madam Chair, thank you. Mr. Abdul, I just wanted to tell you, I'm very, very happy for you that you've got to where you are. You keep up the good work. You're doing a great job, and sounds like you're really advocating for people and trying to help them. So keep up the good work. Congratulations.
Thank you, Mr. Pickett.
I would echo that, Mr. Abdul, but I'm interested, having been in the system as a worker. How old were you at Long Creek, and how long ago was that?
The first time I actually had a Class E, I was 15 years old, and I went in just for a few days, and that made me like, while I was like waiting for probation. That's when it got me into the fear of just ever being incarcerated. And then at 16, I went back in, and when I went in again, mostly because I was houseless and I had to, pretty much survive to get to where I needed to be. Then I was incarcerated for 18 months. And that's when I started the programs inside and started to realize a lot of the disadvantages that I had, and then continued it when I got out. I used to be with Maine Inside Out, but now with other organizations. So I was, when I first time of such the system, when I was 15 years old.
15? Okay. And you are how old now, if I may ask?
I'm 25 now.
So, okay, 10 years ago. No, I am in full support of what I'm reading as the bill and the amendment. And I just wanted to put things in perspective. 10
Right.
years ago, we didn't think the way we're thinking now. So it may have helped you, motivated you somehow that this is not the way you're going to spend your life, and you're not at the Maine Correctional Center. And 3.8 is impressive. I didn't get that till my junior year. So good luck to you. Good luck to you.
Thank you.
I have a question from Senator Seaway.
Yes, thank you, Madam Chair, and also thank you, Abdul, for coming. So you feel, and I just wanted to clarify that you feel first thing you should have had possibly a choice to get some type of diversion program, and that would have helped you tremendously. Is that what I understood?
Well, the reason why I say that is because the opportunities that I have now, like, so now that I have my own place, and for example, like, in higher education, that's helping me. If I getting a bachelor's degree, 6% recidivism rate, a master's degree is 1%. I'm hopefully going for my doctor's after. But the reason why I say that is because, if I didn't have, having these other opportunities, having these other leeways, I was blind to it. I didn't know this could exist. You know what I mean? So if you have the other options and diversion that could take you to these other options, then yes, you're going to go far. But if you don't have that, you're just going to, consistently do what you're accustomed to doing, especially when it's surrounded around you, because you think it's right until you start to see other options and other leeways. And now that I'm working with other youth to kind of, pull them to these other opportunities. But yeah, I think if I had that, it would have been great for me.
Thank you.
I see no other hands. Mr. Ellie, I'm a great proponent of the Department of Corrections, having worked there for, I say 43 years, but I can say 5 decades, both with juveniles and adults. I would love to, if you would contact me, to provide you more information and to walk through that department, so I could learn from you also. Thank you very much, Mr. Alley.
Thank you.
So I will now ask if there's anyone else that wishes to speak in support of this bill. Yes, of course. I didn't ignore you. That's great. Attorney Cabetta, please.
Thank you, Senator DeChambeau, Representative Warren, and distinguished members of the committee. Good afternoon. My name is Michael Cabetta, and I'm Policy Counsel for the ACLU of Maine, and wish to congratulate Abdul Ali on his new job with Westbrook Police Department. On behalf of the ACLU of Maine, we urge this committee to vote that this bill, as amended, ought to pass. Years of study show that in our current system, arrests or jail time actually increases a person's likelihood of future contact with the legal system. Each time a Mainer is arrested and convicted, their chances of coming into future contact with the system increases. The result has been a tragic trend toward mass criminalization and warehousing of people who are predominantly poor and predominantly struggle with substance use disorders and other mental health challenges. When thousands of Mainers go through the same motions each year, it's time to stop focusing on individual fault and moral failing and start to look at the system as a whole. Senator DeChambeau just said that 10 years ago, we did not think the same way we think now. We must acknowledge that our approach is causing these cycles of incarceration. This bill points a way out. Things can be different. The evidence shows that people are shaped by circumstances. Effective policymaking then demands that we focus on changing circumstances, not people. This means pulling our money out of prisons and creating more alternatives. We urge you to vote that the amended version of this bill, which we just learned about today, but fully support, ought to pass. Thank you, and I will try to answer questions.
Thank you. Any questions? And I see Senator Stairway.
Thank you, Madam Chair. Mr. Clute, I just was wondering, would you agree with this, that if they have a choice between being charged and going to some type of diversion program, that would be part of making a decision on helping yourself? And it would be actually, for that individual, it's kind of like a first step. And I think if we could do that with this, it would be helpful. And it would be, but also it can be marked as kind of like, and then the charge goes away once they complete whatever the diversion program is. So that's a thought.
Yeah,
what do you think?
I would love to respond. So there are, 5 types of crime in Maine: A, B, C, D, and E. For A, B, C, and D, this bill would preserve the status quo and give the judges the option of imposing a diversion alternative. The problem with charging and then giving the person a choice is that the charge itself can set that person on a path toward poverty, unemployment, foreclosed educational opportunities, and a life of poverty and second-class status. And that's one of the problems with using a charge as an educational tool. Senator Searway, I don't doubt that you've seen examples where a charge has led someone to reconsider their actions. But what you might not have seen is what happened to that person 5 years later, 10 years later, 20 years later, when they kept having to explain that charge to a landlord, university, or whatever institution it might be. And that's why this bill is so virtuous. For Class E crimes, it takes away the charge.
Thank you.
My pleasure.
Thank you, Mr. Cabetta. Any more questions coming? I don't see any. Again, thank you. I now have Jeremy M. Whatever. Jeremy, are you here to speak in support?
Yes, I am here to.
Okay, go right ahead.
Great, thank you very much. So dear Representative Warren, Senator DeChambeau, and all members of the Criminal Justice and Public Safety Committee. My name is Jeremy Mack. I'm the Young Adult Diversion Program and Policy and Advocacy Lead with the Restorative Justice Institute of Maine. And I'm here today to give testimony for Representative Morales' bill, LD 847, an act to divert older youth from the criminal justice system. Through crafting and running a diversion program with the Restorative Justice Institute of Maine since October, we have seen firsthand the need for the state of Maine to be investing in restorative justice-oriented diversion with a priority on resource connection for young adults. Our Young Adult Diversion Program emphasizes pretrial diversion for young adults ages 18 to 25, working with the Cumberland, Androscoggin, and York County District Attorney's offices to divert young people away from court and into our low-impact and easily accessible program. The Young Adult Diversion Program focuses particularly, though not exclusively, on misdemeanor offenses, the same target audience as LD 847. In our diversion program, we meet with the young adults over Zoom, open up space for them to share in a group setting about what happened, what the ripple effects of the offense were, and create the opportunity for them to be heard and take accountability for their actions. We then open up discussion around the needs that our participants have and offer to help connect them with community-based resources. Data shows that the ages of 18 to 25 are particularly volatile times in many young people's lives as they transition out of school and away from their homes. Studies show that helping young adults address their varied needs and build out support systems reduces their chances for future offending. Over the last 8 months, the duration of our pilot program, we have successfully diverted 42 young adults from the criminal justice system, of which only 2 have reoffended, leading to a reoffense rate of under 5%. For context, nationally, 1-year rearrest rates average at a bit over 40%. Grounding the young adult diversion program's logic is that young people make mistakes, sometimes repeated mistakes. According to brain studies, the frontal lobe, the part of the brain responsible for decision-making, is not fully developed until at least 26 years old, though even later for young people that have experienced acute trauma. Studies show that roughly 50% of Americans have experienced trauma, though that number skyrockets to 91% for youth in custody. The state of Maine needs to invest in its young adults, needs to give them chances to outgrow at times problematic behavior and to understand the science behind their behavior and not criminalize them. Data shows that young adults age out of criminal behavior and that Black and Indigenous young adults are disproportionately impacted by the worst mechanisms of our criminal justice system. What kind of message does this send? We need to be investing in effective off-ramps, which is exactly what LD 847 does by directing the same proportion of funds currently being used to support youth diversion programs towards young adult diversion. Many states and districts across the country have robust diversion programs for young adults. We at the Restorative Justice Institute believe that it is time for the state of Maine to invest in one too. With much gratitude for all of your time and all of your hard work on behalf of the public good. Thank you.
Thank you, Jeremy. Any questions of Jeremy? Jeremy, I heard in your testimony you talked about restorative justice, and I guess you're involved in one of those programs. So you mentioned 42 were diverted and that only 2 have reoffended. Am I correct?
Yep, that is
Okay.
correct.
What is the name of the organization you're affiliated with?
Yep. So like I said, on the I have created and run the young adult diversion program, which is out of the
What is it? Say that again.
So it's called the Young Adult Diversion Program, and it's out of the organization, the Restorative Justice Institute of Maine.
Thank you. Thank you very much. All right, we're all set. Anyone else wishing to speak in support of this LD 847? If none, I will ask anyone wishing to speak in opposition of LD 847.
Seeing no hands, Senator.
Thank you. Anyone wishing to provide testimony neither for nor against LD 847?
Again, seeing no hands.
Therefore, if we are...
Senator, I'm sorry.
There's one.
King, who's going to be speaking from the Muskie School of Public Service, neither for nor against.
Is there someone here?
Yes.
Okay,
Just raised
I'm
her
sorry,
hand
you did not
as
see
you were
that?
ending.
Well, that's a familiar face. Hi, Erica King.
Hello. Sorry, had a little Zoom lag there. Good afternoon, Senator DeChambeau and Representative Warren and honorable members of the committee. My name is Erica King, and I'm a Senior Justice Policy Associate at the Muskie School of Public Service at the University of Southern Maine. And I'm here to provide background to the committee to aid your consideration of this bill without testifying for or against. So a principal focus of my work for the last 17 years has been on juvenile and criminal justice issues in Maine and nationally. And currently our Place Matters team at USM is examining population and system data and outcomes for transition-aged youth who are involved in both the juvenile and the adult criminal justice system. And that includes 18 to 25-year-olds. And so in Maine, there are approximately 106,000 young people in this age group, which is about 8% of our total population. However, this age group comprises around 25% of criminal cases and 30 to 50%, almost half of the civil violation cases filed or disposed of in this state, according to MIJUS data. So this overrepresentation of this age group in the early parts of the adult criminal justice system is also seen in the national level and has been well documented across the country. So the practice of diversion creates exactly that, an off-ramp and alternatives to justice involvement during this key period of adolescent development. And we know from national research that's found that young people in this age category are developmentally distinct from both adolescents and older adults over the age of 25. And these developmental differences have potential documented risks and impact on maturity, on risk taking, on how impulsive young people are, how culpable. So there are ramifications to consider for both law and policy there. And research has found improved efficacy and efficiency, sorry for the ambulance in the background, improved efficacy and efficiency for diversion strategies for this age group in particular. And there are many, many states exploring alternative justice responses for this age group that include a range of policies, practices, and some programs. Not always programs, sometimes it's just a policy change. So the passage of LD 47 really does include reforms that would put Maine's practice in alignment with other jurisdictions that are pursuing data-informed solution to address the involvement of older youth in the criminal justice system and facilitate both positive youth and public safety outcomes. And I'm happy to answer any questions of the committee, and thank you in advance for your work and consideration of this.
Thank you. Any questions for Ms. King? If I was to read your testimony, I would think you would be in support. What is it that would, I don't know how to phrase that. What is it that is lacking so that you would have support of this bill?
Well, part of it is my role is to provide information on research and data and leave it to the committee in the work session to decide whether it's class A, B, C, D, E, and what are the exclusions. So I don't consider myself an expert on that or, okay, have a position on that. I do have, research and data for you, both Maine and nationally, that supports the practice overall of diversion, and particularly for this age group. So I think I have data that I can provide for the work session, but I think
okay,
part of my role is to provide informative testimony.
Thank you. Thank you for that. I will recognize Senator Seaway and then Representative Fluker.
Thank you, Madam Chair. Ms. King, how do you perceive diversion? I guess when you say the word diversion, what do you perceive that to be of making a difference?
I think it's a great question, Senator, because I think for a lot of us, it cues the mental model of it has to be a program or a resource. I think of diversion as a decision. It could be, and what those, programs or strategies are, I think need to be defined locally. But in my mind, it could be, it could include a program. It could include an alternative sanction. Sometimes community service could be a diversion. There are a number of ways to get accountability that other states have used. And there's actually a legislative primer on the front end of the system that I'm happy to provide to the work group that might show some other examples of what diversion could look like beyond a specific program.
And could you bring that to the work session? That'd be great.
Absolutely.
And I do kind of like the idea of the accountability piece, because I think that's what needs to be done. Thank you.
I think of diversion as an umbrella term, and there are many different practices that could live underneath it. And some of them that already do, in some communities across Maine that you've heard about in prior testimonies, and some communities that don't have those opportunities.
Thank you. I now Representative Fluker.
Thank you, Madam Chair. Why do you feel it's important to have an off-ramp without a charge when we're looking at the lowest level of crime?
You say more about the question? I'm not sure.
Yeah, so why is it important that we're not charging folks at the lowest level of crime? Is that,
or do
you feel that it's important?
Thank you. Thank you. Yeah, I think prior research that I have presented to this committee, the unsealed fate research, is one one paper that I've documented where we've looked at what's called collateral sanctions or invisible punishments that happen when young people are leaving the justice system and their record doesn't leave them, right? So it comes up on a background check. It restricts opportunity for higher education potentially. And so that charge, you know, to have an adult charge on a Class E might be a low level offense, but it could have a lasting impact on the future of a 18 to 25-year-old person for the rest of their lives. So avoiding a charge and getting accountability some other way is very consistent with national research that we're finding on diversion.
Thank you.
Thank you. Any other questions for Ms. King? Seeing none, thank you very much.
Great to see you. Thank you so much.
I will ask if there's anyone else that would like to speak, neither for nor against.
Seeing no hand, Senator.
Okay. It's too bad. I would love to hear from a juvenile probation officer. That's it. Okay, I said it. Thank you very much. That concludes the testimony for LD 847. Thank you. And now the next one is LD 1298. And we don't have to go far. We have someone right in our box here, Representative Warren's bill, 1298, an act to provide funds for community-based substance use disorder treatment and recovery services and to reduce by half the funding of the Maine Drug Enforcement Agency. Representative Warren.
Thank you, Madam Chair. Good afternoon, Senator DeChambeau and esteemed colleagues of the Criminal Justice and Public Safety Committee. I'm Charlotte Warren, and I'm pleased to present LD 1298 to you. As we well know, in this committee right now, 11 Mainers are dying each week from overdose. As we also know, for nearly 50 years, the Drug Enforcement Administration has fueled mass incarceration and wasted taxpayer money, and it's long past time for a change. According to the DEA's own 2019 National Drug Threat Assessment, the opioid threat continues at ever increasing epidemic levels, affecting large portions of the United States, and the stimulant threat is worsening and becoming more widespread. After billions of dollars spent on the futile drug war, drugs remain cheap, drugs remain potent, and drugs remain widely available. In Maine, the data tells us that 60 to 85% of those incarcerated struggle with alcohol or drug abuse. The number of drug-related offenders sent to prison has increased every single year since 2014, yet Maine still lacks adequate treatment and recovery services, and last year, drug overdoses caused the deaths of 502 Mainers, the highest number in a decade. Maine's biennial budget includes $14 million over the next 2 years for the Maine Drug Enforcement Agency. This is double the spending of 10 years ago. In that time period, in the last decade, Maine has spent over $47 million on the Drug Enforcement Agency. Again, you can still find any drug you want at any time of day, any place in Maine. In that time that we have spent $47 million, we have lost more than the entire population of my city of Hallowell due to something preventable. And yet we fight to keep doing the same old, even though none of the spending has been shown to have any effect other than driving up our incarceration rates. It's time for change. It's time to admit that the war on drugs is in fact just a war on our friends and our neighbors. It's time to admit failure in our public policy, and it's time to try something different. It's way past time to stop asking Maine taxpayers to foot the bill on the failed drug war. Maine's Director of Opioid Response, Gordon Smith, in his testimony to the Criminal Justice and Public Safety Committee a few weeks ago, reported that the United States Postal Service is the biggest distributor of drugs in Maine. Yet Maine continues to have some of the most arcane drug laws in the country, and partly due to the fact that MDEA insists year after year to make no changes. Our drug overdose deaths continue to rise. And I'll say again, right now in Maine, 11 people a week are dying of overdose. The drug war additionally fuels the heavy price tag on Maine's jails and prisons. While crime in Maine has decreased steadily, and in 2019, we saw a decrease in crime for the 8th straight year in nearly all categories. We have not seen that decline translate into any fiscal savings. Why? Because the drug war fuels Maine's incarceration rates. We should use our resources to fund altering the demand side of the equation. It's interesting, you heard a lot about the demand side and the supply side this morning with Representative Reckitt's bill. It's very similar in this situation. This means encouraging science-based discussions and narratives to educate potential drug users of benefits. We also had a bill about that this morning. Consequences and dangers of drug use. It also means funding treatment. We need to pivot to a health-based approach to address addiction and improve social conditions that contribute to problematic drug use. Again, right now in Maine, 11 Mainers are dying each week from overdose. 2 weeks ago, we heard hours of testimony in support of modifying our public policy response. Maine doctors, the people who actually save lives, those doctors begged us to help them to save Mainers. They told us that criminalization is killing Maine people. And I included a bunch of quotes from the doctors. I won't read those because you all can read those on your own. But I will just remind you that you heard hours of testimony from Maine doctors. You heard from therapists. You heard from nurse practitioners. You heard from people who provide harm reduction. You heard from people on the ground in the recovery community who actually provide rides to treatment. You heard from the people in Maine who are the experts on this epidemic, the people that are actually saving lives. And they're not asking for more drug enforcement agency money. They're asking for less, and they're asking for us to fund treatment. So I thank you for the opportunity to present this bill to you, and I'm happy to answer any questions you have for me.
Thank you, Representative Warren. A question, and I see Senator Seaway.
Thank you, Madam Chair. Good afternoon, Representative Warren.
Good afternoon, Senator Seaway.
Now, from Gordon Smith's testimony, has he ever indicated that we should get rid of half the funding for MDEA or for drug enforcement?
I think it would be interesting to hear from Maine's Director of Opioid Response. I think you've noticed that we did have LD 994 that dealt with the decrim of syringes, and we just a couple weeks ago had LD 967, which dealt with simple possession, and we haven't talked to Gordon Smith.
So we should probably ask him for the work session if
I think the Director of Opioid Response should be available and attending the public hearings and the work sessions. And I'm interested why the former executive director of the Maine Medical Association isn't attending. I think it would be interesting.
Thank you.
And we can ask him those questions of what does he think? And does he think we're doing the right thing in Maine, or does he agree with the doctors?
Thank you.
You're welcome. Thank you for the opportunity to answer that question.
Any other questions for Representative Warren? Frankly, I thought there would be more. Representative Warren, I'm looking at the bill and it includes the funding. Could you please explain to me, section 1 says, shall transfer 66,295 from available balances. And then what you have, or what was presented to us for fiscal year 21-22, it's $3.2 million. And again, 3.2. What is this money? How does this translate to what MDA has now? And could you respond to that?
Yes, happily. So this is actually the fiscal note generated by the Office of Financial and Policy Review. And so as you can see in section 1, transfers from the Department of Public Safety, other special revenue fund balances to general fund at the close of fiscal year 21-22, and each fiscal year thereafter, the state controller shall transfer 66,295 from available balances in other special revenue. What you'll see is that Maine Drug Enforcement Agency is funded in many different sources. There's the state allocation from the general fund. There's special revenue funds. There's federal funds. Obviously, we are not attempting to cut the federal funds here. So that's just a breakdown from the office, the OFPR office.
Thank you. Yep.
You're welcome.
Do I see any other hands raised? I don't. Oh, wait a minute. You guys snuck up on me. Senator Searway and then Representative Pickett.
Thank you, Madam Chair. I know each county has organizations for community-based substance abuse treatment programs and whatever. And what funds are available for from those? I know there's a county right in Gardner. They have a office right there on right near the post office, and I didn't know if you knew any of that.
Are you asking me what community-based services are available in counties?
Yeah, what the budgets are and that sort of thing. Just how that works so that we could.
Thank you. I appreciate the question. I do a lot of work with the recovery community. What I know is that still to this day, if you need treatment, you're turned away because we don't have enough for you. You're told to come back in a few weeks. Near you, Senator Searway, you have the Hope Project, right? Excuse me, the Hope Program at Waterville.
Right. My daughter actually is one of the volunteers for that. Yeah.
Spectacular, yeah. And Chief Massey has done a wonderful job, and he's having bake sales and lawn sales in order to raise money to buy plane tickets to send Maine people out of state where there's maybe a treatment bed. So I think that tells you everything you need to know about what's available for services. Gordon Smith came to our committee also a couple of weeks ago and told us that you can get residential treatment in Maine if you're wealthy. He told us that we have 2 at that point medically managed withdrawal sites for adults. 1 since then has shut down, Milestone in Portland. So we have 1. We have 0 medically managed withdrawal sites for youth in Maine. 0. So the answer to, do I know what the budgets are? I don't. But what I know is there isn't enough. So we continually pay for Maine drug enforcement agents to go out and catch people and incarcerate them or catch them and have them snitch on their friends and run it up the train, always in search of getting the big get, right? So we can then send the press release to the local paper with the picture of guns and money and bags of drugs. And you and I both know that if we lock up that person selling in that area, there's somebody coming right behind them as long as there's demand. There's
So
somebody
during,
right behind them.
so just a question, during the opioid task force that I was on, they had, I think they had like 4 million 1 year and about 6 million another to put towards the opioid crisis. And what have we done with that money?
I think that's probably a good question for the Commissioner of Health and Human Services. I'm going to be really interested to see what the details are in the budget that will be released on Friday. I know there was a press conference about it today, but we don't have access to the budget until Friday. So I'm going to be really interested to see what sort of money is in there. The only thing that I can tell you, Senator Searway, again, is that 11 Maine people a week are dying of overdose. So not enough, right?
But we can, yeah, but we legalized, we legalized all these drugs, and then what happens there? I mean, there's no accountability. So that's a problem, right?
Well, cannabis has been legalized in Maine, but nobody will overdose from cannabis, I can assure you. That's
Really?
not causing,
Okay.
cannabis is not causing the overdose deaths. But yes, the Maine voters did vote to legalize cannabis.
But they don't stop at one drug, most of them. So that's the problem. Thank you.
I would remind people that we are dealing with funding, and the source would be from the Maine Drug Enforcement. But these are good questions. Representative, are you done? I'm sorry, I didn't mean to cut in. Senator Searway, if you have something else to ask. Are you all set?
I just wanted to find out where the funds are that's already been for the opioid crisis, and what
Okay.
happens to that.
Is
I
that
guess that's my
something you
big
would-
question for the work session.
Yep, all right, good. I
Yeah.
think Ms. Overton has that.
All right,
If
thank
not,
you.
if she needs clarification, I think she'll ask you.
Okay.
Representative Pickett?
Yes, Madam Chair, thank you. Representative Warren, I guess my question would be this. I first would preface it by saying, I heard the testimony on 967, and as you did, and you rightly talked about the doctors saying what they had to say about substance use disorder treatment and that stuff. And I agree with that wholeheartedly on that topic took place. But I guess I'm having a hard time because I don't recall any of the doctors ever saying that where the funding should come from. They were just saying it ought to be done. And so I don't think, I just say this because I don't think they ever were saying that we should get rid of MDEA to fund this. They're just saying it should be funded. And that being said, you and I have had this conversation before, and I agree that this has to be done. But I think we disagree on the funding piece. So I just wanted to clear that up, unless I didn't hear it, and maybe you did hear that, but I don't recall hearing them ever say, shut down MDA or take the money from them. I know there was some talk about the war on drugs. I understand that, the failed program, but I just don't remember anything specifically saying that. I just wanted to clear that up. That's all.
Yeah, thank you for the question. If you look at the quotes that I provided in my testimony, and more specifically, look back at the testimony of the, I think, 8 or so doctors that testified, what they're saying to us is what we're currently doing with criminalizing and stigmatizing people with a substance use disorder is killing them. That's what's happening. And so I read that as them saying, we need to change our approach. They are asking for a policy approach, but and I'm fighting for that policy approach as well. And if we do, in fact, if we can create that policy approach, we don't in fact need all of these millions of dollars going to the MDEA. So I read the testimony in that way. That's why I included their quotes. I think that you heard even from the Attorney General when I asked him the question of, do you think what we're doing is working? He said, no, not at all. So that's the way I read it. If you read it a different way, that's totally fine. We can disagree on that.
Okay, we'll agree to disagree.
We've done that about 1,100 times.
Well, we always usually come back sooner or later.
Exactly.
All right, okay, no more questions for Representative Warren from the members. I will now turn it over to if there are any legislators who wish to testify in support of LD 1298. And along with any legislators I could identify if they did come in, would be people who wish to testify in support of this bill. Please raise your hand so we can let you in.
I'm bringing 2 people over.
Thank you. Welcome, Mallory. I was gonna, getting kind of tired here. Mallory Shaughnessy, nice to see you again.
Nice to see you too. You've had a long day. You get to make a couple stumbles there. It's been a long one for you.
We've had a long month. Okay.
Yeah, there is that. Day, week, month. So good afternoon, Senator DeChambeau and Representative Warren, members of the Joint Standing Committee on Criminal Justice and Public Safety. My name is Mallory Shaughnessy, and I'm a resident of Westbrook and the Executive Director of the Alliance for Addiction and Mental Health Services. The Alliance, the statewide membership association for Maine's community-based mental health and substance use treatment providers, advocates for the implementation of sound policies and evidence-based practices to serve to enhance the quality and effectiveness of our behavioral healthcare system. And on their behalf, I'm here in support of LD 1298. I mentioned last time I was here, but if you haven't yet read Chasing the Scream by Johann Hari or watched his TED Talk, I have a link in my testimony, you really should. He highlights the decades of experience that have shown we cannot arrest and punish our way out of substance use and overdose deaths. LD 1298 begins to realign our investment from one of arresting and a punitive response to one of treatment and a supportive approach. The bill provides funding, as you've heard, for community-based substance use disorder treatment and recovery by reducing by half the funding for the Department of Public Safety, Maine DEA. What we're here to say is we must stop treating people affected by substance use disorder as criminals instead of patients. We need a humane and public health informed response to ensure people stay alive and have the best opportunity to live and thrive in their community. People break the law to get drugs, but only because we've made them illegal. During Prohibition, drinking alcohol was illegal, and so securing, making, or selling alcohol was illegal. It didn't stop people from drinking it. Making drugs illegal does not stop people from using them. Arresting people and placing them in jail does not cure addiction. Defunding the police is a terribly misleading slogan. I wish they had never couched that term. It sounds like abolishing all law enforcement, which we would not be in support of. But what it does mean is reallocating or redirecting funding away from law enforcement to other agencies and realigning our values, realigning our investment from the same governmental entity. And that's it. It's simple. Defund means to reallocate resources to better purposes, not taking all the funding, but realigning what our values are. Our budgets show our moral values. It's realigning those values to what we believe works. And in this case, it means redirecting funding for public safety to public health. It's another form of public safety. I thank you for considering these comments. I'd be happy to answer any questions and get you any additional details, research, whatever you have heard from 9 million people, all aspects of this issue. And you've got all the statistics you need. So with that, please vote ought to pass on this important legislation.
Thank you. Any questions of Ms. Shaughnessy? I've got Senator Seaway followed by Representative Pickett.
Thank you, Madam Chair. Thank you, Mrs. Shaughnessy. When you said taking the funds away from, law enforcement for moral values, when we have fentanyl, heroin, cocaine, heavy amounts brought in, and we have MDA to help fight that battle of drug dealing going on, and taking half the manpower, I don't see how that's going to help the moral values of our kids and our families. So maybe you can help me understand that.
I'll share my perspective, if you will. Our budgets define what we value. What we put our money to defines what our community values are and our moral values and what we want to see. We have spent millions, billions of dollars on the war on drugs. We have spent far more on the war on drugs than we have ever thought to spend on treatment, recovery, or prevention. That's a moral choice. That's a value choice. That's a budget choice that our communities have made. And what we know now after all these years is that, and my undergraduate degree was in economics, and it's a supply and demand. As long as there's demand, there will be supply. That's just a fundamental feature of an economic system. And unless we put the money into reducing the demand, doing prevention, doing treatment, doing recovery, and supporting that, unless we put more of our funding into that, we will always have more drugs coming in. They will be opioids, they will be crack, they will be heroin or the drug du jour. They will be coming in as long as there is demand. During the Prohibition, we didn't stop drinking. There was a demand. And so then we ended up with organized crime and all these other ways of getting it to people. What I'm saying is we are putting our money on the wrong side of the equation as far as my perspective is. And as far as I think research shows, we are putting far more money on the wrong side of that equation. We're putting it on the supply, not the demand. That's just my perspective. And I think we'd have a lot less problem with drugs coming in from anywhere if we had less demand.
Thank you. Representative Pickett.
Yes, thank you, Madam Chair. I would be remiss if I didn't say hello to Mallory, so that's why I wanted to just be able to say hello. Miss you on the subcommittee.
Yeah, I know. It's been so busy. I missed it this morning.
Ms. Shaughnessy, you mentioned something that piqued my curiosity. You kept saying stopping the drugs that come in. The war on drugs includes, it's almost like the breweries of homemaking drugs, which is methamphetamines.
Oh, yes.
It's not stopping that at the border, but that is part of MDA, or could you speak on that?
Well, actually, I have to tell you, I spent a couple of years as Maine's methamphetamine prevention coordinator, and I got to go around. I got to go around the state and give presentations on how people make meth and what to watch for, how to look for a lab out in the woods for CMP line workers and all these folks, how to look for it. And I remember, I think it was Roy McKinney who actually said to me, maybe it was one of the sheriffs, but said to me, Mallory, we're really probably never going to have that huge of a problem with methamphetamine in Maine because the heroin is so easy to get here. And I will never forget that. And it's true, but it's like one drug or another drug, if there's a demand, they will come. They will make them, they will import them, they will smuggle them in every which way, they will cook them in their
kitchen in a trailer out back. As long as there's demand, there will be increasing drugs, and all the money we have spent on trying to stop the supply will never, there's not enough money to stop the supply unless we stop the demand. So switching some more funding into that side of it just makes sense to me.
Okay. And I know what you're saying. I was surprised when a few years ago it came to my attention, there was a fire in an apartment and the firefighters obviously showed up and they saw something they never saw before. And it took the code enforcement officer to say that they were manufacturing methamphetamine.
Yeah.
Well,
a colleague that I had back in those days when I was doing the methamphetamine prevention work, one of my colleagues, whenever he traveled and stayed in hotels, he would take, I think it was hairspray, and he would spray it all through because it would turn, if there was any, leftover meth materials stuck in the wallpaper or something, it would kind of turn a purpley color. And so he would be able to alert the hotels about it. And it's like, oh my gosh, because, they can cook it anywhere.
Well, that concludes our public service announcement for the day.
That's right.
Thank you very much. No other questions for Ms. Shaughnessy? Good. Any other? Oh, we've got Michael Cabetta. Attorney Cabetta, go right ahead.
Thank you, Senator Shambo and distinguished members of the committee. Good afternoon. My name is Michael Cabetta and I'm Policy Counsel for the ACLU of Maine. On behalf of our members, we urge you to vote that this bill ought to pass. Over the last 2 years, the legislature has enacted multiple pieces of bipartisan legislation to address Maine's overdose death crisis. Each of these policies moves closer to a recognition that Mainers who have substance use disorders need treatment, not jail. This bill represents a very important step on that path. Last year's eruption of protests across the country and in our own state have emphasized a central flaw in our government. We've relied on policing to solve challenges better suited to healthcare, housing, and educational systems. Mainers of all colors have suffered as a result, but Mainers of color, poor Mainers, and Mainers with disabilities have suffered most acutely. We cannot allow this to continue. Substance use disorders cannot and will not be solved with prison sentences. Evidence shows that treatment works much better than repeatedly arresting and convicting a person for drug offenses. When people have access to treatment, they do much better. Moreover, the kingpin, which we've heard a bit about today, is more a creature of our imaginations than of lived experience. People who sell drugs almost always also use drugs. By transferring resources from the punishment arms of our government to the healing arms of our government, this bill gets at the root cause of the overdose crisis, which last year took more lives than the coronavirus pandemic. We urge this committee to pull money out of failed systems and create stronger and better alternatives. Investment is not only more effective and efficient, it's fair and more humane. We urge you to vote ought to pass, and I'm happy to try to answer questions.
Thank you very much, Mr. Cabetta. Any questions for Mr. Cabetta? Seeing none, again, thank you. Anyone else wishing to provide testimony in support of this bill? Please raise your hand, we'll let you in.
One more hand.
Thank you. Welcome again, Victoria Arrington. Go right ahead.
I really wish there were more people here to speak before me. But I thought I would just share. I'm reading a book called High Price by Dr. Carl Hart, and I would encourage anyone interested to watch the TED Talk Dr. Carl Hart has. And there's a quote in the book that I thought I would share. I'm sorry, I'm not more prepared either. Well, actually one like paragraph that I summarized was criminalization is one of the most dangerous things about drugs. Prohibition makes drugs much more dangerous. And then a direct quote from the book is also, I want to explore with you what I've learned, especially the importance of empirical evidence. That is, evidence that comes directly from experiments or measurable observations and understanding issues like drugs and addiction. Importantly, such evidence is reliable, and experiments are designed to avoid the bias that comes from looking at one or two cases that may not be typical. The opposite of empirical evidence is anecdotal information, which cannot tell us whether the stories told are outliers or ordinary cases. Many people rely on personal anecdotes about drug experiences to try to understand what drugs do or don't do, as if they are representative cases or scientific data. They are not. It is easy to get bamboozled if you do not have specific tools for critical thinking, such as understanding different types of evidence and arguments. I'll share these tools throughout the book. Yeah. He also goes on to say, indeed, much of what has gone wrong in the way we deal with drugs is relating to confusing cause and effect, to blaming drugs for effects of drug policy, poverty, and institutional racism, and many other less immediate factors. One of the most fundamental lessons of science is that a correlation or link between factors does not necessarily mean that one factor is the cause of another. This important principle, sadly, has rarely informed drug policy. In fact, empirical evidence is frequently ignored when drug policy is formulated. Thanks.
Thank you. Any questions for Ms. Arrington? What's the title of that book, Victoria?
High Price.
High Price? Good. Thank you.
Thanks.
Anyone else wishing to, I don't see anyone asking any questions. I don't believe there's anyone else that wishes to speak in support. I will now turn to those who may want to provide testimony in opposition. And this is LG 1298.
I'm bringing over Roy McKinney.
Yes, please raise your hand if you wish to speak in opposition. Welcome, Mr. McKinney.
Good afternoon, Senator and committee members, Representative Warren. Well, let me start, if I might. Senator DeChambeau, Representative Warren, and other distinguished members of the Criminal Justice and Public Safety Committee. My name is Roy McKinney, and I come before you as the Director of the Maine Drug Enforcement. I'm here to testify on behalf of the department in opposition to LD 1298, an act to provide funds for community-based substance use disorder treatment and recovery services, and to reduce by half the funding of the Maine Drug Enforcement Agency. This proposed legislation reduces by half the general fund allocation for the agency, which will adversely impact Maine's ability to disrupt trafficking operations that supply Maine communities with opioids and other dangerous drugs. An effective drug control strategy requires three fundamental lines of effort that are at the heart of such a strategy: prevention, treatment and recovery, and reducing availability, which are complementary and mutually supporting. This legislation offers increases for treatment and recovery to the detriment of Maine's statewide effort to reduce availability. Investigating and disrupting opioid and other dangerous drug trafficking operations that impacts the availability of these drugs is a law enforcement response for which the agency is well designed. While efforts to reduce availability is one of the many activities of police departments, this program is singularly focused on disrupting the drug market in its effort to dismantle drug trafficking operations to impact availability. The investigative component of its task force group is comprised of officers throughout the state, all with statewide authority. The largest component of the budget funds the payroll of those officers assigned full-time, reimbursing the local community to replace those officers, and the community retains the same staffing level. Maine sheriffs and chiefs are committed to that statewide effort in their support of U.S. Department of Justice grant funds for a number of officers. The agency's efforts focus on addressing the upper and mid-level drug dealers that operate below the interests of federal law enforcement authorities and the street level efforts of uniformed agencies. The policy that established a Maine statewide drug enforcement program and strategy over 30 years ago set forth that such is necessary to meet the threat to the health and safety posed by the distribution of scheduled drugs into, out of, and within the state. A funding reduction that eliminates investigative staff will have a crippling impact on this program. The outcome of increased availability only expands the opportunity for individuals to initiate drug use, and the path from first use to chronic use can be especially short with the potent and highly addicting drugs. On behalf of the Department of Public Safety and Maine Drug Enforcement, I thank you for your time and will be happy to answer any questions that I may.
Thank you, Mr. McKinney. I have Representative Reckett would like to ask you a question.
Representative Reckett, your mute is on. There you
Keep
go.
trying to mute to save everyone from the carpenter noise from the next room, and I end up not muting myself correctly. Director McKinney, nice to see you. I'm sure that, I have faced times in my life when somebody said, okay, I'm going to wipe out, 3/4 of what you have to work with and just carry on. And it was a terrible feeling that I fought to the core, and I'm sure that you will in this instance. My question to you is, if we agree, and I suspect we do, that there are three aspects to the war on drugs, really. There's the supply side problem, there's the demand problem, and there's the treatment problem. For what are we going to do if we screw up on the first two steps? My question to you is, if we could talk about, let me get this guy to stop 1 second. Sorry for that. They're sanding the floor next door. I mean, like, what I'm trying to picture in my mind, if we had $100, but really I'm talking $1 million or 100 million, you had $100 million, where do you see the proportionality of the effort needs to go? I mean, what would it take if you had $100 million? What percentage would you put in the trying to get rid of the supply problem? What percentage would you put in trying to recruit the demand problem? And what percentage would you put in trying to treatment problem? Or have I got those in the wrong order? Is it a supply reduction, treatment, then demand reduction? I'm not sure, but there's multiple parts to this problem. And my sense is that what you're working with is the first two, the trying to decrease the supply and therefore decrease the demand, because if there isn't there, they can't have it. So, but where's the proportionality of this problem? How do you solve the whole thing?
Thank you, Representative Reckett, for your question. There is the demand and the supply side, and for availability has to do with supply. We want to interrupt that supply side so that folks are steered towards the treatment. So you have the treatment and recovery, you have the availability, which is the police, and then you have the prevention side of the house. And I'm no expert in prevention or treatment and recovery services and what the costs are that go into that. What I am an expert in is what does it take in order to have a viable, robust program in regards to availability. With that said, I would use robust for all of those elements as we combat this issue, which we've been doing for so long as a nation with regards to substance abuse. And there is frustration. Don't think that I'm not frustrated that the officers who are confronted with calls that they go to and the investigators for MDEA that they want to see more progress being made. And at times it feels like maybe that progress isn't being made, but it does happen. There is progress. It's and I always liken back to when I was in the field many years ago with the Bangor Police, and we had an ad hoc task force group of just 3 officers trying to do a little bit in an area of Penobscot County. And several years later, it was a negative encounter. The person was arrested, but when they came out, they tracked me down to thank me. But for that intervention, even as negative as it was for them, because it is not a pleasant experience being arrested in charge, and they were their offense was a federal offense. But for that intervention, they would have died. And I go back to my time when I first came to the department. I looked at those numbers of overdose deaths, 24. And now we're at 500 plus. Shocking number. It's a shocking number across the nation. So as a nation, we're trying to deal with what are the best approaches without exacerbating what is taking place. And so,
Can I ask a follow-up? Whoever it is that's chairing, is that you, Susan, or Senator or Representative? But my follow-up question really is, you have probably a better view of what is available around this state to try to do prevention, to try to do services. But it's clear to me as a citizen that there is not enough of either one by a long shot. And I don't know what to do about that, except I'm disturbed at the rumors I hear that, well, what I saw in the initial budget that we passed a month or two ago, the absence of funding for treatment services. I don't have any optimism about the next budget. How are we going to do this unless we put money into the operation of trying to provide treatment services for people? And where are we going to get the money? That's the puzzle. I mean, there is not an unlimited force of money in this state. And I think that it has to come from someplace. And I think people were searching around, and because you're a connected agency, it makes sense to think about that. Is this a way we shift how we're dealing? So that my question is, where do we find it if not with you? Where do we find it if how do we get people to shift these priorities, or should we not? Should we just pile on? And how do we know that's going to work?
Well, thank you for your question, and I think it is a matter for public debate on where the funding allocation comes from for these 3 very important elements for addressing the substance use problem that we have in this state and this nation. I'm only speaking from the 4 walls that I deal with availability is I'm always on the lookout for federal funds and reaching out when they're offered by the Department of Justice, which is allowed and given the officers in the field tools that they desperately need to bring them into the current century. I can't speak for Department of Health and Human Services. I have no idea as to what programs and grants that are available through the federal system, but I've got to believe that they have researched those to the fullest extent for those dollars.
I'd like to think so myself, but I'm not convinced. So, thank you for appearing today.
Well, thank you.
I have Senator Serway followed by Representative Pickett.
Thank you, Madam Chair. You know, I was listening to your talk there with Representative Rudnicki, Reckitt and Mr. McKinney and Director McKinney, and just wondered if I know we hear about $1 billion worth of government federal money coming to the state of Maine, but yet they're going to rob Peter to pay Paul on robbing from MDEA. How do you feel about that? I mean, it seems like there could be some treatment centers. This would be an opportunity, actually, from the federal government to take some of that money, make some treatment centers. And to me, that would be that part that really would help. And I see the need for the resources. There's no question about that. I just don't see taking from something that's a big help and then take half of that and then put it somewhere else and still doesn't meet what we need. But I think that the federal funds seems like this would be an opportunity. What do you think?
Well, most certainly, it is. It's there on the table, if you will. But then again, it's always the devil's in the details, right? Is to as how that money may be spent. In my readings, I haven't seen anything coming out of Washington of a new additional efforts in regards to treatment and recovery or prevention. Or even on the impact in the supply side, given that the numbers are especially shocking at a national level over this past year. They released them and they were up from the year before that. So I'm sure I've got to think positively that the federal administration and our representatives there are working on that issue. And at some point, we'll know more as to what programs are going to be put in place for that.
Thank you.
Representative Pickett.
Thank you, Madam Chair. Thank you, Director, for being here this afternoon.
Thank you.
Let's take here for a moment, and I'm going to ask you a question to have a chance to let the people listening in know the reality that if this bill goes through and you're cut one half, what does that do to your organization? And what does that do for the influx of drugs in our state?
Well, as I presented in my testimony, the largest piece of the budget is personnel, is payroll, like any business. We have 53. Right now, I'm preparing 53 contracts with agencies for the services of officers to be assigned here. In the current fiscal year we're in, that amounted to just over 5.2 million. Over 500,000 was federal monies. So back that out, we're at 4.7. So if we take 3 million away, that'll be definitely personnel. And then it comes, then you have to start looking at it from the safety of the officers and how effectively you can address the supply side on a statewide basis. and it may not be available with that kind of money. It may be shrinking it to what existed in the state before the Maine Drug Enforcement Act was passed. And that had just task forces in Penobscot, York, Cumberland County. That was it. Anywhere else in the state, it was up to the local police agencies to pursue the drug traffickers. So I don't think it's hyperbole to say that there would be more drugs available on the street, given what we're seeing right now on the interdiction level. And I just pulled out some numbers, and just last year, the men and women here, 6.2 kilograms of fentanyl. How many people would have died as a result of once that got into the communities? Just that particular drug alone, which is driving this overdose death that we're confronted with. It's the fentanyl. We've never seen anything like it. It's across the country with regards to what's driving these deaths.
Thank you. Follow up, Madam Chair?
Yes, go right ahead.
Thank you, Director. And before I ask the other question, then basically it's putting one hand behind your back and telling you to do the full job with what we'll be talking about. But the other thing, I want to see if we can dispel a theory that seems to be going around, and some think it is fact, and maybe it is. So here's a chance to find out. But I think there's a lot of people that are making policy regarding your department and regarding the drug laws and so on and so forth, that feel that you folks deal a lot with the small time user. And if you can put the percentage in there, if you can, and you may not be able to, but as overall what you're built to do and what your mission is for MDEA, what type of percentage would a small time user have to play in the overall picture of what you're trying to do? Your real and what is your real target as an organization?
Our effort is focused on what we've deemed OCN, or organized criminal narcotic. And that was a term borrowed from the early 1990s when federal money was available for state drug enforcement efforts that targeted substantial dealers and provided the money by which to do that, because it takes, unfortunately, it does take money. It takes overtime and the purchase of those drugs. So we use that here at MDEA with the supervisors writing up a case proposal and a budget to drive the investigations on those substantial dealers. And so when we are doing a case, and there was one recently in which it was 2 kilograms of cocaine and 1/4 kilogram of fentanyl, that was a result of doing that. But at the same time, the law enforcement agencies across the state are asking for our assistance because their phone is ringing off the hook about the person down the street who has a steady stream of customers into their yard, all for the purchase of purchasing drugs. A lower level dealer, those are the ones we all see because they attract so much attention. Whereas the higher level dealer, they're dealing with only a few select individuals, and that's it. So they don't attract the attention. So we balance cases that we do. We'll ask the local department to work up that case as far as they can, and then when they need further assistance, we'll be more than happy to assist them with that, because that's the call that the chief or the sheriff is getting calls about from the community, and people want something done. and we understand that. And the vast majority of departments aren't equipped to do that. They don't have unmarked cars. They don't have the expertise in pursuing these types of investigations. And they are difficult in Maine. In a rural state, drug investigations are not an easy task. They are staff intensive and take time, and you may never ever be in a position to have evidence to bring to the prosecutor and then eventually the court. So what's the percent? I don't know, but I can say that is our focus, is that sweet spot, if you will, between what the federal authorities are interested in, because they have thresholds that below that they're not going to look at unless it's interstate, substantial violator, or international. And then XYZ police department, what they can do. We're trying to cover all that in between with 53 people throughout the entire 16 counties, and at the same time have about 13 or so of that staff rotating out on an annual basis, bringing in new officers that you got to train up. And typically that's going to be 18, 24 months before that officer is at a peak performance level with regards to doing these complex and intense investigations.
I would recognize Representative Morales.
Thank you, Madam Chair. And thank you, Director McKinney. You just said, so is it through attrition? You are losing 13 staff every year and having to retrain? What's that in a percentage? I'm trying to do the percentage calculator of what's 13 out of 53, but that's a lot. So that's a question for you of why you think that is happening. And then, I just don't understand why, because from what I've heard is the problem's getting worse. So why is this approach the approach we should continue if it's not helping? And just so you know, and I know you do know because I've spoke about it, the public health sort of evidence-based approach suggests around the country and through data that actually works. So I'm just wondering what your thoughts are on why we should continue doing what we're doing if it's not working, unless you believe it is working.
Thank you, Representative Morales, for your questions. With regards to the attrition, I don't know, what's that, 15, 20%? I don't have my calculator with me, and the reason is we're a task force. With the officers, the men and women that are here are not here on a permanent basis. They're not employees of the state of Maine. They remain the employees of Cumberland County. They remain the employees of Ellsworth Police Department or the Aroostook County Sheriff's Office. They're on assignment to the Drug Enforcement Agency. For some, that period of assignment may be a long period of time. Because that works for that officer, but not all officers are geared for drug enforcement for year after year after year. We all different personalities, if you will, and at the same time, the officers that cycle out, for the most part, they're being promoted. They're being promoted to detective in their department and go on beyond that. I'll speak to myself, as I came over as an agent, went back to Bangor, sergeant, lieutenant, and up to the ranks. And there are many others, alumni, if you will, that have become chief and above in their law enforcement careers. So the attrition shouldn't be looked on as a negative thing. I always say when When an officer leaves the service of the agency, I congratulate them. At the same time, I say, I hate to see you go. But it's the right move for them because their agency is their home, is their future. Maine Drug Enforcement is just an assignment. It's a passing where they're serving not just their community, but the state as a whole in public service. Now, with regards to the problem getting worse, if I had mentioned fentanyl to anyone in 2013, they would look at me and say, what? It didn't exist then. Excuse me, it did exist, but only in for pharmaceutical purposes. And there were people that would abuse that. Transdermal patches for end-of-life care is where they would be diverted from. But the fentanyl powder that is being illicitly manufactured started in 2014 in the Chicago area, and then it went dormant, and then it just came back big time because of the profit margin. The drug trade is all driven by profit. There are people that at the lower levels that are suffering from SUD, and they will turn to trafficking in order to support themselves. But the traffickers, so they're the ones that are making the money. There's so much more money to be made with fentanyl than with heroin, and that's why we see very little heroin now. And then why we're seeing fentanyl, which can be manufactured in the lab, much like methamphetamine. You're going to not need hectaacres in order to produce this drug, but merely a chemist and the products to do that. And the profit margin is just berserk. And I believe in the public health. I don't think you'll find a reasonable law enforcement that says that prevention, treatment, and recovery are so necessary in this battle, this war, as it's been called. All of them are necessary, and we all struggle for the funds. I struggle for funds every year. I have to balance a budget. In having these officers go out, do cases, and stay within the confines of the monies that I am allocated as the executive, the chief executive of the agency. So I trust that answered your questions.
I think so. I think you're saying this is just one piece of the problem, and you probably agree that enforcement's not going to solve the opioid crisis that we're experiencing alone.
Yes, I mean, the short answer is yes.
Okay,
and I think
thank you.
Sometimes we talk on different levels. If it's the person that is suffering from SUD, that's one thing. When we're talking about the traffickers, we've got to hold those people accountable, because at the same time, one might say we can't arrest our way out of it. If we tamp down that impacting that availability, can it be said that we can treat our way out of it while drugs are flowing into the state? Because I firmly believe this, that don't think that the traffickers don't follow the laws, don't follow public policy, because it impacts their bottom line.
Thank you. And I would like to offer a few comments, and I have a couple of questions. The title of this bill is an act to provide funds for community-based substance use disorder treatment. Who would disagree with that? I do not disagree with that. I do agree with Representative Pickett that it shouldn't come from MDA. Director McKinney, his directive as a director is to enforce the laws made by legislators about criminality, about drug use. And this committee has worked very hard, and I would point to Representative Morales and Representative Warren and others who have worked very hard to decriminalize and to look at the level of that. I'm glad someone asked the question, Mr. McKinney, because I had it too when you mentioned 53 contacts with agencies. And then as more people were asking you questions, you explained more, and I had never heard the term, but it does apply, that the officers, men and women that do work for MDA are really a task force. And I would like, before I go any further, does every state have the equivalent of an MDA?
Thank you, Senator, for the question. They have some equivalent of it. In my experience, I'm the past president of the National Alliance of State Drug Enforcement Agencies, so I have a fair knowledge of about 36 states would attend our twice a year meetings. When you look across the state, about half the states, drug enforcement is the responsibility of through the Attorney General. That's who the investigators are. The other half is with the Department of Public Safety. And within that group, I'd say Connecticut is probably the closest that MDEA has, rather than being a narcotics unit within a state police agency, such as the Maine State Police have much like they have the major crimes unit, they could have a narcotics unit. MDEA chose, or the state chose, the model of a total multi-jurisdictional. Be within the department, officers would come from state, local, county, and tribal agencies. Connecticut is probably the closest. Connecticut is a state police-based run narcotics unit. And they use burn funds to pay a stipend to the assigning department. Let's say it's, for the sake of argument, Farmington, Connecticut sends an officer over. They pay a stipend, but not the full salary. In Maine, it has to be the full salary because the local agencies just don't have the funding to just pick up part of that. So, so every state, all states, I can't say every state, but the ones I could think of, they have a specialized narcotics unit that is responsible for conducting narcotics investigations.
Yes, and I'm glad that Representative Morales asked that question about the attrition and what have you. I think this is a learning experience for all of us and the public that is listening. You are right. My community pays for an officer, and the city council knows about it. And yes, came back and it was a detective because of the experience, and not everybody can do that. And my experience, and I have to address that, we've all had different experiences. Representative Beckett has worked in domestic violence and domestic abuse and can relate, and we all have relations. I happen to be the person that interviewed, and I would say close to thousands of prisoners in my career that were there because of an MDA arrest. When your police chiefs in the community of the whole state of Maine says that there are drugs coming into their community, the first thing they do is let MDA know about it, and they set up shop. There are times about 6 months after the arrest, I would find 3 or 4 or 5 prisoners that all came from the same community, and I couldn't figure that out. But in the interview, there was something you said, Mr. McKinney, about interrupting the supply side. And only with approaching users can you get information, I would presume, how the supply came in. And in one particular case that I remember vividly was the trucks coming in from Canada in big companies. And that's all police work and investigation. So forgive me if I don't have another question on that. If I was wrong, if in making my statements, Mr. McKinney, you are the subject matter expert in this. This is where I'm coming from. It really starts in the community and the chief law enforcement of every community, and it could be South Portland, it could be Hollowell, it could be anywhere. Those chief police do not have the expertise or the manpower to investigate what has infiltrated in their community. And I guess it's like, oh, I almost said killing cockroaches, but it's like you want to just disperse them or arrest them or find out where it's coming from and arrest the supplier. So I had to say this because that's where I'm coming from, if I can be persuaded in any other way. But I truly believe, and I will be 100% behind getting any more funding for community-based substance abuse, but not at the expense of MDA that have a directive to enforce the law. So that's my comment, and thank you for answering my question about MDA and about other states. I didn't know that, and I'll look more into that. So if there's a better mousetrap, I will find it. So thank you very much. Senator Seaway.
Thank you, and I mirror Senator DeChambeau's views as well. I think that MDA has done a terrific job, and it's not only for their department. I'm just kind of wanted to ask Director McKinney, how's it viewed with the agencies that they lend out their men and they go, or women, and they go back to their own agencies, and they've really helped their own agencies because of the knowledge they've learned from that. I mean, to me, that's invaluable of what you've brought to the table. And what's your view on that part?
Thank you, Senator. That is the concept of why this strategy, this program began in 1988, was recognizing that officers would come into a task force environment, would learn skills that they may not learn at their own department. And then when they went back to the department, they would take those skills with them. And that certainly has happened. As an example, I hate to use myself, but rather than talk about someone else, I was a patrol officer, went into detectives. I was a polygraph examiner. That's how I got into detectives, loved investigations. My point is then I got involved in narcotics investigations. And then while I was a detective, I'd never authored a search warrant, an affidavit for a search warrant. When I came back from doing drug investigations, I was the subject matter expert when it came to doing or drafting search warrants, including recovery of stolen property, child pornography, etc. And so these men and women go back to the departments and they'll bring that knowledge. And oftentimes, not oftentimes, what I'm saying is that the chiefs and the sheriffs send over their top personnel, their top staff. And what happens when they go back? Oftentimes they're going to be promoted to sergeant, and they'll be imparting that knowledge to other officers within their department. And the other thing that Senator DeChambeau brought up that struck a nerve with me was when the senator spoke about chiefs. I worked for the Commissioner of Public Safety, but also I worked for the chiefs and the sheriffs of the personnel that are assigned to MTEA. They're in my care and custody while they are here. So we do the best that we can, knock on wood, with regards to safety and planning of all our operations. And those men and women go back safely every night. So we're a family in that sense, but that's who I'm also working for, not only the governor and the commissioner of public safety, but the chiefs and sheriffs throughout the state. So when they call and they have a problem in their community that they suspect is a drug problem, we'll do everything that we can in order to investigate that and bring it to a safe conclusion.
I have a couple of other people. I've got Representative Lookner, followed by Representative Morales.
Hey, thank you, Madam Chair. And with all due respect to the extensive experience of Director McKinney, I think a lot of this has been, just as a point of order, some of this could be saved for the work session, I think. And just want to point out that we've got Secretary Bellows in the waiting room for the next bill, and out of respect for folks' time, I just want to point that out.
Representative Morales.
I'm all set, except that I would like to ask Director McKinney if he could bring to the work session the training costs that are provided to the 25% attrition rate that they have each year, and sort of what that training looks like to retrain folks who are coming on board. I know from the private sector, if you have a 10% attrition rate, that's okay, but beyond that, that's challenging for the private sector in terms of cost of retraining. So if you could do that for us, that would be great.
You're welcome.
Thank you. Anyone else speaking in opposition of this bill? Please raise your hand.
Seeing no hand, Senator.
Okay, anyone wishing to testify neither for nor against, please raise your hand.
Again, seeing none.
Thank you. Therefore, I will, seeing no further questions on this bill, I will rule that LD 1298 has ended, and I will close the meeting of this public hearing. Thank you again. I just lost my page.
I'll take over, Senator. We're
Yeah,
on.
is that yours? Yeah.
Yes, thank
Go
you.
ahead.
We're on LD 1585, Representative Lookner, an act to increase privacy and security by prohibiting the use of facial surveillance by certain government employees and officials. Take it away, Representative.
Thank you, Madam Chair. And I know it's been a long day, so thanks, folks, for sticking with it and giving us your full attention. Anyway, thank you to Senator DeChambeau, Representative Warren, honorable colleagues on the Committee of Criminal Justice and Public Safety. My name is Grayson Lookner, and I represent the neighborhoods of Libbytown, Nason's Corner, Rosemont, and Stroudwater in Portland. I'm here to introduce LD 1585, an act to increase privacy and security by prohibiting the use of facial surveillance by certain government employees and officials. Digital technology has upended our lives in profound ways in recent decades. And the fact that I am presenting this testimony to you via Zoom is enough proof of that. The convenience that technology affords us should not come at the expense of our most fundamental civil rights, however. Facial recognition and surveillance is one such technology. In limited, focused use, it has appropriate applications to prevent fraud and apprehend some people who have committed crimes. Without such narrow parameters, the technology undermines our constitutional rights, such as the right to privacy guaranteed by the Fourth Amendment and the right to freedom of movement guaranteed in Article 4 of the U.S. Constitution. States have a duty to act to regulate the use of this technology. There are concerns about the technology's accuracy, especially when applied to different populations. When studying the use of facial surveillance in the United Kingdom, researchers from the University of Essex found that the technology only produced verifiable results in 8 out of 42 instances. A Massachusetts Institute of Technology study demonstrated the technology is strongly biased towards those with lighter skin color and more masculine facial characteristics. These flaws are so severe that it has led to false arrests based on inaccurate identifications. Last year, one Detroit man spent 3 days in jail after being arrested in front of his 2 children. That man also happened to be Black. After the events of last year or surrounding police brutality towards people of color, it is not hard to envision a situation where such a false identification based on facial surveillance could lead to violence and needless death. We can prevent that from happening with the passage of this bill. This bill, with a few specific exemptions, prevents the use of facial surveillance technology by public officials, public employees, and law enforcement at the state and municipal levels. I have proposed an amendment to allow the Secretary of State's office to use the technology to identify potential fraud for driver's licenses. I'm also considering another amendment to this bill that would encompass more private entities like Clearview.ai, which is a website that maintains a database of billions of individual photos that can be used to identify people against their will for no reason whatsoever. Yeah, so I look forward to working with you all to create legislation that sensibly prevents the use and abuse of and the intrusive potential of facial surveillance technology in the state of Maine. So thank you for hearing my testimony. I'll do my best to answer any questions.
Thank you, Representative Lookner. We're going to take your first question from Senator DeChambeau.
Representative Lookner, I read your the original, and then I just saw the amendment. I want to be clear on that. On the amendment, it says amend the bill as follows in section 6001, subsection 2. Does that tell me that subsection 1, the definition is the same?
Senator, thank you for that question. I believe Secretary Bellows could answer that specifically. That amendment really has to do with allowing the Secretary of State's office to ensure that one individual isn't applying for multiple driver's licenses under numerous aliases. So that's what the amendment has to do with.
So that's okay, because that's all right, because it looked the same somewhat, but thank you for that. That's all I had.
Any other questions for Representative Lookner? Senator Searway, you have a question?
Yes, thank you, Madam Chair. Representative Lookner, have you found any evidence that this actually has happened in Maine for racial problems?
That's a great question. I haven't seen that it's happened in Maine, but it doesn't mean that it couldn't happen. I think we should do all in our power to prevent it from happening. I think other people on this call could talk about, the potential of it happening here, or if it hasn't already happened.
I'm just saying, it seems like we're putting an answer to where there wasn't a problem. So I'm just kind of wondering about that. Thank you.
Thanks.
Any other questions for Representative Lookner? Seeing none, thank you, Representative Lookner. Any co-sponsors or legislators here to testify? Seeing none, I'm going to open up testimony for LD 1585 for those speaking in support of the legislation. Good afternoon, Cade.
Hello, good afternoon.
Welcome, good to see you.
Good to see you. Shall I begin?
Yes, please.
All right. Senator DeChambeau, Representative Warren, members of the committee. Good afternoon. My name is Cade Crockford. I'm the director of the Technology for Liberty program at the ACLU of Massachusetts, where I work to protect and expand core First and Fourth Amendment rights and civil liberties in the digital 21st century. I focus particularly on how systems of surveillance and control impact not just the society in general, which they do, but their primary targets, people of color, Muslims, immigrants, and dissidents. I urge you to vote ought to pass on this important legislation. I have some experience working with this issue. In June of 2020, I worked with a large coalition and the Boston City Council to pass a ban on the possession and use of facial recognition technologies in all areas of municipal government. That unanimous vote at the City Council came after dozens of community members and organizations voiced support for the measure. And after then Boston Police Commissioner William Gross testified that his department does not use facial recognition, in part due to racial bias problems with the technology. Not a single person testified against the proposal, and less than a week after the council's unanimous vote, then Mayor Marty Walsh, who currently serves the Biden administration as labor secretary, signed the measure into law. Boston is a safer and freer community due to this historic law reform. Today, Black and brown people, immigrants, religious minorities, dissidents, students, and poor people do not have to worry that they will be wrongfully accused of a crime or secretly tracked by the government as they go about their business in their neighborhoods across the city because of facial recognition. People seeking substance use treatment or other sensitive healthcare services likewise don't have to worry that their identity will be cataloged by the government merely because they entered a facility in view of a surveillance camera. Thanks to the ban, the Boston Public Schools did not join many other school districts in using remote proctoring software during the pandemic. This technology has been the subject of litigation, student frustration, and community outrage across the country. Just like face recognition technology in use by policing entities, this technology built into remote proctoring systems can often fail when examining the faces of darker skinned people, which has led to complaints from students of color that they've even had to shine bright lights on their faces while taking remote exams in order to be seen by the technology. Boston's face surveillance ban has likewise protected the city from litigation that can arise after police rely on faulty face recognition data to make arrests. So as has been previously mentioned, over the past year, the public has learned about 3 wrongful arrests stemming from police use of facial recognition, all of those people Black men. One of those men, Robert Williams of Michigan, is currently suing the Detroit Police Department over his wrongful arrest. And Boston likewise doesn't have to worry that a surveillance contractor working for any city department will be hacked, enabling untold numbers of non-official persons to tap into the city's surveillance network and use facial recognition to track or identify ordinary people. And this is important because any sensitive data system is an attractive target for hackers, a real public safety concern. In March, reporters disclosed that a private surveillance company called Verkada was hacked, exposing surveillance feeds from 150,000 cameras across the country to untold numbers of unidentified persons. This company offered facial recognition as a service, meaning hackers may have been able to use their unauthorized access to these systems to track and identify people, including in at least one government-run jail. So in conclusion, Boston is a safer and freer community because of our ban. Our communities are freer to exercise their core rights, including their First Amendment rights to worship their religion and criticize the government without interference. Surveillance is not safety, particularly when the surveillance technology at issue, like this one, exhibits extreme racial and gender bias problems. I encourage the committee to vote ought to pass. This bill would keep Mainers safe from using unreliable, dangerous technology. Thank you so much for your time and attention, and I'd be happy to answer any questions the committee has.
Thank you for your testimony. We're going to start with Representative Morales.
Thank you, Ms. Thank you, Cade. I have a question around, I mean, is the technology there? And, is there a way to make this safe? And I guess specifically, what if the algorithms are better trained where the bias problems are removed? Would that make a difference?
So there are kind of two ways of thinking about this. In our view, face surveillance technology is dangerous when it works and when it doesn't. And it raises different problems depending on whether the technology is accurate or whether it's inaccurate. But to more specifically answer your question, there's a lot of debate in the machine learning and AI community about whether these technologies will ever be 100% accurate. And in fact, no technical systems are generally 100% accurate. Another thing that's really important to state is that when government entities like, for example, the National Institute for Standards and Technology, which is the federal government's nonpartisan technology evaluation board, when they in 2019 published a report about the accuracy of facial recognition systems, they reviewed about 200 different algorithms made by companies based both here in the United States as well as foreign companies that manufacture this technology. So they looked at hundreds of algorithms, but what's crucial to note about their study, and they found significant racial and gender, not only race and gender, but also age problems with this technology. They found that it did not work as well for children or elderly people. So in other words, they found that the technology really is only reliable for one tiny slice of the population, which is middle-aged white men. But what's really important to focus on with respect to those studies, including the NIST study that I just referenced, is that they're examining the reliability and the accuracy of facial recognition under the most pristine possible conditions. And so to give you an example of that, they're using full frontal, so that's like a picture of someone's entire face, well lit, right? So they're using images that are essentially perfect when they're examining the reliability of these algorithms. And when government uses this technology, they're frequently, and I think the RMV or the BMV in Maine's case is the exception here because they're using full frontal, full light images. But when police, for example, use this technology, they're often using very low quality, what are known as probe images. So, just think, for example, of a surveillance camera. It's high up on a traffic posts, maybe 15, 20 feet off the ground. They're taking pictures from strange angles. Somebody might be wearing a hat. Even if their face is completely exposed, it's coming from a strange angle under low light conditions. And those are the real world conditions that police are using this technology for. So if you look at the NIST study, those were perfect images, right? And even with perfect images, they found significant error rates and significant bias problems. When you apply the same technologies to real world images, these poor quality probe images, the rates of error are going to be significantly higher. And so, BuzzFeed News just published a story a couple of weeks ago about this company, Clearview AI, and law enforcement's use of it nationwide. And they quoted a couple of police officers from across the country who said they did try to use Clearview in their criminal investigations, but they stopped using it because it wasn't working. It wasn't effective. It didn't give them the information that they needed.
Well, thank you for that explanation. My thought around it in my only experience with this is my own computer, which I'm looking at right now, which supposedly is supposed to recognize my face. But when I'm up at 3 a.m, with my hair up like this and it's dark and maybe I don't have my glasses on right away, it does not recognize me. And so, that's only my non-empirical data evidence of that. But thank you very much.
Senator DeChambeau.
Yes, my question is for Representative, I think it's his bill, Representative Lookner.
Madam Chair, we are on testimony from Cade right now. Can you ask your question of the sponsor when we get to the work session?
Okay, yes, okay, yep.
Do we have any more questions for Cade? I have just a quick comment and then a question. I read the article about the work that you're doing in the New York Times, and I don't know why, but for some reason I'm pretty interested in this sort of technology. I also got some information about what's happening in China with this sort of technology, and that scared me very much. And it's one of the things that got me really interested in working on protecting our privacy. But could you tell me a little about what's happening in the Massachusetts legislature right now around the ban on facial recognition technology?
Yes, I'd be happy to. Thank you, Rep. Warren. So in Massachusetts, we've been working on this issue for a couple of years now. Last legislative session, my organization, the ACLU of Massachusetts, was supporting a bill that would have placed a temporary moratorium on all government use of the technology. After George Floyd was murdered in Minneapolis and the protests, engulfed the nation, Black Lives Matter protests spread throughout the country, the legislature in Massachusetts elected to take on police reform. And so as a part of that police reform legislation, the legislature looked at dealing with this issue, the issue of facial recognition in government use. The legislature enacted actually what would have been the nation's strongest protections on government use of these technologies. It would have effectively banned the vast majority of government use, not only of facial recognition, but of other what we call remote biometric technologies. So that is things like iris scanning, voice detection. Believe it or not, the shape of your ear is also a biometric, which just means that it's unique to every person. And these are all biometrics that can be monitored remotely without someone's knowledge or consent. So fingerprints are different because you actually have to put your finger down on a piece of paper. But these can be divined, frankly, from a satellite, from an image coming, from a camera coming from thousands of miles away even. And so they raise unique privacy concerns because, you can conduct surveillance of an entire population without their knowledge or consent based on their unique physical characteristics. So again, the legislature enacted in the House and Senate a bill that would have, for the most part, banned government use of this technology, making a couple of exceptions, one of which was for the fraud identification purposes at what we call the RMV, the Registry of Motor Vehicles, to continue. And another would have been to create a very small carve out to allow the police, when investigating violent felonies, to obtain a warrant and to go to a judge, and get a warrant, and then ask the RMV to perform an image search to try to identify someone in a very serious criminal investigation. And that legislation, again, was enacted. Governor Baker refused to sign it. So we ended up with a very watered down set of regulations that are set to go into effect in July. We are currently working to support legislation that is essentially identical to what the legislature initially enacted. And I'll just say a couple words about that. The way that I think about it, there are three different ways that governments can use facial recognition. One is to try to identify someone in an image. So that is like you have a picture of somebody and you want to put a name to that person's face. I call that image matching or identification. There's a second way the technology can be used, which is to conduct surveillance, right? You have a camera outside a building and it's trained on the door, and you're just automatically downloading a list of the names of every person who walks in that building. Or you have a camera in a public space and a government agency wants to find a particular person. They're able to get an automatic alert when that person walks past a camera. That's the type of stuff that the government in China is doing. And I personally think that that ought to be prohibited permanently in the United States. It raises way too many concerns about our First Amendment rights, our Fourth Amendment rights, our rights to associate, to speak our minds freely. There's a third use too, which is so-called emotion recognition. So there are some companies that are manufacturing software that purports to be able to discern how someone is feeling based on the physical characteristics of their face. There have been a lot of studies to show that this is essentially junk science. One of the reasons is that there are a lot of cultural differences between how people express their emotions on their faces. And so it's not possible for human beings to discern how someone is feeling based on looking at their face. And therefore it's not possible for a computer to do it either, because we, after all, are teaching these computers how to interpret. That's how machine learning works. We teach the computer essentially, and then the computer learns on its own based off of what we've taught it. We also believe that ought to be prohibited permanently. The worst case scenario there would be in 20 or 30 years, somebody being convicted in part on the basis of a computer saying, well, this person was being deceptive when they said they didn't commit the crime, right? We shouldn't get into that kind of territory. So the bill that we're working on in Massachusetts right now is largely a ban, but again, contains these two exceptions to the ban, one of which is that the registry is able to continue using facial recognition for fraud identification. And the other is that in the most serious types of criminal investigations, not petty theft or vandalism or trespassing, but in murder cases, in kidnapping cases, in arson and rape cases, if they have a good picture of a suspect, they are able to go and get a warrant and then try to identify that person using the RMV's technology.
Great. Thank you for that. Senator DeChambeau.
Yes, that last statement makes me question more. Ms. Crawford, excuse me, you made a statement in Massachusetts to ban all agencies from using this. And then the second sentence was, well, for the most part. And then the third sentence was, except for Secretary of State fraud. I don't know, and I guess I've been told that I don't believe our state police use racial recognition. I'm not sure of that, and I'm sure someone's going to come and testify, and I can ask that question. Can you explain to me? I don't understand why the Secretary of State, I don't know what fraud. Fraud is unlawful anyways, but what is, oh, there she is. I didn't know you'd be there, Secretary of State Bellows. So I guess I could direct that question, but in Massachusetts, I guess it applies to Maine also. Could you give me your version of why that's excluded from the prohibition?
Absolutely.
Absolutely.
You. I'd be happy to. So this history actually goes back quite some time. So the state of Massachusetts began using facial recognition technology in the licensing process to identify fraud way back in 2006. So they've been doing this for quite some time. It's a highly institutionalized process. The state has poured millions and millions of dollars into it at the RMV. And Massachusetts isn't alone. As far as I understand, every state has a system like this. There was a federal grant program in the early 2000s from, I believe, the National Highway Traffic Safety Administration that granted millions and millions of dollars to state licensing agencies to obtain this software so that they could ensure that people were not, obtaining two licenses, one under a fake name. So the reason why the ACLU is not opposing that particular use is really twofold. One, because as I mentioned before, it doesn't speak to the most dangerous uses of facial recognition that we are really most concerned about. It doesn't implicate First and Fourth Amendment rights to the degree that, that would raise serious concerns about someone's ability to freely associate or worship their religion or protest the government without being identified. It doesn't raise concerns about someone being, wrongfully arrested for, a murder that they didn't commit. It really is a very narrow government use. The second reason is more sort of political and practical. It's that it's been in use for over a decade in Massachusetts, approaching 2 decades now. And there's no political will in the Massachusetts state legislature to undo all of that work, essentially.
I'd like to ask a follow-up question.
Yes, please.
In the event in Massachusetts, if facial recognition does appear that someone is trying to commit fraud or get a second license, is there a penalty for that or some retribution?
So my understanding, and I have to be honest, I'm not a full-on expert on the processes that the RMV engages in with respect to their internal investigations. I know a little bit about it. I don't know everything about it. From my understanding, what happens is that, and this is really important too, the decisions, the feedback that the machine learning, that the facial recognition program provides to the registry here about, licensing and fraud is not acted upon automatically, right? So every day these searches are performed for every person who goes in to apply for a license or to renew their license. And whenever there's an anomaly, right, whenever the technology identifies that someone, may be committing fraud, there's a process where human beings review all of those records. And so, believe it or not, and you'll probably hear this from the Secretary of State in a minute, most of the time it's actually that someone's a twin, right? And it's a totally innocent explanation. And so for those cases, nothing happens, right? The person's, application proceeds, they get their license, no big deal. In some cases, it is actual, there are signs that there actually may be fraud. And so my understanding of that is that a state police officer who's assigned to the registry initiates a criminal investigation, and they start to look at, whether or not this person, may have actually tried to commit fraud. And if they have, then, I believe that they use whatever tools and statutes are at their disposal to deal with that. And yes, I think it is a criminal issue.
Thank you. Thank you.
Any other questions for Cade? Seeing none, Senator Searway.
Thank you, Madam Chair. Thank you for coming. This seems like it goes both ways on facial recognition, depending on the times of what events happen. And this seems to come on the racial end because of what had happened on a couple of events that's happened in the last year or two. But also we had 911. We could have had facial recognition, would have helped a lot here in Maine if we had known those people came through by the airport or whatever. Or it might be at the bombing in Massachusetts. All these situations, it seems like it's a wave. And how do you feel about that? I mean, when these things happen?
I really appreciate that question, Senator. Thank you. I think the question about terrorism is particularly important. People watch a lot of movies and television shows in this country about, miraculous technology that facilitates incredible efficiencies in criminal investigations. Movies that show us that the facial recognition found the terrorist and stopped the bomb. And that's not real life for a couple of reasons. One of which is that if take 9/11, your example of the hijackers traveling through Maine and then coming actually through Logan here in Boston. If the government had known that those people were planning to, blow up the Twin Towers and cause so much chaos and mayhem and death, they would have been stopped, right? And facial recognition did not have to be a part of that. They would have been stopped because someone at the airport would have reviewed their travel documents and pulled them aside. Facial recognition is not a good solution to stopping terrorism for one core reason. In order for facial recognition to work in that situation, you have to know who the terrorist is. And terrorism is a problem because it is so rare that, government agencies are always taken by surprise. They don't know these events are going to occur. And therefore, a technology that is fundamentally about identifying individual human beings is completely ill-equipped to address the problem of terrorism. The Boston Marathon is a good example of it as well. In that case, the tragedy occurred, and sorting through many, many reams of images and video, investigators were able to narrow down some images, the famous images, the white hat, black hat images of the Tsarnaev brothers. And in fact, the FBI claims that it did try to use facial recognition to identify those brothers, both of whom, by the way, had Massachusetts driver's licenses, both of whom were in the Massachusetts RMV's database, and they say the technology didn't work. Another way to address that question is that if Maine were to ban facial recognition, to pass this bill as written, it would not have any impact on the Federal Bureau of Investigation and their ability to use their own expansive facial recognition system to conduct terrorism investigations. Again, in Massachusetts, we have gotten to the place where we are ready to support legislation that does have a carve out for law enforcement's use of just one system, the RMV system, as well as the FBI system, with a warrant in serious criminal investigations. So if your concern is that, there may be some situations in which there's a very serious crime and the police have a picture of someone and they just need to put a name to that person's face, that would be something that, at least we at the ACLU of Massachusetts find would be a reasonable exception to this general prohibition on government use.
Well, we also had the Washington DC situation where they are using facial recognition trying to locate them. And then also there's, I was in a town office the other day and this person came in and tried to use his credit card and said, to pay his taxes with. And he said, that's, go ahead and pay it. And it wasn't his. And so she asked to see his license. It had a picture of him, which if they get rid of facial recognition, that could be the next step, try to get rid of pictures on your license. And I see you smiling. So what I'm saying is, there we go. We're taking step by step to get rid of all this information. And so to me, he could have pulled some fraud on and found out that it wasn't his credit card.
Well, I'm smiling because, I would love to live in a world where we didn't all have, our most sensitive data stored in various government databases all across the country. But that is certainly not the world that we live in today. We are far past the point of, turning back from state identification documents. But to your larger point, I think this is actually really important. Earlier I heard a comment to the effect of, why are we dealing with this? This is a new issue. This doesn't affect Mainers. For far too long, our approach in legislatures and certainly in Congress has been to say that corporations and government entities can do effectively whatever they want with new technologies, that there are no rules at all until something goes tragically wrong. And then all of a sudden people start to think, okay, wait a second, we need to impose some rules here. Or like with the not license plate readers, cell phone location tracking, a case eventually gets to the Supreme Court, like we saw with the Carpenter case in 2018, saying that police have to get a warrant to access cell site location information. I know that in Maine, you all did that many years ago. So kudos to you for that, for your wisdom on that. But the point is that we should not allow technology and the possibility of certain surveillance systems existing in various spaces, controlling us in various ways in our lives, dictate what our freedoms look like. In a democratic society, we ought to be the ones that are drawing the lines in the sand and saying, this is actually inappropriate. We don't want to go down the road that China, for example, has gone down, where everything is fair game, where you can be tracked everywhere all the time. I believe that it's preferable for legislatures, especially in states like Maine, which have demonstrated time and again that they are really committed to personal privacy, to say, no, we're going to create some rules. And, a general prohibition or a prohibition that covers most areas of government, I think is a good rule. If you later learn down the road, there's a particular way in which this one government agency could be using this technology in a way that does not violate civil rights and civil liberties that Mainers are comfortable with, then you can, tinker with the legislation later on down the road. But I think the general, way that we've been dealing with privacy and technology issues has been to say anything goes, let's just put the technology before the policy. And I think that's really backwards. I think we ought to be putting the policy first and then sort of tinkering with the policy as we see the technology develop, not the other way around.
Thank you.
Thank you, Cade. It's so helpful to have an expert here. I'll just let all of you know, for those of you who served on the Criminal Justice Committee for a long time, Omi Amarosingham. And Omi Amarosingham, also an expert, is married to Cade. So I wanted to make that connection for you all because we all miss Omi and her work. So Cade, thank you very much for all of that information. I don't see any more hands up. So I'm going to move to the next person here to testify in support. And that is Madam Secretary, my former senator, Secretary Bellows. Thank you for being with us.
Thank you, Representative Warren, Senator DeChambeau, and distinguished members of the Joint Standing Committee on Criminal Justice and Public Safety. I am Shanna Bellows. I am Secretary of State and representing the Bureau of Motor Vehicles today to speak in support of LD 1585. The right to privacy is a key component of the First Amendment right to freedom of speech and association, as well as the Fourth Amendment right to freedom from unreasonable searches and seizures. Facial recognition technology has the power to completely eliminate privacy in public spaces with serious consequences for civil liberties, should it be deployed on a widespread basis without limitation. In the interest of defending the right to privacy, it is incredibly important that policymakers put in place limitations on the deployment of facial recognition technology. That's why we support the underlying premise of this bill. Maine has traditionally been a leader in protecting our constitutional freedoms and should continue to do so. At the same time, as has been discussed, there are some narrow legitimate uses of facial recognition technology to advance the public good without harm to civil liberties. One example of the use of facial recognition technology is found in Title 29A, Section 1401, which permits the Secretary of State to use facial recognition technology for the issuance of a driver's license or identification card. So how does it work? Currently, the Maine Bureau of Motor Vehicles utilizes image verification technology through a vendor called IDEMIA for the issuance of the licenses and ID cards. The software operates by using the characteristics of an individual's face to compare images. The program does not generate leads based on race, gender, or ethnicity. Leads are created through an analysis of the distance between known points in comparison to other images. The software runs two basic screening processes to identify potential fraud. First, new images that are captured, for example, at our branch offices when they take your picture, are processed and compared to existing records to verify whether that image matches other images that exist for that particular person. So this protocol ensures that the current applicant is the same individual that previously obtained a credential under that history number or in that person's name. This security check protects applicants from potential identity thieves that may be trying to obtain a credential in another person's name. A second screening is run that compares the newly captured image to all other images that are in the BMV database. This search identifies potential leads for individuals that have multiple credentials. So that would be a different type of fraud. It is important to note that the customer is generally not impacted by the use of image verification technology. Branch transactions are processed without impeding the customer. All image verification leads are reviewed by BMV staff daily, and most leads are cleared without further action, and credentials can be processed according to normal procedures. If an image cannot be cleared, it is referred to further investigation. Now, the BMV has 14 investigators who are members of law enforcement who protect Mainers against identity theft, fraud, and many other things, including stolen vehicles and the like. Through the investigation process, the images are compared more closely and background data may be gathered on the individual. Most images are cleared through investigation as non-fraudulent behavior. An example of this would be the first appearance of twins. Once twins have been identified, they are noted in the system and they will no longer match in the future. In some cases, the investigation reveals that an individual is a victim of identity theft. In those cases, detectives assist the individual with securing their identities and helping them to prevent fraud in the future. And when fraud is detected, the fraudulent transactions are investigated and referred for administrative or criminal proceedings. The software is in place to safeguard the identities of Maine credential holders and to maintain the integrity of the BMV database. This BMV system is a standalone system. It is not accessible to any other agencies. The system relies on high quality photographs to generate the leads and is not used in any form of surveillance operations. We appreciate the sponsor's willingness to amend the bill to ensure that the BMV is able to continue to do this, to protect Mainers from identity theft or license fraud, and the proposed amendment is before you. It would add a subsection C to section 6001 2. I'd be pleased to answer any questions. We're happy to work with the committee on this amendment and any other policies to safeguard privacy and civil liberties. Thank you for your consideration.
Thank you, Secretary Bellows. Questions from the committee? Senator Searway.
Thank you, Madam Chair. Madam Secretary, I was wondering, has there been an issue with facial recognition here in Maine?
So this technology was adopted in 2019. Maine was a late adopter. This is a very narrow use of facial recognition technology, and I think that's what's important. I think what we see in China, where facial recognition technology is being used to capture images of everyone walking about in their daily lives or gathering in the public square for a protest or something of that sort, is contrary to the Constitution, right? To the First Amendment, the Fourth Amendment. And so that's why I think it's important, you know, when you look at Title 29A and what the legislature did in 2019, there are very specific rules about when and how the Secretary of State may use biometric technology. And there are some limited exceptions that fortunately we have not had to use, but that does allow a specific search to aid only in emergency circumstances, I'm quoting from the statute, involving an immediate threat to the life of a person. That's the type of very careful policymaking that was done in 2019 that I think is part of why we're supporting this bill today. There's some legitimate uses, but they should be very specific and narrowly tailored to avoid violations of the Constitution.
So, is this something that's looking at what could come to Maine, or is it? Is this what change is this doing to what we currently got?
So I think the change that would be, in some ways, your question reminds me of when we had conversations about drones, right?
Right.
So we had some conversations in several legislatures ago where at the time the question was, well, is anybody using any drones? And the answer was no, but here, I remember I brought one to the State House because you could get it on Amazon for like $100. And, and so, you know, the legislature at that time decided to move forward with some safeguards saying, you know, the use of drones is authorized in some circumstances, but not every circumstance. So it wasn't a blanket ban, it was rules and procedures. And sure enough, soon thereafter, we've seen, you know, the acquisition of some drones by government in the state. It's not yet widely used, but there has been some acquisition. So similarly, facial recognition technology through IDEMIA has been adopted by the Secretary of State in 2019. To my knowledge, it has not yet been adopted by another agency for another purpose. But it is appropriate perhaps to put the rules in place prior to adoption to make sure that people don't make investments with assumptions about certain practices that then need to be curtailed. So I think that this is taking that sort of proactive approach of saying, what are the rules under which we want to allow this to be deployed? And when do we not want to allow this to be deployed?
Thank you.
Other questions for Secretary Bellows? Senator DeChambeau. You're on mute, Senator.
Thank you. I had asked other people, did you? Okay, I got it out. These questions, I might as well direct them to you, Secretary Bellows. Title 29A, Section 1401, you mentioned, I guess it was public law just a couple of years ago, correct?
That's right.
So before that, there was no subsection 9 that spoke about the Secretary of State. Is that correct?
I would have to double check that for the work session, but that is my understanding. And I did check with the chief detective, and he confirmed that we did not, the detectives did not have access to facial recognition technology until 2019.
So since that time, 2019, you have 14 investigators who can now use that, correct?
So there's the BMV has long had an enforcement division with investigators. That's a longstanding practice, and there are many other things that the investigators do. Investigating when people are engaged in fraudulent vehicle registrations or vehicle theft, or selling lemons or things that they shouldn't be selling. There are a lot of things that the investigators do. And the investigators have always engaged in protecting against license fraud and investigating identity theft. But identity theft is very much on the rise. So I think we're seeing rates nationally of identity theft at levels, even here in Maine, we had the identity theft that led to the unemployment fraud through impersonation. So I think that's a real challenge, and the IDEMIA technology has created a very powerful tool to do those searches, to make sure that when someone, if someone goes to a BMV branch and asks for a license for Shanna Bellows, that they can use the facial recognition technology to make sure that it's me and not someone else who may have obtained my social security number and other details fraudulently and is fraudulently impersonating and presenting as me. So I think that's a legitimate, important safeguard and use of the technology, just as Representative Lookner has acknowledged in the bill text. It's not that it can never be used, but it needs to be carefully regulated. I would feel very uncomfortable, for example, if there were, if there was universal access of, those images are really important to safeguarding people's identities as well.
A follow-up, Representative Warren?
Yes, you may.
So I'm not sure, but I've heard that law enforcement, state police in particular, do not use facial recognition. You're okay. So this bill prohibits them from instituting that, correct?
I think it would be useful to ask the sponsor or public safety to evaluate what the bill does and doesn't prohibit. I can speak to the BMV. When I read the bill, Section B has some important exceptions. So there's nothing that would prohibit law enforcement from using evidence related to investigation of a specific crime. There are a few other uses, but that's a better question, again, to evaluate in the work session with a sponsor and perhaps the ACLU.
Thank you.
Yeah.
Thank you very much.
Thank you.
Any other questions for Secretary Bellows? Seeing none, thank you, Madam Secretary.
Thank you.
Next up, we have Michael Cabetta.
Thank you, Representative Warren, Senator DeChambeau, and exhausted members of the committee. Good afternoon. My name is Michael Cabetta, and I'm Policy Counsel for the ACLU of Maine. And on behalf of our members, I urge you to vote ought to pass. In response to Senator Sirway's question, if it doesn't happen here, then why ban it? My answer is for the same reason that you would get a flu shot before you got the flu. The flu that this bill would protect us from is very serious. There was a bank robbery in Denver a few years ago. A security camera there picked up the robber's face. Local police decided to use facial recognition to match that person with faces in their database. They zeroed in on a man named Steve Talley. They went to his house, threw flashbangs, and arrested him. He was a banker. He had a wife and children. He was a white man. Charges were eventually dropped against him, but his wife filed for divorce and he lost custody over his children and he lost his job. That threat, experiences like that are exacerbated for women of color, for immigrants, but they exist for everyone. Face surveillance technology poses an unprecedented threat to civil rights, civil liberties, and an open democratic society. Maine should join our state's largest city in prohibiting the use of this technology by government officials with certain exceptions. I've submitted extensive written testimony outlining all the reasons and citing research about why this technology is so threatening and so unreliable. I'll just mention a couple of the reasons quickly. It enables the government, if deployed on a mass scale, to identify people while they're exercising basic rights that are protected by the First Amendment to the US Constitution. Freedom of speech, freedom of the press, freedom of association, and free exercise of religion are all at risk if the government can easily and continuously track our public movements. This technology also threatens our Fourth Amendment right to be left alone. The government's use of face surveillance allows officials to keep tabs on all of our public movements and activities very easily. These are just two risks that I'll highlight now, but the others are contained in my written testimony. We urge you to follow the bans in 15 communities around the country, including 7 in Massachusetts, and a ban of facial recognition used by police in Virginia, and vote ought to pass. We enthusiastically support the amendments put forward by the Secretary of State. I thank you for your time and attention on this long and exhausting day, and I would be happy to entertain questions.
Thank you. Any questions for Michael Cabetta? Seeing none. Thank you. We also have Anthony, and I can't see your last name, Lombardi. Welcome, Anthony.
Thank you. Can you all hear me?
Yes.
Great. Representative Warren, Senator DeChambeau, and honorable members of the Committee on Criminal Justice and Public Safety, good afternoon. I know it's been an incredibly long day. My name is Anthony Lombardi, and I'm a legal fellow at GLBTQ Legal Advocates and Defenders, New England's leading legal advocacy organization for LGBTQ rights. And I'm also a lobbyist associate of Mary Bonato, who lives in Portland. GLAD, alongside Equality Maine, the state's LGBTQ civil rights organization, right to share their support for LD 1585. We believe this technology can create problems, not solve them, and that ordinary people will be hurt along the way. The misapplication of facial recognition technology in perpetuating gender and racial biases is well documented, so we speak to provide additional context to illustrate the clear dangers that implementation of this technology poses for members of the LGBTQ community. GLAD and Equality Maine adamantly oppose any practice that perpetuates racial, gender, or economic injustice, and we urge this committee to carefully consider all the privacy and equity concerns raised, including from our peer organizations such as the ACLU of Maine and Massachusetts. Now, a fundamental flaw in technology design in which facial recognition routinely fails to identify transgender and non-binary individuals has severe implications for our community. Inadvertent disclosure of transgender identity exposes trans individuals to a range of negative outcomes, from denial of employment, housing, and public benefits, to as far as harassment and violence. Further, some research suggests that facial recognition technology can be designed and used in a way to identify, target, or catalog individuals based on a presumed sexual orientation, oftentimes and almost definitely inaccurately. This raises considerable privacy concerns because if previously undisclosed status is gathered or inaccurately presumed by government officials, or if that information is distributed to the public without the individual's consent, like mentioned before in a data breach, members of the LGBTQ community face a very real threat of harassment, discrimination, or violence. And this threat may be particularly acute for intersectional members of the LGBTQ community, individuals who are of color or indigenous. And solving the current failures of this technology and facial recognition, even if it were possible, would probably not make it any more suitable for use by public entities, including law enforcement. Discrimination against transgender individuals remains widespread. Relative to the general population, LGBTQ people are more likely to experience homelessness or to engage in sex work because of job discrimination and hostility, and this exposes them to frequent interactions with law enforcement and the criminal legal system. These contexts place them at heightened risk of abuse from the use of the technology, and given the racial and gender biases and stereotypes upon which this technology relies, there's a particular equity concern for intersectional folks and all BIPOC people for that matter. The threats of misidentification posed by facial recognition for all individuals speaks to the urgency of the policy position of LD 1585. All of us deserve the right to live openly and freely without the threat of surveillance or cataloging of our identities and movements by public entities and officials in the ordinary course. Passing LD 1585 also removes a contentious issue from attempts to reset the relationship in Maine between the police and those who are policed. And I see that my time is up. So I thank you for your time. It's been an incredibly long day, and I applaud you for your endurance. I'm happy to answer any questions.
Thank you, Anthony. Any questions? Seeing none. Thank you so much for hanging out with us all day.
Always a pleasure.
Anyone else here to testify in support of LD 1585?
I'm bringing over one more person. Hand just
Thank
went.
you. Good afternoon, good evening, Jan Collins.
Thank you. Can you hear me?
Yes, perfectly.
Super. I've had technology issues today. Senator DeChambeau, Representative Warren, and honorable members of the Criminal Justice and Public Safety Committee. My name is Jan Collins, and I am Assistant Director for the Maine Prisoner Advocacy Coalition. I'm here today to speak in favor of LD 1592, an act to increase privacy and security by prohibiting the use of facial surveillance by certain government employees and officials. I am not much of a photographer, but when I do occasionally take a few photos and upload them to my computer, I label the people in the photos. The Photos program on my computer uses facial recognition to suggest names for the people in the photograph. The more pictures I take of a particular person, the more accurate the suggestion. But sometimes, even with lots of photos, the suggestion made by my computer is bizarre. I look at the suggestion and say to myself, maybe out loud, "What? How could you possibly think that?" Yes, I talk to my computer. Cameras are ubiquitous today. Even out in the middle of the woods, you may come across the game cam. If you knock on someone's door, you may be on their surveillance camera. Some of those cameras are recreational, some for security, and some for science. None of them should be for government surveillance. Our government should not be spying on average citizens going about their daily work. It exposes all of us to the imperfections in technology, to the possibility of mistaken identity, and to accusations of criminal activity that we did not commit. I am particularly concerned that facial recognition technologies' imperfections are lopsided, posing a grave danger to the people who are already over-policed and adding to the inequities of the criminal legal system for people of color. But it is not just people of color. It is also children and the elderly that the facial recognition technology frequently misidentifies. Although I do not yet fit the category of elderly, I can see it from here. And the idea of being wrongly accused in my sunset years does not appeal to me. The US government studies have confirmed the biases in facial recognition technology, calling into question the efficacy of its use. I ask you to do the same. This technology is more detrimental than beneficial and should be banned. Please support LD 1592, an act to increase privacy and security by prohibiting the use of facial surveillance by certain government employees and officials. And I do thank you for your very, very, very long day.
Thank you, Jan. Any questions for Jan Collins? Seeing none, thank you so much.
Thank you.
I'll now take testimony in opposition of LD 1585.
We had one person signed up, but I think we've lost him.
Okay. Thank you, Deb. Anyone here to testify neither for nor against LD 1585?
I'm bringing over Brian Scott.
Thank you. Hello, hello. Thank you for joining us.
Absolutely. Representative Warren, Senator DeChambeau, and other distinguished members of the Joint Standing Committee on Criminal Justice and Public Safety. My name is Major Brian Scott, and I'm here to represent the Maine State Police and the Department of Public Safety, testifying neither for nor against LD 1585. Facial recognition technology involves the ability to examine and compare distinguishing characteristics of a human face through the use of biometric algorithms contained within a software application. This technology can be a valuable tool to detect and prevent criminal activity, reduce an imminent threat to health or safety, and to help in the identifications of persons unable to identify themselves or deceased persons. The result of a face recognition search is only used as an investigative lead and is not to be considered a positive identification of any subject. Any possible connection or involvement of any subject to the investigation must be determined through further investigation and investigative efforts. While the Department of Public Safety and the Maine State Police do not currently own or operate a facial recognition system, there have been instances where we have utilized other states' systems who do use it to support criminal investigations and in the aid in the identification of a victim of violent crimes in Maine. In reviewing the bill and in talking with the bill sponsors, we understood that while this bill creates an outright ban on the use of facial surveillance or facial recognition software by certain government officials, namely law enforcement and public safety officials, it also understanding that it does create some important exceptions to that ban pursuant to section 6001 2B. We feel the language for these exceptions could be reworded and more prescriptive to make it clear that there are allowable uses for the technology. We recognize that with new and emerging investigative technologies, there can be concerns surrounding privacy, civil rights, and civil liberties. We believe those concerns can be balanced with the value that these technologies can have on criminal investigations and public safety, and to ensure we are making the most effective use of public resources allotted to public safety agencies. We feel that this can be addressed by ensuring that agencies who do own and operate these technologies have policies and principles in place governing the collection, access, use, dissemination, and retention of facial recognition programs. These policies will ensure that all facial recognition's use is consistent with authorized purposes. We will urge the committee to take a look at the statutory rule that was already mentioned earlier by Madam Secretary Bellows. That's in Title 29A, Section 1401, subsection 9, that was passed by the 129th legislature. On behalf of the State Police and the Department of Public Safety, we'd appreciate your careful consideration of the issues that we just outlined. I thank you for your time. I'm happy to try and answer any questions that you might have.
Thank you, Major Scott. Any questions for Major Scott? Seeing none, thank you for being here at the beginning of the day and the almost end of the day. Senator Searway.
Thank you, Madam Chair. Major, good afternoon. I was wondering if you can, is the amendment already in there, or are you saying that there should be an amendment in there that you would agree to? And what was your thought on that?
So thank you for the question, Senator Searway. So there was an amendment that I heard referenced earlier, put in at the request of the Bureau of Motor Vehicles, but I have not seen that. So the rest of the wording, if that wasn't changed, it would appear to be from our read to contain a couple of areas of direct contradiction, one section to another. And what I would point out is looking at the first page of the original bill under not the definitions, but going right to number 2, which is the public employee or public official use of facial surveillance. It says a public employee or public official may not. You can't obtain, retain, possess, access, or use a facial surveillance system or information derived from the system. But then in paragraph B below that, it seems to authorize its use for limited purposes, but the language is so confusing that we truly don't know what it means. I know that Lieutenant Johnston had a chance to speak with the representative regarding the bill, And we believe the intent would be something that we are agreeable to, that it should be prescriptive in nature, and it should only be used for criminal investigations or maybe an investigation to identify a person. And the only reason why I add that is looking at paragraph B in the original bill. It says nothing in paragraph A prohibits a public employee or public official from using evidence relating to an investigation of a specific crime that may have been generated from a facial surveillance system. So the confusing part for us is it says generated from, but in the initial restriction says we can't use it. So as an example, we had a homicide in Rangeley, Maine, a couple of years ago. The person who was deceased didn't have any identification on them, and we didn't have any witnesses right in the area to help us to identify that person. Well, one of our detectives on scene was aware that there were other states that did have some of this technology, and they might be able to help us. And we had some indications from the evidence on scene that the person may have traveled from Massachusetts to Maine. So through the use of a coordinated effort with our fusion center, also known as the MIAC, they coordinated with Massachusetts authorities, I believe through their fusion center, and we were able to take a picture of the deceased here. They were able to run that through a database that they had, and it helped us to start the investigation regarding a presumptive identification of the individual based on a record that we did receive, and it was later determined to be a positive identification through the medical examiner's office. It was a tremendous tool to help us to focus the investigation. So in that case, the lead, so to speak, wasn't generated from the facial recognition like as its origin, it's we requested it. So the way that it's worded, we're confused. Would we be allowed to request that and then have that potential response from another system and be able to use that tool? But an example that I haven't mentioned yet is we investigate a lot of cases where we have John Doe and Jane Doe, folks who are deceased. And it may not be a crime. It could be a natural death, and we may want to try to use that technology. And so the way that it's currently readed, it would say a specific crime. And we were thinking if it said a specific crime or for the furtherance of, identification of a deceased person or a missing person that's not able to communicate or something along those lines, that it wouldn't restrict us and lack, putting us in a position where we lack the ability to try to, further investigation. However, it would balance those privacy interests that have been raised today that we think is the responsible thing to do with any technology such as this.
Thank you. Madam Chair,
Yes, Senator Searway.
would it be okay if he developed an amendment to work with Representative Lookner on that?
I think he and Lieutenant Johnson are already working with Representative Lookner. So let's
Okay.
get a look at that amendment. I agree. It sounds like we want some changes, but I think Representative Lookner is already working with them, and we'll see
Great.
that at the work session.
Good, thank you.
Yes, thank you. Any other questions for Major Scott? Seeing none. Thank you, Major. Have a good night.
You're welcome. Thank you. You all also hope you get some rest this evening. I know it's been a long day.
Thank you. Anyone else here to testify neither for nor against LD 1585? Seeing none. Oh, excuse me, Representative Pickett.
Yes, Madam Chair, I just wanted to let you know, I did put in a text message to Sheriff Morton to see if he could locate Sheriff Carroll, who I think they were going to testify against, and he had left the room. He'd been around all afternoon, but left. But I have not got a response yet, and I see he's still not in the participants list. So I don't see I don't know. I don't see there's any reason to wait around. We've got his testimony. We'll have to read that, but I did try to reach out to him.
Thank you for doing that. Yes, I'm looking to see. Oh, I see. Okay. We do have his testimony. I couldn't find Major Scott's testimony. I see that he was going to testify, but maybe it just hadn't loaded by that point. I'll keep looking for that. There you are.
It's in there.
It has loaded. Okay, great. Thank you. All right, so we'll read the sheriff's testimony as well. I will then close the public hearing on LD 1585 and open the public hearing on LD 1473, an act to exempt land-based aquaculture facilities from the Maine Uniform Building and Energy Code requirements. And Deb, when you get a second, could you bring in, you're already on it.
Leave it to our good friend to have us here the last thing in the evening.
My former co-chair. I miss you, Senator Rosen. Good to see you.
I miss you too.
Welcome.
Thank you. Senator Deschambault, Representative Warren, I think that was either tank or tissue with you, and distinguished members and friends of the Joint Standing Committee on Criminal Justice and Public Safety. I am Kimberly Rosen, and I represent Senate District 8, which includes many towns in Hancock and Penobscot County, including the city of Brewer. Today, I am presenting LD 1473, an act to exempt land-based aquaculture facilities from the Maine Uniform Building and Energy Code requirements. As a senator and longtime resident from Bucksport, I am introducing LD 1473 to update Maine law for the purpose of providing regulatory clarity and parity to an emerging, exciting industry for Maine, particularly for Bucksport. In 2014, Bucksport lost a major part of our community, a paper mill that had operated in our town since the early 1930s, employing literally thousands of Mainers and providing tremendous community benefits over the years of its operation. While the town was devastated to lose this longtime economic engine in our region, we stood proud and opened ourselves up to the future. We were thrilled when we were approached approximately 4 years ago by a company known as Whole Oceans. Whole Oceans expressed a desire to locate a land-based recirculating aquaculture system on the site where the paper mill had once operated. This was music to our ears. Land-based recirculating aquaculture systems are in operations in other parts of the world, such as Norway and Finland, but it is a new industry to the United States and to Maine. We are excited to become the home to one of the first of its kind in the United States. In this type of system, fish are grown from eggs to maturity in tanks on land. Since its arrival, Whole Oceans has purchased the land and applied for and met the requirements to receive the environmental permits needed to build the facility. We are excited and anxious for them to move the project forward. But we have a law on our books that is creating an obstacle to them in their design phase of the project. LD 1473 has been submitted to address the obstacle. LD 1473 clarifies that land-based aquaculture facilities will be treated the same as buildings that house livestock and harvested crops under the Maine Uniform Building and Energy Codes, also known as MUBEC. This clarification is needed because land-based aquaculture facilities are a new industry in Maine, and our current laws do not provide clarity that fish are livestock under MUBEC. So this bill provides that land-based aquaculture facilities will be exempt from MUBEC, treating them the same under MUBEC as buildings that house livestock and harvested crops. Of course, when the Maine legislature enacted MUBEC, the raising of fish on land was not contemplated. And when the Maine legislature enacted many other laws that address and define livestock, again, the raising of fish on land was not contemplated. We need to modernize our laws to stay abreast of agriculture developments. Maine is a large food producing state, and adding land-rich raised fish is a large food producing state, and adding land-raised fish is our food product lines will strengthen our brand. The benefits of land-based aquaculture are many. Raising fish domestically will reduce greenhouse gas emissions from the importation of fish. It is noteworthy that the United States imports more than 90% of the Atlantic salmon consumed in this country. Maine could play a significant role in reducing those emissions. Also, the demand for fish as protein source continues to increase, and that demand cannot be satisfied by increasing the catch of wild stocks which are already being fished at their limits. Finally, other states are competing for the land-based aquaculture industry to locate in their states. Maine is uniquely positioned to gain an edge in this industry if we can treat this industry fairly and on par with other agriculture endeavors. LD 1473 makes perfect sense. Fish raised for human consumption in large tanks on land covered by a steel building are an agriculture endeavor, the same as raising cattle or sheep producing food for human consumption. It makes sense to treat the buildings that house them the same under MUBEC for building and energy code purposes. They will still have to meet fire codes and other professional design codes to ensure safety and stability requirements. The Department of Economic and Community Development will be offering a small amendment to clarify that only buildings that exclusively house aquaculture facilities are exempt from MUBEC and not buildings that have mixed uses or multiple occupants in which land-based aquaculture facilities are only a part of the building purpose. Thank you for your consideration.
Wonderful. Thank you, Senator Rosen. And we're going to go to questions. And I have first Representative Pickett and then Representative Morales.
Yes, my question is, I'll give you my address and you can send your goodies directly to my house.
Absolutely. I know you want raisin pie.
And Representative Morales.
Thank you, Madam Chair. Hello, Senator. It's good to see you.
Hello.
And I don't know if I should ask folks coming after you this question, but just wondering, what are the onerous provisions in MUBEC that the owners of the company, don't like? And how are the buildings treated under the code currently, and what they would like?
This bill is from the governor, and her people can answer all of your questions.
Gotcha. Thank you.
Thank you.
Great. So I'll come back to you, Representative Morales, when we have another testifier. Representative Reckitt.
Excuse me. I'm sort of curious. Excuse me. Because I've had more mail on this issue than any other topic in the legislature this session.
Oh, wow.
Excuse me. And I don't know why I'm coughing all of a sudden. And I keep saying to myself, why am I getting all this mail from, it appeared to be from Bucksport, as opposed to, no, it appeared to be from Belfast instead of
Belfast.
Bucksport. Yeah.
Exactly.
And so I'm glad to talk to you because I had no clue. The only thing I was clear about is that for some reason they thought it was an that the bill was put forward as an piece of emergency legislation, and they thought this was not an emergency. And I'm like, wait, somebody tell them what an emergency bill means. It just means it's going to pass quick. It's really not. Doesn't mean that the situation is an emergency necessarily, only that they want to do it right away.
Right.
But I decided not to.
Whole Oceans in Bucksport is so different than the one going in that wants to go into Belfast. So it's totally different. And the Belfast people are very against it. The Bucksport people are very for this.
Okay, so I don't have to connect the two, or no, I can just ignore that. All right, since there was not one single whiff from my own district. The other question I have, I think will get answered when Representative Morales gets her questions answered.
Yeah.
Although I miss you too on this committee, so.
I miss you too.
Anyway, it's good to see your face. Since we don't get to see it any other way, I used to see you at least in passing in the hallway. So that was about it. And I think, the other question I had is, I was on a tour last year in Aroostook County, and there were people raising trout inside a facility, inside a building. I don't even want to tell you where in case they were in violation, and I, just really think that's terrible. But
I'm from Aroostook County, so I'd like to know.
Well, it was the native population at Aroostook Mixmax. And Well, I'm wondering whether or not they're covered by what MUBEC code doing that, or none at all, or.
Yeah, for
you know,
4 years, we have gone through all the hoops and everything they've had to go through. And this is just the last little thing that's holding it up. And the governor came to me to ask me to present this.
Okay. So you don't know what's happening in Belfast? Is it a similar thing, or it's just? they
In
just-
Belfast, it's a whole different group. It's a whole different
kind of
different
facility?
thing,
Okay.
whole
All right,
different company.
Thank you much.
Next up, I have Senator DeChambeau.
Yes. Well, I sit closest to her in the Senate, so I would be remiss without saying it's so good to see your face
Thank you,
and to
Susan.
have you on this committee again. I think we all miss you. So I will end with just one very good comment for you. I thought your testimony was spot on. I liked the statistics and the information. I have read this bill at least a couple of times and wasn't sure what it meant, but you cleared that all up in your testimony. So again, I thank you for that.
Thank you, Susan.
Great. All right. I think that's what we have for you, Senator Rosen. Thank you so much for bringing this bill to us.
Thank you. I've been Zooming since 8 o'clock this morning, so I feel your pain and thank you for having me. I miss
Thank
you all.
Have a nice evening.
You
Snuggle
too.
that little dog for us.
I will. Representative Pickett, good to see you all.
Bye.
Bye. Bye, Scott.
Legislators or co-sponsors here to testify?
Senator Rosen, where's George?
George is over here and my husband just got home and he just made me a drink.
Perfect. You're
Cheers.
living your best life.
I am.
Thank you.
Thank
Thank
you. Okay, so now I'm going to open it up testimony in support of the bill, please. If you're here to testify in support, please raise your hand and we'll bring you over.
Did you hear me? I momentarily dropped off. Is it my turn?
You hold on one second. I'm going to go to Kate Foy first, and then I'm going to come right to you, Michael, okay?
Sorry, the computer glitched.
Oh, you're perfect. You just hang on one second.
That scary cyber thing that happens when you transition from attendee to panelist. Thank you so much for having me. Hello to all of you. This is my first time testifying in front of this committee, so I'm happy to be here. Senator DeChambeau, Representative Warren, and members of the Committee on Criminal Justice and Public Safety. My name is Kate Foy, and I am the Legislative Liaison for the Department of Economic and Community Development. I am here today to testify in favor of LD 1473. As you may know and now have heard, Whole Oceans is retrofitting the former Verso paper mill in Bucksport to establish a land-based aquaculture facility. As part of this process, Whole Oceans is installing several large water tanks inside of a metal building on site, but the building code as currently written would require the installation of an elaborate and expensive sprinkler system that is not necessary given the nature and use of the building. Whole Oceans approached the Department of Economic and Community Development to see if there might be a solution to this costly installation. We reached out to and worked closely with the State Fire Marshal's Office to present a governor's bill that provides an exemption under MUBEC statute so that the project may continue. This bill does not exempt all buildings at an aquaculture company. It would exempt from MUBEC only those buildings that are used for aquaculture of marine or freshwater organisms, such as buildings where they will store water tanks. Office locations, for example, would still be built to MUBEC standards. Furthermore, those buildings that are exempt, NFPA 101 Life Safety Code would still apply and would be reviewed. The buildings and facility operations are also still subject to a host of other regulations through the Department of Marine Resources and the Department of Environmental Protection. Maine has a set of high regulatory standards, and for a good reason. Our natural resources are one of our state's greatest resources, and safeguarding them for future generations is critical. This exemption in no way compromises these high standards, but places the aquaculture industry in alignment with agricultural buildings that are used in similar ways. Land-based aquaculture is rapidly increasing in the US as demand for seafood also continues to increase. There has been significant investment worldwide in this eco-friendly and sustainable technology. Maine can now benefit from the latest advancements as we grow and diversify one of our heritage industries. We can take a leadership role in this emerging industry on a global scale, becoming one important part of the sustainable food solution and protecting the long-term sustainability of our wild-caught fisheries. Land-based aquaculture has the potential to bring jobs to our area of our state and will also infuse significant investment dollars and tax revenue into the state, reaching far beyond the locations where these facilities are based. This in turn will spur further economic development that will have far-reaching long-term positive impact on all Maine people and the communities in which we live. DECD, along with the Department of Public Safety, would like to offer one small amendment to the bill as printed, and it's in my testimony, and I've sent it to the clerk. And so thank you. I'd be happy to take any questions. I see my time is up. And Senator Rosen, I'm coming to your house. This is definitely the way to do committee.
Great, thank you, Kate. We're going to start with Senator Searway.
Thank you, Madam Chair. Good afternoon, Ms. Boy. Just wanted to ask about, I guess, two things. One is, why is this in this committee? It seems like it should be in either marine or agriculture. And then,
oh, sorry, can I answer your first question? So it's in this committee because you have jurisdiction over MUBEC. So you're the committee of jurisdiction over MUBEC, which is where we need to make the change in the code.
Okay. And then, so when you make a change of the code, I guess we're going to need somebody that knows, familiar with codes, but when you change it, when you say that marine resources has a certain code, and then you want to change it to what agriculture is, it seems like marine resources would still have buildings and facilities very similar.
Sure.
So I don't know why we have to change the code.
So the code that we're looking to change lives, it's in MUBEC, which is what covers this particular sprinkler system installation. It's part of the fire safety code. So we're not changing any definitions of what land-based aquaculture is. We may talk about doing that at some point, but we're not talking about changing any definitions within the Department of Agriculture or within the Department of Marine Resources of what land-based aquaculture is. Knowing that Whole Oceans had an important project and this was going to potentially hold up moving this project forward, and our commitment to Whole Oceans and what they're bringing to the Bucksport area, including land-based aquaculture as part of an exemption in MUBEC, was sort of the easiest way to move forward, and also brings into alignment with sort of the growth of animals that take place in agriculture, right? So they're growing a food product. It's also a building 75% filled with water that we're asking to put a sprinkler system in. And again, when MUBEC was created, land-based aquaculture, as Senator Rosen said, wasn't even part of a thought process. Nobody, probably when these codes were created, nobody thought we would ever grow fish on land. I certainly, it's a new concept.
Now, and just the other part of this, and it was mentioned, I think, about Bucksport loves it, and and Belfast doesn't. How does this affect that whole setup? Because if we approve for state, it could approve it for Belfast too, and I don't know how that works.
Sure, and I think this would be something that could be approved for any land-based aquaculture company. They still need to meet all other environmental requirements. So again, this is just not requiring a sprinkler system to be put into a building that's 75% filled with water. It's my understanding that that's not the, I don't want to speak for other people. I guess what I would say is, it's not, this bill doesn't impact the high standards that we have for these projects environmentally. It just brings it into line with other, I guess, again, just with growing food. It brings it into line with that.
Thank you.
Yeah.
Next, we have Representative Reckitt.
I never thought that my marine biology background would be useful on the Criminal Justice Committee, but here goes. I do have a master's degree in marine biology. Anyway, my question is, I have two questions really. One is I'm reading some information that leads me to believe that this project is, and I've seen the mill in Bucksport, so I assume it's a pretty large scale project. And what you are just saying is that the only subsection of it that would be not holding to the original or the current MUBEC codes is this one building that will have the fish in it, right?
Correct.
So that's good. My other part of this is I noticed that there's a regulation that facilities like this be able to recycle their own waste as opposed to dumping it in the ocean, which because dumping as much nitrogen as this will be in the ocean would be catastrophic in the bay, in my view. So my question is, how are they going to deal with the recycling of waste in this facility? Do you know? Or
I can't speak to how they, and somebody here, Michael Thompson is here, and he might be able to answer that question. This particular code change would not impact any of the environmental regulation. This code change does not impact those types of permits and the process that these companies need to go through.
Thank you.
Absolutely.
Any other questions for Kate Foy? Seeing none, seeing one. Representative Pluker.
Oh, so close, guys, so close.
You're heading to Senator Rosen's house, right?
Yeah, I know.
So is the only aspect of MUBEC that they're looking to exempt themselves from the sprinkler part of it?
It is the sprinkler. There is one other piece around insulation that they and I'm not super familiar and would be happy to pass on some additional information for the work session or going up to the work session. There's some insulation pieces also that have to do with fire safety code, is my understanding. However, in a building that they're looking to grow fish, and again, Michael may be able to better address this, that needs to be climate controlled in Maine in the winter. They're not going to cut back on any insulation. But again, the intent of this is again around the sprinkler system. And we did work closely with Rich McCarthy on the best way to work with this statute to help modernize our codes for this emerging industry.
A follow-up, Madam Chair?
Yes, please.
So if this bill were to target aquaculture facilities don't need to install sprinklers, does that meet your needs or does that not meet your needs?
It does meet our needs. It
Okay.
does. And it aligns with, yeah, thank you. And again, it modernizes it to align with other food production for human consumption with livestock.
Thank you very much.
You're welcome. Thank you.
Any other questions for Kate Foy? Seeing none, thank you very much for
Thank
being
you.
here.
Thanks so much for taking this up. And I know it's late and we appreciate your patience on this.
Absolutely. And now next up we have Michael Thompson. Welcome.
Thank you very much. I know you have a long day. So Senator Deschambault, Representative Warren, distinguished members of the committee. My name is Michael Thompson. I'm a resident of Camden, Maine, and the project manager for Whole Ocean's Atlantic Salmon Aquaculture Facility in Bucksport. Our goal is to humanely raise salmon from eggs to maturity in land-based tanks at the site of the former Verso paper mill. And I'm here to testify in support of LD 1473. The United States currently imports over 90% of the salmon that we see in our grocery stores and restaurants, and land-based production in Maine will provide a locally grown alternative to these offshore imports. Replacing some of these imports with fish raised in Maine will reduce greenhouse gas emissions associated with long-distance shipping and improves food security. Our project has already provided jobs as we prepare for construction, and we look forward to providing more jobs for Maine's economy as we build and operate the project in the near future. Our facility, as you heard, has received approvals from the Maine Department of Environmental Protection in the town of Bucksport. The state of Maine has also issued a land-based aquaculture facility license for the project. These and other regulatory approvals indicate that the project will meet Maine's strict environmental standards, and we're pleased to do so. But in designing our facility, our architects and engineers have struggled with how to apply MUBEC codes intended for schools, hospitals, office buildings to a simple steel frame building covering fish tanks. Maine law provides that buildings that house livestock and harvested crops are exempt from MUBEC for good reason. While we in our industry as a whole have always considered farm-raised salmon to be livestock and a harvested crop, it's not clear in Maine law that land-based aquaculture facilities are exempt from MUBEC. LD 1473 would clarify this matter and ensure that our facilities receive the same treatment under MUBEC as buildings that house other kinds of livestock and harvested crops. If LD 1473 were to pass, land-based aquaculture facilities would still come under a host of codes, potentially including Maine's adoption of the National Electrical Code, Life Safety Code, and Fire Code. Our tanks and buildings over them would also be designed by Maine professional engineers and architects following published design criteria. We'd work with the town of Bucksport and the fire marshal as necessary to identify those specific codes and design standards that apply to our facility, just as would happen for any other building that houses livestock and is exempt from MUBEC. As the aquaculture industry looks for where to place facilities around the world within the United States, Maine stands to build on its strong reputation for sustainably grown food. But if Maine is to attract these facilities, it should consider laws and regulations that are consistent with other states. To the best of our knowledge, other land-based aquaculture facilities in the U.S. are exempt from the Uniform Building and Energy Code, and Whole Oceans would welcome similar consideration by the state of Maine. So thank you again for your time. We appreciate it, and I'm happy to answer any questions.
Thank you for your testimony. I'm going to start with Representative Morales and then Representative Pluker.
Thank you, Madam Chair. Thank you, Mr. Thompson.
Yeah.
Are you located in other states with this type of operation?
We have a facility right now in British Columbia called Katera that's up and operating, and we're looking at other sites in other parts of the country.
This works pretty well.
So this would be your first in the U.S.?
The first operating in the U.S., correct.
Okay. And as far as the exemption that you're seeking, is that, I mean, it seems to me, has there been a cost estimate of how much it would cost to put the sprinkling system in? I think that's the major issue with cost.
Crops are exempt.
Yeah, it's there's more to it than a sprinkler system. It's the people that invest in these projects invest all across the country and around the world. And so when you look to Maine regulation, it clearly has this exemption in MUBEC for agriculture and livestock. And so the question I have is why aren't we considering aquaculture as a similar use? Why aren't we exempt? So that's number one, and that's causing a lot of pause. But MUBEC is really in large part intended again for hospitals, buildings, schools, buildings where there are people in them. And this, the way these systems work, it's a series of tanks covered by a steel building, and we open the doors at a regular basis. The air comes in. It's like a barn. So the things that cause pause, one is the sprinkler system that you heard about, and that can be $9 million or more. But the other part that really gets us is the air handling systems, or they can be $24 million to make it meet the code as if it were an office building or a school. And if we were to treat this like a barn, we're familiar with barns. If it's hot, you open the doors. If we're bringing feed in, we throw the doors open. We're shipping fish out, we throw the doors open. Fresh air comes in, goes out. But really, these buildings are designed to keep the fish alive and thriving. The people aren't in them all the time. They come in and check on fish periodically, but they're going to be off mostly in an office building nearby that would come under MUBEC. So again, it's why is Maine not considering this an agricultural use, because they're clearly exempt from MUBEC. And then there's the specifics, the air handling, the sprinkler system, and then some of the specifics of the code that really relate to buildings that are mostly airtight. You're not opening and closing doors and windows all the time, and that have people in them all day long.
Okay, thank you. That's a little clearer. So it's about the ventilation system as well. Is it a ventilation system, or are you talking about emissions?
No, it's the ventilation, the air handling of the system. Within MUBEC, you have to meet certain air criteria. And again, those are really designed for energy efficiency in buildings that house people, that you're not throwing open doors and things like that to move feed and fish and things like that around.
Thank you.
Representative Pluker.
Thank you, Madam Chair. I think Representative Morales might have gotten to this. So my initial question was, is it just the sprinklers? But you're saying it's sprinklers and air handling requirements.
Oh, it's a whole host. MUBEC in itself is 800 pages long, and all the other codes that go with it are thousands. Those are the major ones. There are a lot of little ones that all add up to things that, again, appropriate if it's a school or an office or a hospital you're making. But when you get into these agricultural settings where you're just housing livestock, which salmon are, they just don't fit. They're square pegs in a round hole, and that's where we're sort of stuck as we design these things to try to make it fit in the type of building that we have for the fish. Again, happy to do it for our office buildings, things like that. That makes sense. But when you're talking about the buildings that are really just housing the animals, it's a challenge.
So to be clear, a specific exemption for sprinklers does not, or air handling equipment does not work for your
company. Because then you would have to go down the list of all 800 plus pages, and we carve out all the other ones to say, here are the questions. And the fire marshals, the code enforcement officers are all very helpful, saying, look, we'll help you understand the code. But there are so many portions of it that, again, if I was designing the office building for the facility, no problem at all. But when it comes to the livestock buildings, then you're just going down a whole long checklist. So really the proposed legislation just makes it very clear land-based aquaculture is exempt because it is an agricultural use with livestock in it. If you start getting into amending specific things like sprinkler systems and air handling systems and ventilation and thickness of insulation, you're going to have probably hundreds of pages of legislation.
Thank you. I just want to highlight in the current code, it does, or in the current statute, it doesn't mention anything about agriculture. It does say that buildings used to house livestock are not subject to the Maine Uniform Building and Energy Code. And you're essentially, or your lawyers are questioning whether or not your crop is livestock.
Well, we think it is. It's always considered livestock. And there are other places in Maine's law where livestock is defined to include organisms grown in an aquacultural setting. So there's that inconsistency right there, that in one place in Maine law, livestock clearly includes fish grown in an aquacultural setting. It's also defined as a harvested crop. Now you flip over to MUBEC and it's not included. So
who is telling you that this law does not exempt you?
Well, it started with the code enforcement officers saying that they because it doesn't specifically define livestock in the MUBEC code, then they felt that, well, it must apply.
And that's the code enforcement officer in Bucksport.
In Bucksport, and then going, the fire marshal, again, I think it gives them pause too. The other thing I'll point out in MUBEC, not to get all technical, but there's an appendix called Group U buildings. Group U buildings are for agriculture, but Group U does not apply unless the state specifically adopts Group U when it enables MUBEC. MUBEC's a national code. Maine didn't do that. Maine exempted livestock buildings and buildings that have harvested crops. So it just set aside Group U buildings. So we don't even know if Group U buildings can apply because they weren't adopted by Maine when MUBEC was adopted.
Thank you very
Again,
much.
this clarifies that if you include it in there, then we're done, we're happy, we go back and finish our design. And again, we work with all the regulatory authorities to say, well, these are the exact codes that we're going to be building to. And there are dozens and dozens of those. It's just trying to get clarity on MUBEC because we're clearly livestock, we're clearly a harvested crop. Elsewhere in Maine law, land or aquaculture, organisms grown in aquacultural settings meet those definitions. It just was something, as was said earlier, when these codes were adopted, no one even knew what land-based aquaculture was. So it's just this internal glitch between two sets of regulations in the state of Maine that we're seeking to clarify.
Thank you.
Mr. Thompson, I'm wondering if you're going to be able to be at the work session, which will be next week, and we'll announce it. Is your plan to come to the work session when we announce?
Oh, absolutely. Yeah. Whatever helps. I know this is highly technical, and so I'm happy to, I don't want to become overly technical, but I'm happy to get into details in a workshop.
Thank you so much. I'm going to encourage the two members with their hands up. If you have a burning question that you need right now tonight, let's go for it. But if there's something that you can get answered in the work session, we still have folks that are here to testify. I'm going to ask that you do that. Representative Reckitt.
Well, they're burning questions for me, but I guess what I'd like you to do is bring an answer to these questions to the work session, perhaps, or let us know beforehand. The two things that are burning questions for me are the one I raised a while back in terms of the plans to recycle the waste from these facilities rather than dumping stuff in the bay, wherever the bay is in relation to these to the facility. The other is the whether or not there's been a consideration made on the impact of the whole facility on Maine's carbon footprint. Because I'm worried about, we're having huge endeavors to keep that, eliminate carbon, and I would be guessing that this is going to be an impact on that. So if you could bring an answer to those questions or some source.
Is it okay to briefly answer those?
I would love it if you could bring that information to the work session. Would that be acceptable to you, Mr. Thompson?
Well, the only thing I want to clarify is the waste stream comes under Maine's waste discharge law. We have a license for that. And I will at the workshop explain how we do that, but we are under strict requirements for what we can discharge. That's handled by a whole nother set of regulations that don't come under MUBEC.
Okay. Yeah, I would tell you that this committee's pretty used to MUBEC. We spent a lot of time on it in the last couple of years when we were trying to get specific, the new codes in. So anyway, thank you very much.
Thank you, Representative Reckitt. I appreciate that. Senator Searway, could you also ask for information that you'd like to have at the work session?
Yes, I just wanted information where Mr. Thompson had mentioned about ventilation, and that kind of extended it from the sprinkler system. So I'm kind of, I was thinking if I was a neighbor of the residents and whatever, what they do for a filtration system and stuff for smells and odors and whatever. So I guess it's a little more complex because of that.
Well, and keep in mind, that's covered by Maine Site Location and Development Law, which we do have that permit. Odor, noise, all those things are covered by the site law. They're not covered by MUBEC.
And my comment is if we could get the code enforcement officer maybe for the work session so we could ask a few questions.
Yeah, I'm sure we'll get Rich McCarthy, who oversees MUBEC, which is what our decisions will be about. Thank
Right.
you. Great.
Thank
Thank
you.
you, Senator. I appreciate that. All right. Thank you, Mr. Thompson.
Oh,
And
thank you. I appreciate it.
you'll get the information. We're meeting tomorrow to decide on next week's work session schedule, so you'll get that in your email. I
Okay.
am going to now open testimony to anyone here to testify in opposition to LD 1473.
Hands are starting to go up. I'll bring in at least 2 people.
Thank you, Deb. We'll start with James Merkel. Welcome.
Welcome. I've been with you since 11:05 this morning, so nice to be with you all. My name is Jim Merkel. I'm here on behalf of the Sierra Club, who has over 20,000 members in Maine and 3.8 million members nationwide. And I'm here today to oppose the LD 1473. And some of the main reasons are that these facilities, I've been digging into them very, very deeply for the last 2.5 years, living in Belfast. And I've been to the plant in Bucksport. They're highly complex industrial operations, not in any way similar to a potato barn or a cow shed. They store long lists of chemicals and fuels on site, draw heavily on clean fresh water and seawater, and return wastewater into rivers, bays, and release daily air pollution from generators, and have noisy and potentially smelly ventilation systems. Some have gone bankrupt. Some, like Nordic Aquafarms in Denmark, the Fredrikstad Seafood, have been found deficient in their measurements of programs for emissions and have a lot of complaints by the residents. Just to provide an example, the proposed Nordic facility in Belfast would have complex buildings and technical infrastructure covering 14 football fields with large storage tanks for fuels, chemicals, many of them flammable, such as glycerin, some of them very toxic, caustic, fish pumps, filters, processing operations, sludge ponds, fish gutting operations, and offices. The scale is immense. 33,000 metric tons per year, 7.7 million gallons a day of wastewater plume, 11 times more nitrogen dumped into the sensitive bays, say, for example, with Nordic, than the Belfast city sewer. They have 8 2-megawatt diesel generators burning 900,000 gallons of fuel annually. So I'm an engineer and I worked in large manufacturing facilities. And I was on the first aid team when I had to bring a young graduate to the hospital who disconnected a pump that had been pressurized, and he got blasted in the face with caustic and he lost his eyesight that night. And caustic is one of the things that is stored there and used in the tanks. There's pages of cleaners. And so these facilities need careful safety protocols, designs, emergency procedures, maintenance schedules, careful adherence to laws to keep the workers safe and prevent industrial accidents. There may be operator errors, construction flaws, routine breakdowns, power outages, and any of these could result in injuries or accidental release of sewage, non-wild fish, diseased water, chemicals, medications, fuels, and more. Safety rules should be more stringent for these types of facilities, especially near residential areas and sensitive marine ecosystems. All the 5 proposals in Maine discharge into shallow waters, and they should be made to be fully recyclable systems without any discharge into this nearby. Their carbon footprint of even Belfast alone is 5% of Maine's total greenhouse target, the entire state's total target by 2030. One facility that's how big the carbon footprint is. So these large scale aquaculture projects have been very challenging to investigate. As they're a new industry to Maine, they're being sold as sustainable and they're not. Not a single one of the 5 meet Sierra Club's national policy for aquaculture systems. They
Thank
could
you,
be
Mr.
named, but they're
Merkel.
not.
Mr.
I'll
Merkel,
stop
I'm
there.
going to ask that you summarize the end of your testimony and then
No, that's it there.
Okay, well, good
So
job.
thanks.
Thank you.
Yeah, and I'd love to come to the work session if you know, if you have more questions for me, but if you have some now too. I've been here since 11, so I'm happy to stay.
Wonderful. Thank you. Let's see if we have any questions for you, Mr. Merkel. Any questions from the committee? Okay, we don't have any, but I did see that you submitted written testimony. Thank you for that, and we will see you at the work session.
Great, thanks.
Thank you. And next up, we have Kathleen Rybars. Thank you for being here.
Yeah, hello and welcome. Thanks for Senator Shambo and Representative Warren and members of the Criminal Justice and Public Safety Committee. Thank you for the opportunity to speak on LD 1473. I live in Lemoyne, Maine. In my work in pharmacy, I handle toxic chemicals every day. I had a lot of specialized equipment and safety training to ensure a safe workplace. A worker's right to a safe workplace means a lot to me, and this is the primary reason that I testify against LD 1473 today. Reclassifying a land-based aquaculture facility as a storage facility for animals is wrong. This water-flowing aquaculture facility is more like a public aquarium than a simple shelter that would house potatoes. Public aquariums have fire suppression systems, they have air handling systems, and they also raise fish. Fish farms require complicated monitoring, specialized equipment. There will be plenty of mechanical systems that have a possibility of malfunction, of electrical shorts, all kinds of things that cause fire. A finfish pen in the sea off Tasmania recently caught fire in the middle of the ocean in December of 2020, and I give you a source to that article. This bill will not just affect Bucksport, but will affect 4 other projects that are currently in being processed, and there'll be more in the future. So this is not just a simple fix for one facility. It'll affect Bucksport, Belfast, Millinocket, and Jonesport this year, and I'm sure there'll be many more fish operations that happen. Right now we have fish hatcheries that can accommodate sprinkling systems and air handling, and it's not a brand new science. We raise baby trout, we raise baby salmon in Maine, and we work with MUBEC. The employees are going to be working in this building 24/7. It's an invaluable crop. They're not going to be just closing the barn doors and letting the cows sleep at night. The employees deserve an air handling system that keeps them safe. They deserve fire suppression systems that give them the 20 minutes they'll need to escape the building should a fire occur. A safe fire extinguishing system can be designed that takes fish health in mind. All safety workplace rules in MUBEC need to be applicable. Allowing this exemption puts workers at risk. Saving one employee's life is worth the cost of using an efficient sprinkler system. Let's invest in Maine citizens by requiring the best fire and air handling systems for this workplace. Thank you for your time and attention.
Thank you. Thank you so much for your testimony. Let me see
Sure.
if there's any questions for you. Any questions from the committee? Yes, Representative Pickett.
Yes, thank you, Madam Chair. Thank you,
Sure.
Mrs. Rybars. Just one question for you. Are you familiar with this company at all, or are you just talking about companies that do that?
No, I've done a lot of research. We have a fish project here in Frenchman's Bay that I've been working with. So I've been investigating, and for about 1.5 years now, studying up on how things work.
This particular company?
Yeah, I've looked at all the companies: Belfast, Bucksport, and Jonesport, the Kingfisher facility too.
Okay. Okay. Thank you.
Thanks.
Any other questions? Seeing none, thank you again very much for your testimony.
Thank you.
Anyone else here to testify in opposition to LD 1473? please raise your hand and we'll bring you in. And I'm seeing none. Anyone here to testify neither for nor against LD 1473? And again, I'm seeing none. So I will close the public hearing on LD 1473. And we'll end our day. So thank you all. Anything needed from Jane before the work session?
I'm sorry, I forgot to ask her when we were doing facial recognition, if she would get us a copy of Title 29A, whatever it is, the one that's quoted in the amendment. I'd like to see that we all have that.
Great. I think it was 29A 401 or section.
Yeah,
4.
I'll get that for you. I can get that for you, but it is, it's attached to the amendment. It's at the very end of the amendment.
Oh, no, really?
Yeah.
God, I've been looking at that. Oh, if it's there, I apologize and I
That's
thank
okay.
you. So, thank you.
Thank you. Senator Searway.
Yeah, and on the same bill, I was just wondering if they could, if Jane could see if this would affect the iris scan that they use for sex
Yep.
offenders.
Thank you. I already have that as a question.
Thank you.
Great. Thank you, Jane. Okay, so we are all back Friday morning at 9 a.m. As you've heard us say a couple times, Susan and myself and Jane and Deb are meeting at 8:30 tomorrow morning just to map out what next week looks like. So you guys will all have a sense of when your work sessions are, etc. And we'll get that out to you pretty soon after tomorrow morning. Great. Susan, anything from you?
Bye-bye.
Susan, did you have anything to add? Or are you all set?
Other than let's just relax before we go to bed, take a shower, relax.
Good idea, Senator. Thank you.
And tomorrow, enjoy your family. That's it. Okay. Thank you.
Thank you. Good
All
night,
right.
everyone.
Nice work, everyone.
Good night.
Night.